Welcome, everybody. Welcome to another episode of the Law of Self-Defense and our Karen Reed murder retrial live stream. We're covering the Karen Reed murder retrial. She's on trial again on charges of murder over the death of her police boyfriend, John O'Keefe, who prosecutors say she hit with her car and left to die in a Boston blizzard. Of course, she says, I didn't do anything wrong. And she convinced at least one juror the last time around that the state had failed to prove guilt beyond a reasonable doubt, got a hung jury, and now she is back for a retrial in the Commonwealth of Massachusetts. I'm covering this with my buddy Nick Rekieta of Rekieta Law. We're co-streaming it, which sounds kind of homo, I know, but he's streaming it to his audience on YouTube and Rumble. Rekieta Law on both of those, and I'm streaming it to the Law of Self-Defense YouTube channel and to our Law of Self-Defense members, and but we're doing it together from the same StreamYard interface, so it's just more fun than doing it by oneself, especially these very long trial days. So please, you could all join us here today and make sure everything's working the way it should be, and it looks like it is. Today's going to be a little bit of a complicated day because the jury is taking a field trip. It's taking a field trip on a bus to the site of the home in front of which John O'Keefe's body was pulled from the snow. Obviously, he did not make it. To get a sense of what that environment looks like. Of course, it looks quite a bit different on April 25th than it did on January 29th in the middle of a blizzard. But nevertheless, that's what the jury will be doing. There will also be, we heard yesterday, some in-court testimony today, at least one expert being presented by the state on blood analysis, presumably for the alcohol level of Karen Reed. Everyone involved in this event, John O'Keefe, Karen Reed, everybody in the house in front of which this occurred, the death occurred. It was a house party. Apparently, everybody was juiced to the gills. Certainly, Karen Reed was. Her blood alcohol level 6 hours after the event that we believe killed John O'Keefe occurred, her blood alcohol level was still 0.09, which is pretty darn high. So if she wasn't drinking during those 6 hours, one can only imagine. Well, I suppose the state's expert will postulate how high her blood alcohol had to be when she was driving her car. Even she concedes she should not have been driving. She's given imprudently, she's given a number of interviews to various news organizations in which she says things that are not helpful to her defense, including things like, I should not have been drinking. I may have had up to 9 drinks, but it's not really that many because some of the drinks were weak. The bar doesn't pour good drinks. But don't worry, she made up for that by getting bonus shots to add to her drinks to make sure they were up to full strength. And of course, then she engaged in driving around. One of the dynamics here is that John O'Keefe was apparently very well liked. He was a Boston police officer, well known and well liked in his community. He was actually raising the children of his dead sister. He himself, being unmarried and a bachelor, took on that responsibility. Certainly a noble thing to do. He had lots of friends. Everybody at the house party in front of which he would die were friends of his. People only seem to have good things to say about him. And the town itself is very cliquey. They all have kids. The kids all play sports. They all know each other. They live in the same neighborhood. They're on the same Facebook neighborhood page. And some of them went to high school together. One of the key witnesses, Carrie Roberts, I believe, went to the junior prom with John O'Keefe. They went to school together as kids, known each other forever, for decades. Karen Reed is very much not part of the clique. She's an outsider. So there's an open question that remains, and that is, Nick is not here yet, or I would have him join. I don't think he's here yet, unless something weird is happening with StreamYard. So one of the questions, for the defense, so the prosecution says Karen Reed was drunk, backed out of the driveway at speed. She was angry with John. They'd been having an argument all day, bickering back and forth. She backed out at speed, hit John with her car, and left him there to die. The defense says no collision ever occurred. Simply no collision ever occurred. And there's some other explanation. Somebody else did something to John, or he suffered his head injury and was left unconscious in the snow in some other manner. And of course, the burden is on the state to prove guilt beyond a reasonable doubt. Now, I will say that those interviews that Karen Reed did with the media, at least the very short clips we have, are very, very damaging to Karen Reed. It wouldn't surprise me if she got convicted on that basis alone. I keep hearing little beeps like Nick is trying to get in, but when I try to add them, I don't get an image. Whoops. Let me text him. Okay. Yeah, those interviews are pretty bad. I have managed to download a number of them. Maybe we'll share them as we have pauses in today's live stream coverage from the court. Karen Reed trial live Friday. Let's see what I come up with for a link this time. Let's see. I guess I should specify day 4. Court TV. And I do have a ceiling fan. I do have a ceiling fan. So while we're waiting for something to happen and for Nick to arrive, I just want to remind all of you, the biggest favor you could do for both Nick and myself is subscribe to our YouTube channels. And in Nick's case, YouTube and Rumble. Again, that's Rakaida Law on YouTube and Rumble. If you're watching over there, that's great. You should keep doing that. But you might pop over, open up another window, YouTube window, and go to Law of Self-Defense. And just hit that subscribe button. Hit that subscribe button like it's like you're Karen Reed driving a Lexus SUV in a blizzard at your cop boyfriend, John O'Keefe. Also, hit that like, thumbs up button. It would be great to hit 198 subscribers here today. And, oh, we got court.
Please be seated. Court is in session.
Good morning.
Good morning.
For the record, before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial.
Thank you. So good morning. I heard the council wanted to see me about something.
Yes, please.
All right, why don't you come on over to sidebar?
Okay. We got audio and then we got no audio. Pretty quick. Pretty quick. So we got all the way through witness. Yesterday, we got through witness number 8 with a couple of the witnesses testifying and then leaving and then coming back. But it's still 8 distinct witnesses. Yes, that makes sense. The judge is Beverly Canoni. So far, the defense lawyers we've heard the most from are Alan Jackson, who's done an excellent job. He did a lot of excellent cross-examination. We're still in the state case in chief, so we're hearing from state witnesses. And he did the opening statement, very, very good opening statement by defense attorney Alan Jackson. And we've had some cross-examination by David Yannetti, who's the local counsel. A number of the lawyers on the defense team are operating pro hac vici, meaning they're not licensed to practice in Massachusetts. They're licensed to practice in some other jurisdiction, but it's common for courts to approve out-of-jurisdiction lawyers to work within the jurisdiction if there's a local counsel who's kind of the anchor there. That's the role being played by David Yannetti, and a more substantive role as well. The prosecutor we've heard from, the only one so far, is Prosecutor Hank Brennan, very monotone kind of guy, low key, low energy, I would say. Seems professionally competent. The other prosecutor is Adam Lally. He was also involved in the first trial. Have not heard yet from him. At least I have not yet heard from him. So again, today is the field trip. Yesterday, we went through a whole bunch of text messages between John O'Keefe and Karen Reed. On January 28th, he would die, of course, the night of January 29th. So this was text messages leading up to them getting together at local bars, McCarthy's and Waterfall, and then going to the house party. And it's a day of bickering. Bickering. My sense of it is that Karen Reed is looking for more relationship.
All rise.
Okay, we're back. All rise. Heading back to the ceiling fan. My sense as a man of experience in relationships, being of a certain age, that Karen Reed is looking for more out of this relationship than John O'Keefe was interested in giving her. He sounds like he's a bachelor, never been married, is raising 2 children only because his wife died. His sister died of cancer, and then her husband died of a heart attack a couple of months later. So these kids were left with nobody. And he took it upon himself to raise them. But this is not a life that he'd ever planned. I'm sure he planned being a bachelor. Now the children are 17 years old, the daughter, and 14 years old. The daughter's going off to college. The son will be going off soon enough. And John O'Keefe may feel like he's finally getting his bachelor life back. Meanwhile, he's dating Karen Reed. Karen Reed is in her early 40s when all this is going on. She's 45 currently. And she's never been married. So she's spent the last, no offense, she spent the last 30 years or so getting run through by a variety of guys who never committed to her, has never had children. She's getting to be of a certain age. She's a pretty good looking woman, but looks don't last forever. And 40 is kind of the tipping point. By the time any women are 50, if they're not in an established relationship, they're effectively invisible on the dating market. That may have been the eminent future Karen Reed was looking at. She found a good guy in John O'Keefe. I've heard nothing to the contrary, and certainly him raising his dead sister's children would support that view of John O'Keefe. She found a good guy in John O'Keefe and wanted to nail him down, have a more permanent, committed relationship. And she seems to be engaged in these text messages we heard about yesterday, in basically passive-aggressively goading him into making more of a relationship commitment than he seems willing to do on his own initiative. There's a lot of, now they've been dating 2 years at this point. There's a lot of, I get a feeling you're not really into me anymore, which really means tell me that you're into me more. Tell me that you love me. Tell me that you can't live without me. Let's do the notebook speech in the rain together. And John's just like, so Karen apparently picked a fight with him that morning, the 28th. That's often a way for borderline personality disorder, Amber Heard types. They love the drama. They're desperate always for attention. If they can't get attention in a good way, if things are kind of quiet, they'll start a fight to get attention. Any attention is good attention, even if it's fight attention for these people. We saw that with Amber Heard in the Johnny Depp trial, right? She kept saying, why won't you fight me? Why won't you fight for me? She's punching him. She's cutting off his finger with thrown vodka bottles. In her head, that's all just part of a relationship. That's part of 2 people engaging with each other. I'm not sure what's going on with Nick. It looks like he's streaming to YouTube. Anyway, but I don't think he is. Let me take a look. He's kind of in my dashboard and kind of not in my dashboard. Oh, right now I'm streaming to Nick. All right. I'm streaming on Nick's YouTube channel. That's fine, of course. There we go. All right. So she seems to be desperate for attention and more commitment from him, and he seems much more, hey, I'm just looking for a girlfriend. Stuff to do on the weekends, go out, have a few drinks, have a few laughs, have a little bit of sex, and she's looking to lock him down. She doesn't want to start another 2 to 3 year dating cycle at her age. I mean, there's a limited number of times you can do that. She's been doing that apparently for 30 years. 30 years she's never been married. She's 40 plus years of age. She's never been married. The 30 years is when I presume she started engaging in the sexual marketplace. never been able to keep a man. And now it's getting to be a time when keeping a man becomes imperative. I don't know if you all know, but statistically, by the end of this decade, which is only 5 years from now, fully half of women 40 years of age or older will be partnerless and childless. Half. Meaning at that point in life, they're almost certainly never going to have a husband, never going to have children for biological reasons, the biological clock reasons. And they're looking at spending, statistically, they're going to live to be 80 plus years of age. So they're looking at spending the last 4 decades, 40 years of their life in desperate loneliness and probably crushing poverty. That's not a good look. I would be terrified if that were me. And I think people like Karen Reed, and maybe Karen Reed in particular, are terrified. That doesn't mean she killed him, but that's the dynamic I get from that text exchange of the day of January 28th, the last day John O'Keefe would be alive on this earth, between the two of them. It just comes across as kind of needy and desperate on her part. But those video clips of her for the media, first of all, it's insane to me. Some of these video clips she did after her mistrial. So she already knows the prosecutor's trying to put her in prison for the rest of her life. She just went through a murder trial. It's a mistrial. She knows she's going to be tried again. And she's giving interviews. And I don't see any of her lawyers anywhere near her in these interviews. And I can't believe they would allow this. She must have done it without their knowledge. Again, maybe just more of an effort to get attention. But these interviews they just make her look bad. They make her look bad. They make her look like she likes to drink a lot, like she's irresponsible, like she's, what do they say? Accountability is women's kryptonite. Everything is somebody else's fault. It can't ever be her fault. All that kind of jazz. In fact, I think I may have, let's see. I think I have the meme. This is, let's see, desktop. Yeah, here it is. Have you all seen this meme before? Accountability is women's kryptonite. Yeah. A little bit of truth to that. All right. So we're waiting to see what's going to happen in the courtroom. We're still looking at the ceiling fan here. So not much going on except for the fan. It says live court will begin shortly. I'll believe it when I see it. Somebody asked, am I married? Yes, I'm married. I'm very happily married. I'm ecstatically married, passionately married to my wife, Emily. Let's see. So these super chats so far. Oh, here's one super chat for me already. That's very nice. King Ginger, $5, says the interviews were done before the first trial with the intent of being released after the verdict, but we didn't get a verdict. Oh, that's fair. Maybe they were filmed before the verdict and just released after. I only have the date of release. So that's possible. By the way, this is a second trial, a retrial. I did not watch the first trial. I did not cover this case at all the first time around. But of course, I am covering it this time around. But that means I'm approaching this retrial as a blank sheet of paper. So I haven't really researched or investigated any details in the background. I know there's lots of rumors and innuendo and hypotheticals and things that people believe to be true that may or may not. With any of these high-profile cases, people just begin to fabricate beliefs and supposed evidence and then believe all that stuff is true. And in my experience, a lot of it is not true. So I'm deliberately approaching this retrial without having researched the prior trial, judging everything I see based only on the evidence and testimony presented in this particular case. We are watching the state's case in chief so far. And so the state witnesses are I would say have not come across very well, in my view. They seem very argumentative and combative with the defense, which is not what a credible witness should look like. A credible witness should simply be receiving questions from both sides and answering the questions, not trying to provide long, complicated contextual answers, pretending they don't understand what the question is, which is what the state's attorneys have been doing here, which only reinforces the impression that they're all kind of cooperatively working to make things difficult for the defense. That's not what you want. That's not what you want. I'm not seeing court back. Whoops. Nope, I'm not seeing court back. I'm going to pull this over. I'm leaving. You'll see such a woman move. Oh, yeah. Tim Robinson says, I'm leaving. You'll see such a woman move to want attention, even as they claim they don't care and leave. Right. Yeah, that's what I got. All right, now we're back. Sorry, folks. I'm all right. We were back for a moment and now we're not back. I'm trying to get this window working correctly. Let's see. We are live. There's nobody in the gallery. Nobody in the gallery. So pretty clear they're not looking for anything substantive to be happening right now. Whoops. I hate when I do that. Here we go. I think that guy on the right might be Paul, John O'Keefe's brother. I'm not sure, but the camera goes to him a lot. The older woman there in the middle is Peggy O'Keefe. That's John's father. She testified yesterday, I believe, very teary-eyed testimony. The defense had no questions for her, just said they were condolences for her loss. She testified very negative about Karen Reed. One of the interesting things that has happened is Karen Reed, in one of her interviews, said that when she visited Peggy O'Keefe's, the mother's home afterwards, to pick up her own car, to pick up Karen Reed's car, that the mother leaned over the kitchen island and yelled at her and said, did you see the injuries on my son? It looked like someone hit him with a car. But it turns out there is no kitchen island in Peggy O'Keefe's home. And she says she never said those words. And now the prosecutor wants to introduce that video as evidence of consciousness of guilt, that in effect, Karen Reed fabricated that evidence in an effort to make herself look good. Just like if she fabricated a piece of physical evidence, evidence tampering, which is consciousness of guilt evidence. And frankly, I thought the defense did a very poor job of combating that. Consciousness of guilt evidence is extremely damaging. It literally is what it says, consciousness of guilt. It suggests the jury's told they're allowed to infer from this evidence that not only does the prosecution think the defendant is guilty, but the defendant thinks the defendant is guilty. And that is not great. That is very damaging. But the defense seemed like, oh, we'll just deal with it as it comes up, Your Honor. It's okay. We have no objection to admitting this as evidence. I don't have an objection to admitting it as evidence. I think it would be hard to exclude it as evidence. That video clip where Karen Reed says this thing about the mother leaning over the kitchen island and yelling at her. But as evidence of consciousness of guilt, that I would have fought against hard. Because generally, if there's an innocent explanation for the behavior, you won't get a consciousness of guilt jury instruction. So, for example, a very common traditional form of consciousness of guilt is flight from the scene. Criminals flee, right? The guilty flee to avoid identification and accountability. But there's other reasons people might flee a scene. They might flee because the house is on fire, or it was a violent interaction and they're scared to remain in that place. The fight might continue. There's lots of reasons. They may run because they're of a certain demographic that they believe is treated poorly by the police, and so they just don't want an interaction with police. They don't want to be identified as a witness and get involved in a legal process. Lots of reasons people might flee the scene other than consciousness of guilt. So courts are really generally very hesitant to allow consciousness of guilt evidence, to allow it as consciousness of guilt evidence. If there's any explanation consistent with innocence, without guilt for the behavior, they generally won't allow it to be argued. So, for example, say you're involved in a self-defense situation, you shoot somebody, but it's dark, it's late at night, it's not your neighborhood, and you're like, oh, that was self-defense for sure, but I'm not going to stay here and get killed by this guy's friends. I'm going to leave, get to safety, and then once I've achieved a position of safety, I'll call 911 and claim self-defense and do all that stuff. That's not consciousness of guilt. That's just flight from the scene for purposes of safety. That's perfectly lawful. Might a prosecutor try to characterize any kind of flight as consciousness of guilt flight? Sure, they might make that effort, make that argument. They're allowed to do that. And then your defense counsel would have to explain that, well, this wasn't for purposes of avoiding identification and accountability. He called 911. There's an innocent explanation for why he left the scene. Let's see what else. Take a look at, are there more? Oh, there are the lawyers. There's Karen Reed.
Yes, please.
So the lawyers are on the long table in the back, and the prosecutors are the two gentlemen closer to the judge at that smaller table there. 4 lawyers altogether for Karen Reed, one of whom was a jury on the first trial, a jury member on the first trial. She's a civil attorney locally, and now she's joined as an attorney on defense, but she's not sitting at defense counsel. I think she's more as a kind of an advisor or consultant to the core defense team. I don't see her there now in the gallery. But we have 4 lawyers sitting with her. We have, of course, Alan Jackson, who did the opening. He's on closer to us from, well, I'll go in order. So that's David Yannetti at the far end in the back there. There's Karen Reed. There's Alan Jackson. There's Elizabeth Little, a quite attractive blonde with often red fingernail polish. And then there's Robert Alessi. Robert Alessi sitting closer to us. He's off frame right now. And the woman who was the prior juror, who's now working on the defense team, but not at this table, is Victoria Brophy. And I'm pretty sure that's, I don't know for a fact. I should see if I can get a definite identification on this gentleman. I suspect it's Paul O'Keefe, the brother of John O'Keefe.
All right, jurors entering.
Oh, the jurors are here. Well, that didn't work. Let's see. We're back to the ceiling fan.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session.
I forgot my earplugs again.
For the record, before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. Our 18 jurors are present. The matter is on for trial.
Thank you very much, Madam Clerk. Good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. When we leave you out there, we're very much aware that we're leaving you in another room waiting, but we were working this morning to help streamline things and we were successful. So we do appreciate your patience. I do have to ask you those questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone nodded affirmatively or said yes. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did any of you happen to see, hear, or read anything about this case since we left yesterday? No. Thank you. Everyone said no. All right, folks, as you know, this morning we are going on a view. And a view is simply, we're going to a place that you've heard about. and that you will continue to hear about during the course of the trial. The purpose of the view is to help you better understand the evidence, which you'll hear during the course of the trial, and to help you appreciate the location and its surroundings. So the view that we're going on is part of the case, and it means that the observations that you make there can be used and considered by you in your deliberations on this case in reaching a verdict. So we're going to, you've heard 34 Fairview Road in Canton. The lawyers and I will accompany you. For the Commonwealth, we'll be accompanied by Attorney Brennan, and ADA Lally, ADA Schillinger, and for the defense, Attorney Yannetti and Attorney Little. The lawyers will have the opportunity, Mr. Yannetti and Mr. Brennan, have the opportunity to point out various things that they may want you to direct your attention to. Otherwise, there's no conversation between the lawyers and the jurors. So it's simply in a few minutes, you'll hear a little bit from each Mr. Brennan and Mr. Yannetti about what they want you to look at. And then when we get there, they'll direct you, look in this direction. They won't be able to testify to you, but they'll direct you on what they want you to look at. While you're in the view, you're not to take any notes, you're not to take any pictures, you're not to conduct any independent investigation at all during the view or any time during the trial. You're not to return to this scene or ask anybody to go back there for you. Today's your chance. You'll see photographs during the course of the trial, I bet, but today's your chance to really look at everything. So the best way to summarize a view is that your job is to simply stop and look. It's really no more complicated than that. So your responsibility is to see the place, observe it carefully, and to remember what you see. Now, during the trip to and from the view, and while at the view, you're not to discuss this case or anything about it with other jurors. We'll be accompanied by court officers who will direct you, and the court officers are there for all of us. So you'll be under their supervision until you're returned back here. So that's basically it. We'll be leaving in a few minutes, but first, before Madam Clerk swears the court officers in, Mr. Brennan, do you want to make a view opening?
May I?
Please.
Thank you, Your Honor. Good morning, ladies and gentlemen. As Her Honor explained to you, we're going to go to 34 Fairview Road. We have some exhibits that are already in evidence. You haven't had a long time to look at them, study them. But essentially, we're going to go to 34 Fairview Road. I ask you just to pay attention to the street, the front yard of the home. And you'll see to the left side of the front yard in the corner, there'll be a car. It's the Lexus that we've spoken about, the defendant's Lexus. And you'll also see a flagpole and a fire hydrant. And so I'd ask you to take a look from different vantage points. Take a look from that area where the flagpole is, from where the fire hydrant is. And you'll see on the street before the grass is a little firm, concrete that comes up a little bit. I'd ask you just to note that when you go there. One thing I'd suggest is April 25th, 2025, not January 22nd, 2022. So the weather will be very different. The temperature will be different. The conditions will be different. We're going to go there probably at 10 o'clock. It won't be the same visibility. It won't be the same elements and the same colors. Keep that in mind when you're looking around. When you look at the Lexus, a couple things I'd ask you to look at. There is some evidence already in of photographs of the right rear tail light. When you look at that tail light, it will be different than the photograph that is in evidence. It has been removed, so it will appear differently, and you'll later get testimony explaining that process. Also, I'd ask you to make a note on the Lexus about the height of the bumper. I'd ask you to make note of the height of the right rear tail light. And I'd also ask you to take note of, on the top of the hatchback, there is a part that protrudes. I'd ask you to take a look at that as well. Thank you very much.
All right. Thank you, Mr. Brennan. Mr. Yannetti?
Thank you, Your Honor.
Good morning. As I told you at the start of the trial, my name is David Yannetti. I have an office in Boston and in Dedham. And on behalf of my co-counsel, we will be accompanying you on the view that you will take today. Although the view is is not evidence. I suggest to you that you will find it to be helpful, important, even necessary as you later do your investigation of this case within the four walls of this courtroom. We've already received into evidence, some photos and videos, but there is no substitute for your own two eyes. As we all know, photos and videos sometimes can be misleading in terms of relative distances, depending upon the perspective from which the photo is taken. But your eyes are the best computer that you could bring to the view. When we get to 34 Fairview, we will be pointing out certain things that we'd like you to observe. The house, the second floor window to that house, the three front doors in the front of the house, the driveway, the street, the front lawn, and the flagpole. And we'll be asking you specifically to consider the distance between that second floor front window and the front lawn. The distance between the front doors to the house and that front lawn. The distance between the driveway to the front lawn. And we'll be asking you to take a good look at that Lexus. Just stand next to it. Just size it up. To take it in. You were all selected as jurors because the parties entrusted that you would do a proper investigation of this case within this courtroom. On behalf of Ms. Reed, we have every confidence that you will do a proper investigation. Thank you.
All right, jurors, I have to make something very clear. So the purpose of this view is to help you better to understand the evidence that you'll hear during the trial and to help you appreciate the location and its surroundings. The view you'll take is part of this case. The observations that you make while on the view may be used and considered by you in your deliberations in reaching a verdict. So at the end of the trial, when I explain to you what is evidence and what is not, I'll remind you that your observations on this view can be used by you in your deliberations. Also, while you're in the view, the same way you're not to take any notes or photographs, you're not to conduct any investigation on this case. You really are simply to stop and look, okay? Those are the instructions. We will see you in a few minutes. All right, thank you. Oh, sorry, Madam Clerk has to swear in the court officers.
You could all raise your right hand, please. Do each of you solemnly swear that you will take the jury upon the premises in question and there suffer them to view the same or any property, place, or thing bearing upon the issue in the trial as the parties may think necessary? That you will not permit the parties to enter into a debate in the hearing of the jury, nor any person to speak to them unless it be the attorneys of record, then only to point out such places or things as they may deem expedient for the determination of the issues. That you will keep the jury together until they shall return to court, unless the court shall otherwise order, so help you God. Thank you.
All right, thank you.
All right, please, jurors, follow me.
Goodbye.
Oh, goodbye. I think that might have been the court feed telling me goodbye. All right, so I'm just trying to click through some of these super chats and member notifications. This is for Nick. I do have member activated on the Law of Self-Defense YouTube page as well. Here's a new member, ASIB. Thank you very much. That's very kind of you. Your support is much appreciated. Let's see. Again, the biggest thing you could do for Nick and I during all this is subscribe. I'm only 79 away from 198,000 folks. There's several thousand of you watching this. If you're watching on Nick's channels, that's, of course, perfectly fine. You should keep doing that. But maybe open up another window. Pop over to Law of Self-Defense on YouTube and hit that subscribe button like it was John O'Keefe and you were Karen Reed drunkenly driving an SUV. as per the state's theory, and hit that thumbs up like button as well. And if you're watching on my channel, my YouTube channel, pop open another window and go to Nick's. Go to Ricada Law on YouTube and Ricada Law and Rumble and subscribe there as well. I know Nick would appreciate it, and I certainly appreciate it. All right. Still don't have a good feed from Nick. I'm just getting this. I'm hearing noise. Yep, I'm getting background noise from Nick's feed, but no camera yet. So not sure what's going on. We'll have to see when Nick can join us. Karen got Nick. His internet is messed up. I don't know. Yeah, he says actually criminal now. I'm going to leave Nick's story to Nick. Those of you who know, but I'm not going to continually retell his story. That's for him to tell. No tie Branca stream at 200,000. Yeah, we're getting pretty darn close. Whoops. Okay, that was the courtroom music, weird music. Synth, I think they call that. We're getting pretty close to 200,000. That'll get us 20% to the million, which is our goal, 1 million subscribers at Law of Self-Defense on YouTube. But we don't get to 200 without hitting 198 first. Now we only need 61 more subscribers to get to 198. At 200, I will have a very special live stream in appreciation to all of you, a no tie live stream. For those who don't know, a no tie live stream is as based as F. As based as F. Nothing but hard truths from me on a no tie live stream. We cover all kinds of stuff. We'll cover law, we'll cover politics, we'll cover relationships. We'll cover relationships as well, of course, because that's the kind of stuff we do here at Law of Self-Defense. We may talk about prior cases I've covered, and all kinds of funny memes, stuff like this. So for those who may not know me, it's kind of hard for me to believe, but I am, of course, attorney Andrew Branca from the Law of Self-Defense. My core legal expertise is use of force law, meaning self-defense, defense of others, and defense of property. In fact, this is a good opportunity to mention that tomorrow, I will be teaching a class. I only teach twice a year. It's a full day live class streamed from me to your computer, where I teach you everything you need to know to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. All in plain English. It's a very popular class. I only teach it twice a year. So if you miss this one, it's at least 6 months before you can get hard to convict if you're ever obliged to defend yourself. It's about 6-7 hours long. We take a 10-minute break every hour, cover a ton of stuff. It's a fire hose of information. We spend almost an hour talking about things like interacting with the police in the aftermath of a use of force event, which can make or break your case of self-defense right there. It's a bit more sophisticated than simply say nothing to the police. That's why it takes almost an hour for us to talk about it. And we talk about much else, of course. You can learn about all the stuff we cover. We answer more than 100 detailed questions about use of force law. It's all listed for description at lawofselfdefense.com/advanced. If you have a conflict tomorrow and can't attend a full day class, I totally understand. But I would urge you to register anyway, because everyone who's registered does get the recorded version of the class for 2 weeks afterwards, so you can watch it at your leisure over that 2-week period. Learn about all that and register at lawofselfdefense.com/advanced. lawofselfdefense.com/advanced. All right, let's see. Do we have things I need to address? Here's $5 for Nick. No question, but thank you very much. I'm sure Nick appreciates that. And $5 for me from G-Man. How many subscribers to get the Apple Bottom Jeans Branca stream? Maybe I'll sing the song during the 200K live stream. Apple Bottom Jeans, boots with the fur. Got the whole club looking at her. Yeah, I know the song. Much to my children's chagrin. Let's see. Please don't. We'll see. Anything can happen on a no tie stream. And I'll probably invite a bunch of friends on as well. I'm sure Nick will come on. I'll ask Joe Neerman, and we'll see who else might want to join us for some shenanigans. Maybe Steve Gosney, if he's available. I mean, I'll definitely invite him, but I don't know if he'll be available, especially for a no tie show. Steve is in hard adult mode recently, and for very good reason. He's I'm very proud of Steve. Steve is putting Steve Gosney, a lawyer from Florida, good friend of mine, found himself in a difficult professional position recently and came out like a champion, as I knew he would. Very capable, very smart lawyer. You can't keep a good man down, and Steve Gosney is very much a good man. All right, so let me see if there's any. I think I've covered all the super chat stuff so far. Feel free to put more in on my stream. If you're watching on the Law of Self-Defense YouTube and you'd like me to address a comment or question directly, it needs to be in the form of a $5 minimum super chat, or become a Law of Self-Defense member at our website, lawofselfdefense.com, and you get your questions answered for free instead of $5 a piece. Now, membership itself is not free, but it's less than $10 a month. So for less than $10 a month, you get all your questions answered for free. At least try it out for 2 weeks for 99 cents for a 2-week trial at lawofselfdefense.com/trial for a 2-week trial. And after that, it's, again, only about a quarter a day, less than $10 a month, and you get all your questions answered for free. So let me take a look at my member questions currently on the member dashboard. Let's see. Law of Self-Defense member Zakuza says, so Karen Reed could have hit him and just had no idea she did. Yes, that's possible. So the charges against her are second-degree murder, which in this case, I believe the state said at opening, they're not trying to argue she intentionally killed him. But another way to get to second-degree murder is that she acted with extreme indifference to human life, knowing her actions could cause death. So like racing the car at him could potentially be enough for that purpose. It carries the maximum penalty of life in prison with the possible, this is Massachusetts, so life in prison with possibility of parole. The other charges she's facing is basically vehicular homicide while drunk and then leaving the scene of an accident that caused death. All felonies. Let's see. Zakuza says the amount of reasonable doubt that can be generated from this case is wild. Yeah, the trouble is most jurors, although they're not supposed to convict unless guilt has been proven beyond a reasonable doubt, tend to default to kind of a preponderance of the evidence standard. That's how we normally make decisions. The defense did hit the beyond a reasonable doubt threshold. They talked about it in opening by defense counsel Alan Jackson. I thought he did a good job there. But, you know, we're going to go weeks before the jury hears those words again. Not until we get to the jury instructions at the end, closing argument. Let's see. Law Self-Defense member Cycle Boy says, do you think Karen got paid for those interviews? Desperate for funds to pay for this crud trial? I would have no idea. I've never been paid for an interview. That's why That's why I don't do as many as I used to. It's kind of a stupid way to raise funds for your legal defense by increasing your legal jeopardy. It seems like two opposed missions. Let's see. Law self-defense member Phil says, question, is a jury field trip to the supposed scene of the crime a usual thing? No, it's not usual, but it's not abnormal. It happens from time to time. It's always an option in any case. You just have to convince the judge that it would be helpful. It's much like getting an expert witness, right? So you don't always have to have an expert witness. The purpose of an expert witness is when you're dealing with evidence that's not within the common knowledge of a juror. Jurors are presumed to possess common knowledge. Ice is cold, fire is hot, knives are sharp. But when you get into technical knowledge that requires special training or experience that a typical juror would not be expected to possess, you can bring in an expert to discuss that kind of training and experience and expertise to put the evidence in a context that it's useful for the jury to arrive at a verdict. That's what these field trips are for. The argument is there's things about the physical scene that would be helpful to the jury in contextualizing the other evidence. And that's the argument for having the field trip. I think both parties were more than happy to have the field trip here, it sounds like. And so they're going. They're going on the field trip. I'm not sure how, well, who knows how much help it'll be. But certainly the lawyers feel that it's going to be of some assistance. And so it's something that's always on the table. It's not like it's a bizarre event. I wouldn't say it's common because it's not often done. But it's something everybody knows is always an option they can request. And if the judge agrees, off you go. Get on the school bus. Let's see. Yeah, like all other evidence questions, it's ultimately up to the judge whether or not a field trip happens. Law self-defense member Stogies and Boomstick says, question, what is the actual utility of visiting the scene almost 3 years after the fact? I don't see any utility other than to suggest to the jury that the fact that the scene exists, so she must be guilty. No, I think there are questions that the defense wants to raise that I think visiting the scene would be helpful for. For example, the defense wants the jury to wonder why the owner of the house was owned by a man named Alberts. There was lots of Alberts family members around this event. Alberts was a police officer. So about 6 a.m., John O'Keefe's body is found out in front of his house. And there's an ambulance, there's a fire truck, lights are flashing, there's multiple police vehicles, there's crowds of people, there's people screaming in anguish over the discovery of the dead body. And for some reason, Mr. Albert, who was part of the house party, this is his house, the party was at his house, who himself is a police officer, never bothered to step out of his house and see what was going on. And these lawns in these Massachusetts homes, from the front of the house to the curb, it's not a great distance. They're quite close. The front lawns are very small. So the defense wants to say, see, look how close that window is. Look how close the front door is. Why in the world would this guy not have come out to see what was going on right in front of his house? And the answer, of course, that the jury is supposed to come to for the defense is, well, that's pretty suspicious. Maybe he did something nefarious. And the state wants to make similar arguments with, like when Karen Reed's car was approaching the front lawn in the blizzard, at what point would it have been really possible to spontaneously see John O'Keefe's body in the snow? Karen Reed was the woman in the car. There were two other women, Carrie Roberts and Jen McCabe, driving around looking for John O'Keefe. And as they were approaching the party house at 34 Fairview, suddenly in the back seat, Karen Reed shouts out, "There he is, John, there he is." And the other two women say, we couldn't see a body at that point. So how would Karen Reed have seen it unless she knew it was there because she put it there with the impact of her car? That kind of thing. Let's see. Law self-defense member Phil says, isn't placing a white Lexus, is it the one involved in the case? Yes, it's Karen Reed's car. Isn't placing a white Lexus without all the other vehicles placed where they were that night likely to give a very inaccurate perspective of the case apart from the snow and weather? Well, the other vehicles may not be available. I mean, this is 2 years ago now, almost 3 years ago now. It is 3 years ago. people sell their cars. And those cars were not evidence. So they're probably not around. You probably can't actually replicate the scene that way. The lawyers will just have to address it. Any of those variations they think might be relevant to the jury's analysis. Phil says placing the actual damaged Lexus probably would be very prejudicial. That's what they're doing. I think it's relevant. I think it's relevant how high off the ground the bumper is, the taillight is, other physical attributes of the vehicle, especially given the nature, kind of the odd nature of the arm injuries to John O'Keefe. Law of Self-Defense member Zakuza says, Steve, speaking, I guess, of my friend Steve Gosney, is a turncoat working for the prosecution. So he's not working for the prosecution. He had spent, I think, a couple of decades working for the public defender's office in Florida, got a job to transition over to the prosecutor's office in Miami. That didn't work out for various reasons that Steve has talked about himself. And now he's working in civil litigation and doing very, very well. So he's out of criminal law, at least for the time being, which is a bad thing for Florida criminal law practice. Steve was an extremely skilled, highly trained, gifted criminal defense attorney and would have made a fantastic member of the prosecutor's team as well. So they've punched themselves in the face with all of that. But Steve himself is doing very well. Very happy for him. Law Self-Defense member Stogies and Boomstick says, I'd rather have someone like Steve on the side of the state than a lot of prosecutors out there, such as Binger or Lunchbox. Yeah, Steve had been a prosecutor before for a couple of years, I think, before he worked for the public defender's office. And I'm sure he's very good at it. But he's honest. Steve's an honest lawyer. So he's not going to he wouldn't pull the kind of shenanigans and tricks that a Binger or a Lunchbox Krause would, of the type of things they did in the Kyle Rittenhouse trial. Zakuza says, and the court's not going to go out and buy a Lexus. Well, that's for sure. Let's see. Yeah, I mean, the whole point why the prosecutors wanted Steve to join their team was because basically to inject ethics into the prosecutor's office, to let them know when they were doing things the wrong way. And they could have used that. It's really too bad. Let me take a look at a couple super chats here. These are from Nick's channels. And B, $5 to Nick. I'm sure he appreciates that. Why did the feds hand the defense over 3,000 pages of exculpatory evidence on behalf of Karen? Why wouldn't they? Why wouldn't you want them to do that? I mean, I don't know what exculpatory involving maybe the Proctor guy. So apparently the lead investigator here, again, I didn't watch the first trial. I'm just getting this from innuendo. I'm going to pull up the, just to subtly remind people that we're looking to get subscribers. Look, we're only 24 away, folks, from 198,000 at the Law of Self-Defense YouTube channel. Open up another window if you're not already there and hit that subscribe button like it's John O'Keefe. And you are a drunk ass Karen Reed driving a Lexus SUV in a blizzard. Hit that subscribe button. Get us to 198. Can we do it by the top of the hour? We have 4 minutes. 4 minutes. Let's make that odometer spin. So anyway, the lead investigator here, I don't need to make myself quite that small, do I? Okay, the lead investigator here was a Massachusetts state policeman. Proctor was his name. And he's apparently since been fired in disgrace for a variety of reasons. I don't know if that was part of a federal investigation. The feds may have handed over a bunch of documents related to him. I don't know. But certainly his involvement in this case will be used to impeach the integrity of the state's narrative of guilt against Karen Reed. I would expect. We haven't seen that yet, but that's what I would expect to happen. Again, this is a super chat to Nick's channel, M, $2. What level do you press your gas to get out of snow? So one of the apparent facts here claimed by the prosecutors that Karen Reed depressed her gas pedal 75% and sped her vehicle. at John O'Keefe. And the 75% is supposed to indicate, some kind of deliberate malice of some form, I suppose. Yeah, but there's other explanations consistent with innocence for why you might do that. Also, you might not really be pressing it that hard, but the wheel might spin, might slip with poor traction. And if the wheel's spinning and you're not moving because the wheel's spinning, you might press the gas harder in the hopes, a foolish hope, for those who haven't driven in the snow. You don't get more traction by spinning the wheel harder. But somebody might not know that and might press the gas pedal harder, even to 75%, in an effort to get some traction and move. Oh my gosh, we're going to do it. We have 2 minutes left. Can we get to 198 in 2 minutes? I only need 8 more subscribers, folks. Law of Self-Defense at the YouTube channel, 7 more. We have 1 minute and 57 seconds left. 6 more subscribers. Hit that subscribe button. Law of Self-Defense at YouTube. I know you can do it. Call your friends and family right now. Call your colleagues in the office. Tell them 5 more to go. We're so close. We have 1 minute and about 30 seconds. We need 3 more. 3 more subscribers. 2 more subscribers. We have 90 seconds to go. 1 more. Thank you. Thank you. Thank you. Oh, man, you guys, this community is fantastic. The law self-defense community and, of course, the Rekieta Law community. What great people. Thank you so much. That is so kind of you. Really, really appreciate it. The best way to support Branca is to become a platinum member and get hard. Yeah. Today, we're just pushing the advanced class. Our Law of Self-Defense advanced class. Learn how to get hard to convict all in a single day. You'll love it. It's a really good class. Many people attend multiple times because it's such a fire hose of information. And we'll talk in the class about how to become a platinum member and what that means in the course of the class. But the best thing you can do for yourself is just join us. Join us tomorrow, April 26th, for this full day class. I teach only twice a year. Learn how to be hard to convict if you're ever compelled to defend yourself, your family, or your property, all in one day in plain English. In plain English. And it's a great time. Full day class. We do take a 10-minute break every hour, so you have time to get up and get a snack and all that kind of stuff. But probably 6 or 7 hours, depending on how long the live Q&A goes. I answer all your questions, or at least as many as I can fit in, with as long as my voice holds up. And usually it's about an hour or so of live Q&A. And you will be genuinely hard to convict, an unattractive target for prosecution. If you're compelled to defend yourself, your family, or your property. Learn all about it at lawofselfdefense.com/advanced. And I'll put the banner for the advanced class back up at the bottom there and bring up the counter. Look at that. 198, and we already picked up another 30. You guys are fantastic. That means we're down to what? 1,970 to get to 200, and the no tie live stream. When I'm wearing my tie, folks, for those who don't know, there's a lot of new people here. Of course, I'm a lawyer. I do legal analysis, political analysis on the internets, as well as a legal consulting practice on use of force cases all over the country, helping people be hard to convict, helping them get acquitted or charges dismissed if they've been compelled to defend themselves. But when I'm in that official mode, I'm wearing my tie. So you can always tell the moment you see me on screen, is Andrew being serious here or is he having fun? Well, often I'm doing both, but when I'm in official lawyer mode, the tie is on. That's how you know. That's my signal to all of you. When somehow my earbuds, its cord got all tangled up. Let me see if I can fix this. All tangled up in the tie I'm referencing. There we go. That's better. But when the tie comes off, it's pure fun at that point. Pure fun and entertainment and jokes and laughs and memes. It's a good time. But I can only do it so often. It's exhausting. So when we hit 200,000, I'll hit it. Matthew says, "Sorry, Andrew, associating with the felon is an unsub for me." Nick's not a felon. It's not a felon. won't be a felon as long as he does his parole as instructed by the court. But he says associating with the felon, what was it? Is an unsub for me. That's fine. Everybody's entitled to make their own choices. Yeah, I don't know what's going on with Nick, but I'm sure something is happening. It's fine. I would have been streaming the trial regardless, although it's a lot more fun when he's here. Let me see. Are there more questions? Yeah, law self-defense member Zakuza says, Nick isn't a felon unless he wants to be. Yeah, so for those who don't know, I mean, it's really Nick's story to tell, but he's told it. I'll just paraphrase it. About a year or so ago, Nick got tangled up in drug charges, illicit drug charges. And it's been a year-long process. And just last Friday, he had a sentencing. And the sentencing is essentially 5 years of probation. Now, he was found, well, he pled guilty to the drug charges, but he was not sentenced in the sense of the verdict was not entered. So it's not a guilty. It's not a finding of guilt for criminal record purposes yet. You're found guilty by the jury, and then there's a separate step. The judge has to enter that verdict for it to count. What the judge has done here, what they often do, especially for a first offender, is they say, well, I'm not going to enter the verdict. I'm going to give you 5 years of parole, which means stuff like no drugs and alcohol, no drugs, obviously, but no alcohol. And if you go through the parole for 5 years and you don't have a problem, I'll never enter the verdict. So it'll never be on your record. And then there's no criminal record. If you screw it up, then I'm going to enter the verdict. So then you get whatever you screwed up, whatever new charges that might involve, and we retroactively enter the conviction. So that would not be good. And I sure hope that Nick doesn't do that, but I don't expect he will. I have confidence in him. Let's see. Yeah. Law self-defense member Zakuza says, Nick has been given the opportunity to not have the felony conviction entered into the record. And that's correct. It's a good deal. It was a good deal. I've always wanted, I said from the very beginning, my hope for Nick is that he gets the best possible outcome for himself and his family. That's not excusing Nick for bad decisions. He has owned up to those. He's being held accountable for those. But this is a pretty good outcome for Nick and his family. And I'm very pleased about that. I think Nick's a really smart and talented guy. And I think he can bring a lot to the internet and to his community and to his family in a very positive way. And it's not necessary that he screws it up. That's, of course, up to him to determine. Let's see. The Nick redemption arc. I hope so. I believe in redemption. That's why I'm co-streaming with Nick. Although there a number of you are unhappy with me about that, but that's fine. Law self-defense member Zakuza says a sequel to My Cousin Vinny is in the talking stages in Hollywood. I don't know, man. That would be like a second season of Firefly. You don't think they're going to screw it up? I don't know. I'd be pretty nervous. That movie's perfect. My Cousin Vinny, best law movie ever created. Very, very accurate in terms of the actual law, and of course, very entertainingly done. It's shocking for me as a lawyer to watch My Cousin Vinny and see just how good it is on the law. It's amazing. Maybe now that DEI and woke is getting strangled in the crib a little bit, maybe now Hollywood could produce a good sequel to My Cousin Vinny. I guess we'll have to see. Joe Pesci wants back in. Well, he was excellent in the role. And Marissa Tomei, of course, was fantastic. Everybody in that movie was very good. Very, very good. Even like the witnesses in the court, they were all fantastic. The guy who played Herman Munster played the judge. I don't remember the guy's real name. Law self-defense member Stogies and Boomstick says that unsubscriber guy must not believe in redemption. Yeah. Everybody's entitled to, Nick has his share of haters. And listen, it's not like those were good decisions. No question about that. Zakuza says, as we all know, Marissa Tomei is still banging hot. Very attractive woman, for sure. Very attractive woman. Let's see. Yellum says Nick is the only reason Branca has an audience at all. I'm not sure that's true. I had 50,000 subscribers before I ever met Nick. It just, that number never went up from 50. And most of our growth has been in the last year when Nick wasn't really streaming. So, but that said, being on Nick's channel has often been very productive for me, financially productive. Because of course I have like the course I talked about the law of self-defense advanced course. We have books here at Law of Self-Defense, and Nick's always been very generous with letting me pimp my products and services when I'm a guest on his show. And he's had massive audiences, especially during things like the Johnny Depp trial, and that's been extremely financially rewarding for me. So I can never thank him enough for all of that. But I don't think I ever got many subscribers from Nick because I was always guesting on his streams. We weren't doing this co-streaming thing like we are now. I don't think it was available at the time. Let's see. Can I do these? Collector's Digest. This because it's flattering. It says, Branca is extremely intelligent, the world's leading expert in the law of self-defense. At least America's leading expert. I am an internationally recognized expert in self-defense law. I have been interviewed at length on international news stations about self-defense law. Lenny says, 100% the best law movie ever produced, My Cousin Vinny. Absolutely. Absolutely true. By the way, you can get our book, The Law of Self-Defense, the soft cover version of it. This is the hardcover. But you can get the soft cover version of the same book for free at lawofselfdefense.com/free. I have a banner for that too. There you go. lawofselfdefense.com/free book. We do ask that you cover the cost of shipping, but the book itself is free. You can check it out on Amazon. It's 5-star rated on Amazon, folks. I mean, well over 1,000 reviews. But Amazon will charge you for the book and the shipping and handling. We only ask you to cover the cost of the shipping and handling. If you'd like to get the hardcover of the book, you can do that too. But that one's not free. It costs too much to print up the hardcovers. Get the hardcover at lawofselfdefense.com/gethard. These are very, by the way, pretty books. They make great gifts, the hardcovers especially. Father's Day is coming up. Mother's Day is coming up. A great gift for dad at lawofselfdefense.com/gethard. Get hard. Let's see. The members, Law of Self-Defense members. Psycho Boy says, the Rittenhouse trial with the full LawTube group was fun to watch. I had fun. Of course, I'm from New York, and I'm just kind of, I like to talk, and I just kind of insert myself into conversations. If I have something to say, I just say it. Some of the other LawTubers are kind of, I guess I'd call them more polite. And they would like wait for an opportunity to speak, like for a pause. And if I'm in the group on a self-defense case, there's not a lot of pauses, folks. So I think a lot of those people thought I was just talking over them all the time. Sorry. Zakuza says the book goes well with a gun as a gift. Indeed, it would be wonderful. Every gun should come with a copy of The Law of Self-Defense. Every gun. Law of Self-Defense member Stogies and Boomstick says, I found Branca from an interview he did on War Poet, John Lovell channel. Yeah, I like John. He's a great guy. Very popular YouTube channel. I think it's called Warrior Poet Society. Is that what he calls the channel? Great content, very well produced. John, I think John is a former Army Ranger, if I recall correctly. Yeah, big fan. I think he interviewed me for self-defense insurance. About self-defense insurance programs, if I recall correctly. But I do a lot of interviews. Zakuza says, I remember the Depp trial. Feels like decades ago. It sure does. It sure does feel like decades ago. Zakuza says, I forget the trial that got Branca a BMW. That wasn't a trial. That wasn't a trial. So Nick hosted me on a stream, a live stream. I was a guest, but we were talking about another attorney. We were talking about, I don't even remember her name, a young woman, a female attorney, who was during the Kim Potter, the taser trial, had made some legal arguments that I thought were really silly. And so I think I'm hearing Nick getting ready to pop in. So I was critical of her legal theories, and I explained why on Nick's show. He hosted me on. I explained why she was wrong, and she got very upset about that. But it was in the course of that show that I was. I don't remember what I was promoting, but whatever I was promoting, we sold enough of it to buy me a BMW and two Rolex watches. So that was pretty awesome. Hey, man.
Hi, my camera is doing this great thing again where it's obscenely choppy. I don't know what causes this. Or
I think
why.
it still is.
Yeah, I know. I
Okay.
can see. So I'm trying to fix it in real time, which is making me want to exercise the earth of all life. So
Well,
yeah.
nothing's happening. So we just got the ceiling fan from the court going. So they're on the
lovely.
field trip right now. They're at 34 Fairview, or on their way, I guess. And so I've just been telling war stories.
Well, thank you for doing that. I apparently had a date with my mattress and slept through all my alarms. So that was nice. That was good. But I'm glad how this co-streaming works because it's just taken, it's just running it. I'm just trying to figure out what the hell is up with all these fucking tabs. Get rid of all these tabs. See what's going on. Maybe I can just, I have no idea.
I got a super chat here for me. Donnie says $5. If I order a Branca approved hardback book, which you can get at lawselfdefense.com/get-hard. That's how hard it is, folks. Can I get it signed? The answer is you can get it signed, but you'd have to find me. I don't sign the books come from a warehouse, so I don't see them before they go out. If you find me at some event or in person, or if you want to send the book to me, and I'll be happy to sign it for you. But I don't think you can order a signed copy. I used to pre-sign copies and put them in the warehouse, but it's a lot of books, man. It's like boxes and boxes of books to sign. I just don't have the time.
Look,
but if you happen
you,
to catch me, I'm happy to do it.
Yeah, if you can catch him like from the bushes, around his house,
well,
late
I
at
wouldn't
night.
do that.
Not safe.
That might get loud and flashy.
Not safe at all. I may have to reboot again. It's weird. If you just reboot a computer, you think rebooting it probably won't fix the problem, but maybe there's like a driver update I'm missing. I want to scream.
I'm a boomer. I just pour gasoline on them and set them on fire and buy another computer.
I'm very close to doing that. The computer I want just released today, actually. I want to kind of change up how I do things. But, I don't know exactly when I'll be able to grab one.
Far Side says, change the USB port.
That's actually good advice. Let me see. I'm going to try out a different one.
Unplug the camera, let it sit for 5 minutes, and plug it back in. Okay. It's like a woman. You got to give her a timeout. It's like Karen Reed starting a fight. You got to sit her down for 5 minutes, let her calm down, give her a few drinks.
So, the crazy thing is this is not bad advice. Sometimes you get really terrible tech advice, but I use a DSLR camera, mirrorless camera. And so it has to run by HDMI into this little thing called a cam link. And I think the cam link is exceptionally warm right now. Hello, touching it, caressing it. It is smooth to the touch. But no, it is a little warm, so I'm going to let it sit for a minute. That might be the problem.
What camera do you use?
I use a Sony Alpha 7R.
So that's what you use as your webcam. So I have one of those. I'm using a Logitech Brio right now. But one of our contractors suggested I buy this Sony A7 thing, Alpha 7. So I've got one. I can see it from my desk here, but I never considered using it as a webcam. Are you able to stream like in 4K doing that, or what's the advantage?
You've seen my you've seen the video. Like it's a 59 megapixel camera, and I've got like a $1,500 a 24 millimeter lens on it. So it just looks really nice. but yeah, it's kind of, sometimes it's a pain. Like the camera isn't doing anything other than just capturing the room like a, like a camera does. And then you have to run it in through a capture, like a capture card, or in this case, a Cam Link USB stick. And that's what turns it into a webcam. But it just looks better because it's got a bigger sensor. So it's better with light. Like webcams are fine.
Well, mine does weird stuff like suddenly the color shifts. Like I have so much blue because the wall behind me is blue and I often wear a blue shirt. It just decides everything. Andrew needs to look like he's underwater right now and just turns everything. I look like a Smurf.
Well, I wasn't going to say anything. Let me see if I can try this one more time. Problem is with my broadcast software, everything looks perfectly fine and smooth. And then I'll go over here. I think it's a memory issue that I have. Yeah, look. See. I don't think this has anything to do with my camera. I think this has a lot to do because it's just pulling in the same 4K video that any other camera would. I think this is something I've been dealing with. I think I have a bad RAM stick or something. So get a Mac Studio M3. I don't want anything on a Mac. Oh my God, kill me. No, a family who uses Mac. I just not my. Everything. My entire life has always been Windows associated. Well, prior to Windows, but mostly Windows associated. And it's like I don't want to redo everything, relearn everything.
Yep.
Plus,
I would never go back. I'm using a Mac Studio right now. My whole house is Mac. That's all we use.
Yeah, I mean, people who use them, awesome. For me, no, not my style. Let's see, drivers. So I have a driver update. Is that what happened? Fucking hell. Yep. It's probably gonna fix it.
Yeah, I can't operate. I mean, I've used Windows machines, of course. I used Windows XT was my favorite operating system for many years. I used it long after they stopped supporting it. But once I got into Macs, now if I try to use a Windows computer, it's unusable to me.
Let's see. Install.
It can't be anything on my end, right? That's
No. It's. I think it's this. I just did a driver update. Now I have to restart my fucking computer again. I hate this. It used to just be that you would just not have to do anything, and everything that worked would continue to work. Does that make like you wouldn't, if it worked, it would just stay working. Nowadays, like, well, it was working this morning. Now it's not. All right, I'll be right back. I'm gonna restart and hopefully that'll resolve this issue.
All right, man. I'll hit some more Q&A here. Let's see. Yeah, I think Nick normally builds his own computers, but he's talking about, I guess, some high-end pre-built one just came out that he's interested in. Thanks for all the ongoing subscriptions, folks. Let's make that odometer spin, spin, spin. Subscribe, subscribe, subscribe. Oh, we got some super chats here. All right. Well, this one I answered from Donnie. Thank you, Donnie. You'll really like the book. The hardcover is really a nice looking book. Looks great on a bookshelf, too. Really a nice gift. Let's see. $5 super chat for me. Thank you very much, Sport Nuggets. And I figured I should give you a chat since you're the one I'm actually watching. You can give us both chats. Just go back and forth and give us both super chats. We both like money. That's fine. We appreciate your support. Fret Pound says, Nick should have taken your class. Well, yeah, I don't teach that particular class. My class is for when you're concerned that you might have to shoot somebody someday or otherwise defend yourself. M says, $2 super chat. Love your contribution. Thanks for being here, Branca. Yes, it's my pleasure. It's my pleasure. I love hanging out with all you people. Little Gray Squirrel, five British pounds, says, sir, can you study UK law and do a version of your book for us? Thank you for your stream, insights, and supporting a friend. Well, that's very kind of you. And no, I will not be doing that. American use of force law is quite enough. We have 50 states, the District of Columbia, Puerto Rico, Guam, Samoa. It's enough. it's quite enough to cover as it is. Especially since I'm doing so much political analysis these days of the Trump lawfare stuff. So if you look at our YouTube channel, my YouTube channel, Law of Self-Defense, it's mostly political legal analysis, constitutional law legal analysis of all these unelected black robe tyrannical inferior district trial court judges who think they are all powerful, universal authority and jurisdiction. It's just not true. Judges, in fact, have very limited authority. And that authority, the scope of that authority is denoted not just by the Constitution, but by Congress. All the inferior courts, every federal court besides the Supreme Court, is not a creation of the Constitution. It's a creation of Congress. Article 3, the judicial branch of government under the Constitution, says there shall be one Supreme Court and such other inferior courts as Congress may from time to time create. And Congress determines the jurisdiction of the district federal courts, and that jurisdiction is limited. It's limited by subject matter. We have specialty courts, for example, that handle things like immigration and bankruptcy and tax, patents. That those things, the jurisdiction for those subject matter areas are taken away from the federal district courts. We have another specialty court is the Court of Federal Claims. If you have a contract dispute with the federal government, normally you cannot sue a sovereign government unless the sovereign government gives you permission. Well, our sovereign federal government says, yes, we'll allow you to sue us, but only in the Court of Federal Claims, not in federal district court. So all these contract lawsuits, these spending lawsuits happening in federal district court are happening completely without jurisdiction. Hey, Nick, welcome back.
See, we got it fixed. Who knows?
All right.
Everything's nice and smooth now, like baby food coming out the other end. That was disgusting. That was horrible. Why would you say that?
Let's see, another super chat here. 10 and more. What is this? What is that? Oh, euros. 10 euros. I used to get paid in euros. About a decade ago, I lived in the Netherlands for 2 years working there, and I got paid in euros. 10 euros. Creative Starfax, whatever happened with that organization you volunteered your time to, but then you ended up at some Karen convention and they sent an angry letter. Oh my God, there's so many groups I make angry. I'm not sure. You're thinking of USCCA? That's one.
I think so.
Um,
wait, no. Remember, we
the
we read
Public
the letter
Defender's
on-
Office,
Yeah,
Colorado, right?
we read that on air. That was hilarious.
They're so unimportant. I forgot all about them. The Colorado Public Defender's Office. Yeah, I did a legal consult for them in a murder case, pro bono. I didn't charge them a penny. I had to show up in court for multiple days to testify, and I got their client acquitted. And I know it was me because their defense counsel used my PowerPoint slides in his closing. Didn't even ask me. But which is fine. But we got them acquitted, and then they were so proud of me. They asked me to speak at their annual conference, the Colorado Public Defenders Annual Conference. So I did, again at my own expense, paid for my own hotel room and everything. They gave me a T-shirt, and then it turned out apparently when I mentioned that some of the examples I was giving involved young black male defendants.
Uh-oh.
That was too much. That was over the top. They sent me a 4-page single-space typed letter in the mail, the physical mail, and amongst other things, told me I was persona non grata. They'd never work with me again, and they wanted their T-shirt back. So instead, I raffled off the T-shirt online for $1,700 and gave it to a Second Amendment rights organization out in California. That was a fun time. But yeah, so now if you're an indigent criminal defendant in the Commonwealth of not the Commonwealth. In Colorado, you can't have me pro bono. The Colorado Public Defender's Office won't let you, which seems kind of a weird way to deal with your client's defense, considering my success rate. But there you go.
Which is insane because pointing out a factual proposition, a consistent pattern when we're talking about the general topic of legal self-defense, of law enforcement, there are specific things that can be said that are terrible, but there are also realities that must be addressed. And many of these organizations would agree with the realities, but if you start saying it out loud, if you say this community is starting to have a problem where there's consistent issues where self-defense law is starting to play more and more because of circumstances surrounding it. I mean, the public defender's office is the type of organization who would agree with those analysis. They would just have different reasons maybe than someone else as to why that's happening.
And I wasn't making a value judgment. I wasn't saying something like, hey, we got to be careful around these young black men. They're dangerous. I just happened to mention their gender and their race. It was part of the police record. The public defender's office could have taken it the other way. They could have said, you know, it's really good he's pointing this out because these young black men are getting shot by police at unbelievable rates and the problems with the police, right?
Right.
But they chose not to take that approach.
No, they're so scared of it really depends on where we are on the issue at any given moment, but they're so scared of the mention of a demographic reality. Ever since demographic based policing produced good results, actually, that's kind of the scary thing. And I don't mean demographic based on race. I mean, in a city, you can take demographics relevant to that city and you can focus policing in a very specific way to target crime and do it very effectively. They did these studies back in the 70s that I've talked about a couple times, and they found that in every major metropolitan area that they studied in the United States and globally, 50% of crime, it's not a 1350 joke here, but 50% of crime was entirely encompassed in 5 city blocks that are not economically mobile, which meant if they focused their policing on those 5% of city blocks where the crime is high, it's not mobile. So they could actually effectively reduce crime and it stays gone. But they can't do that because people call them racist. There's nothing to do with race, because if you go to London, those 5 city blocks have a different racial makeup than in the United States. It's just the realities of where crime is focused, because that's where drug trade goes. That's where, prostitution rings start to happen, and crimes associated with those things are violent because they involve the enforcement of territory. They involve the wrangling in of employees, et cetera, et cetera. But, don't have a demographic discussion about crime with the wrong crowd. They will make you return your t-shirts. Then what will you wear?
Yeah. Hey, here's one. $2 says, can you explain the new gun laws in Colorado? I can't really, because I don't care what they are, because I'm moving out of Colorado because of the gun laws. But I can tell you generally. So Colorado's gone completely insane. They have worse gun laws now than California does. They've basically banned the purchase of any semi-automatic firearm at all. They've put a massive training requirements on getting a concealed carry permit, made it much more expensive, which of course only hurts poor people who may need a concealed carry license to defend themselves from the crime in their community. They put a tremendous tax on the purchase of ammunition. And now they're looking at passing what they're calling an armory bill, which will tell you the number of guns you're allowed to own.
Oh, lovely.
In your home. Yeah.
I remember that in the Second Amendment where there's like a cap.
Yeah. That part where it says no infringement.
No, right. No infringement unless you get past 7 cool guns.
Yeah. So when I moved to Colorado, I only moved here because my wife was raised here. Her family is here. And when I moved here 8 or 10 years ago, it was a purple state. So the legislature was split. There was there was some of the granola California type stuff going on, but much of the state is very conservative. The county I moved into is perhaps the most politically conservative county in the country. So that was fine. But I told my wife when we moved here, listen, I'm fine being here. I ride a motorcycle. The mountains are great for riding. The world's best, actually, in my opinion. But if they start screwing around with the gun laws, I'm out. Well, they started screwing around with the gun laws. So we're out. We're moving to Tennessee, probably Nashville, south of Nashville. We're about 90% decided. But yeah, so I'm not going to worry about the Colorado gun laws because I am gone. Colorado can go stuff itself. Me, my business, my taxes. I pay a lot of taxes in Colorado. All that money and me, my family, we're out. We are out. I don't need to be here. And they're doing all the other California type stuff. You can't get bags in the shopping in the grocery store anymore.
Oh my God.
All that kind of nonsense. So I'm done.
every time I go somewhere and they're like, "Are you getting a bag?" I'm like, "Yes, it's a grocery store and I have stuff. I'm not going to carry it around in my arms like some sort of weirdo, like dropping bell peppers all over the place. Yes, I want a bag." And they're okay. And they tap it in 1, 2, 3, 4, 5, 6, 7 bags. I'm like, here's your 14 cents. What are we doing? What's going on here? They used to just be baked into the price.
You can't get plastic bags here at all. They only have these paper bags that are apparently made out of tissue paper. So you put a dozen eggs in it and you pick it up and the eggs fall out the bottom of the bag. Of course, they want you to haul around like you're a serf, a bunch of permanent reusable shopping bags in your car all the time. F you, I'm not doing that. I'll spend $20,000 moving out of your shitty state before I start storing disgusting reusable grocery bags in the trunk of my BMW X4.
I just found out the Rumble stream was not running. That's my fault, I guess. It should be running now.
It's running now. It's
What a
showing at my
disaster.
end.
What a disaster. No, I hate the. Oh, go ahead.
I was just going to say, by the way, I just had a very interesting experience with cars. So about a year ago, I drive a very nice car. It's a BMW X4M. It's like a, I don't know, 400 horsepower car. Perfectly fine car for me. But it was time to buy my wife a car. So we got her a Tesla X Plaid. X is the one with the Gulf wing doors. And that Plaid, holy crap. We've had the car a year. I've never floored the gas pedal completely. I got too scared. I get like Karen
do it.
Karen Reed, 75% down. And it's like that scene from Star Wars where the Millennium Falcon goes into hyperdrive and all the stars turn into lines and start racing at the spaceship. That's what that Plaid X is like. It is so fast. It's unbelievable. I love the car. The car was great. By the way, Teslas make other cars feel stupid as far as I'm concerned. But we had a problem with the car. One of the Gulf wing doors, the passenger side one, the one my wife would use to drop the kids off at school and pick them up, it kept not operating. It kept failing. And so you'd have to get out on the street side of the car. We don't want that with kids. We brought it back to Tesla like 7 times, and they would fix it and it would work for a few days and then it would stop working again. And finally I went to Tesla and said, listen, it's a $100,000 car. I mean, it's an expensive car.
Right.
I said, it's got to work and you can't fix it, obviously. So I'm going to lemon law this car. And they said, well, you don't have to do that. We'll do a buyback. And I said, oh, really? I said, all right, well, figure it out. Send me your numbers. And maybe I won't have to go to court with this. And they gave me a very generous buyback offer.
Nice.
I have to say. So I'm not making any money on it, but we did drive the car for a year. And
Right.
what they're returning, I think, is very reasonable. So we're taking their offer. And so we're selling our Tesla X Plaid back to Tesla on very good terms. So I'm very pleased. We're back to being a 1-car family. But of course, we only bought a second car because I had an office out of the house.
Right.
And we only did that for 2 years. I'm back in the house now. So we don't really need 2 cars. I've got the motorcycle. And we're moving to Tennessee, and it's one less car we have to move in a year. When we move over, we'll buy a second car when we get to Tennessee, I imagine. But the Tesla was a really great car. When it didn't work, I thought the company did a great job. It was very fair. But I don't know if I'll buy another X. Those Gulf wing doors look cool, but they're kind of slow to open, which is a little inconvenient when you're doing drop off at a school when everything's happening very quickly.
Right.
But
You just tape your kids to the outside.
To the
Like,
outside,
that's-
yeah.
Yeah. They
Throw
don't need to
them
be
at
on the
back.
inside of the car. We're a 3-car family because we still have I have 5 kids, for those who don't know. And so we still have like a big 12-passenger van from back, because everybody hates, or like everybody, all these companies hate larger families these days. Like, the more kids you have, the more inconvenient everything becomes in just small ways. And buying a car that can take 7 people around comfortably, you're relegated to minivan, SUV, or giant van. And SUVs tend to get really expensive really fast. So a while back, when we needed a place that could fit 3 car seats, like full-size car seats at a time, when the kids were the wrong age for everything. And so we had this giant van. And so we still have that thing. But if if one of our kids is bringing a friend anywhere and we're bringing everybody else, we have one more person, we have to have the giant van, like, because there'd be 8 of us. But otherwise, I drive a Lincoln Navigator, which is much more comfortable. But there's so many damn electronic systems in this thing, and I like all of them, but when they don't work, it's the most infuriating thing on the planet. Like, I had to get it fixed because the main computer like broke just randomly, and it took them forever. They couldn't figure out why. It turns out in the right captain's chair, a wire had gotten the insulation on the wire had worn loose, and then the wire was being pressed against a metal piece inside the chair when anyone sat on it, and it would short the battery through this metal. Like, it would just drain the battery entirely, and it just they couldn't figure that out. But it only happened when someone was sitting in that seat in a certain way, and then it would push the wire against this part. So they finally figured that out. But when they did that, I guess while they were testing it, the running board motors got desynced and broke, and so now they're sometimes out, they're sometimes up, they're sometimes halfway. Sometimes they're not very good running boards. They don't support anything. Kind of like the Democrats. They don't support anything. But and you can't just turn them off for whatever reason. Like, you can try, it just doesn't work. So now it looks like it's all janky. And once you have janky electronics in a modern car, you want to kill it every single day. But yeah, and then I have my Mustang, which is awesome, but you can't drive it in the winter here. You just can't. Yeah. It goes right off the road. It's fantastic. So
how much to get Joe in on this? I don't know if Joe wants to get in on this. I don't know if it's possible. Can you co-stream 3 people?
I would assume so, but I don't know. I've never tried it.
I mean, as far as I'm concerned, if Joe would like to join us, that's fine with me.
Yeah, I love that guy. He's been such a good friend ever since I met him. I would have no problem. I spoke with him by text briefly the other day, and he didn't mention, or he asked. He said he would pop on at lunch or something sometime if we wanted.
Oh,
the other day being, I think
Joe's welcome anytime.
Yeah.
Smart guy, smart lawyer, entertaining. I'm not sure I'd want to go above 3 though. The large panel things,
terrible.
I have I think a little PTSD from some of those, even though they work fine for me because I just talk over everybody. But it's just the energy gets kind of negative over time.
It's too many people who everybody wants to say what they want to say, which is great. But then there are people who maybe aren't as assertive, and they get to be bad feelings if they didn't speak up. And it's like, sorry, no one knows when you wanted to talk unless you say something. They don't always approve of the same jokes. Some of them are wildly dull.
Yeah, if Nick and I are on a stream, there's not a lot of pauses for other people to enter the conversation. You just have to kind of elbow your way in.
Right.
Which is fine. I wouldn't take offense. Talk over me. It's okay.
Speaking of elbows and how sexy they are, I've got some chats and stuff that were going on. Thanks for running a show for me. Like, I didn't even know what I was doing. I woke up and I was just like, what the hell? Oh my God. Here we got some of these. Scott, Christy Jones, Nick, watch the stream start. Branca is a knobber. What happened at the start of the stream? I have no idea. M, thanks for the donation. Says also, what level do you press your gas to get out of snow? Depends on the car. Depends on the snow. Legitimately. When I found out how to turn off traction control on my last car, because if you have really thick, fresh snow and you get into a spot, your tire will just spin for a little bit because it has to get down. And you have to turn off traction control literally to melt the snow to get down to the ground underneath it sometimes. And until you learn how to do that, your car will just sit there and you won't get any torque to the tires at all. It's useless. And B, why did the feds hand defense over 3,000 pages of exculpatory evidence on behalf of Karen? Because they may have been obligated to. I mean, that would be the main thing. Why wouldn't the feds hand over 3,000 pages of exculpatory evidence on behalf of Karen? Like, I don't know. I don't know what any of that actually represents, though. Like exculpatory evidence could be anything, and it could not amount to it. It could just be something that is potentially useful in their defense. So
just FYI, there's no way to coordinate this, but I answered a bunch of these early on while
Sure.
we were waiting. But those are my answers. So if I'm not jumping in now on these, it's because I've already said what I had to say about it. So
Oh, gotcha. Sounds good. Colby Newlick says the best way to support Branca is become a platinum member and get hard. Donnie says, if I order Branca approved hardback, can we get it signed? I saw you answering that one. Fret Pound, Nick should have taken your class. Em, love your contribution. Thanks for being here, Branca. Chief Danny, StreamYard is a memory leak issue. You'll need to restart when it happens again. So it's StreamYard? Maybe. Angela Picard, thank you. Crypt Keeper VT. Nick, have you considered streaming The Game Schedule 1? Cheap $20 game worth every penny. The Game Schedule 1. No, never heard of it. Was not considering streaming gaming right now because I haven't been into playing video games in a little bit. Angela Picard, can you explain the new gun laws in Colorado? Yeah, I heard you. Oh, there we go. Oh, M for the Joe Fund. Frederick Little says, Nick, would you get a motorcycle? I almost bought one a couple years back, just on a lark. I was down at the post office, and there's a power equipment store right next to it. And so they have cool like ATVs and stuff. But the guy had a motorcycle out there, and it was like it was a Harley done in the style of Captain America's motorcycle from the Captain America movie with Chris Evans, and it was awesome. It was really great, and it was super inexpensive. But never driven a motorcycle, and I was about to go on vacation. I said, if it's here when I get back, I'll buy it, but it wasn't. But I don't think Lady Raggets wants me to get one because she knows if I get a motorcycle, I'll probably be dead in a couple days because I have a problem with driving fast. I mean, actually, I have no problem with driving fast. That's the issue. And on a motorcycle, I'd probably be flying off it. Last night on says, please get Angry Joe back so I can make more shorts. He is too chill now. Well, we'll get Joe worked up pretty soon here. I love that guy. I like when he gets in it, man. He just goes and goes and goes. It's like sometimes it's fun to push his buttons. This one. So here's a super tip that came in yesterday between shows.
After those texts, I'm not convinced he killed himself and his cop friends helped him frame her.
That text message conversation was pretty brutal, man. She just needed to, lady, you need to stop for a little bit. Just stop. You can get attention from him later.
she just wanted to get laid.
Ava, no, women don't like that. Ava says, welcome back. Nick got his own stream back. Woohoo. Yeah, sorry, guys. This one has several voices.
Hey, Nick. Great to see you back. Love your energy. I've seen the procurium of the Abrego Garcia deportation order on Robert Gouveia SQ channel, but Noon is discussing the validity of the claim that
the withholding from being returned to El Salvador isn't in it. El Salvador was mentioned as a request at the top, but the withholding is for Guatemala, where he and his family moved to when he was a
young boy. His family was being threatened by Barrio 18 gang, causing them to move 3 times within 15 minutes of their home and prompting them to choose which child they were going to protect by
sending him here. Ironic that they were protecting him from a gang and gang violence, and he became a gang member and abuser. He had roots in El Salvador.
It's not that ironic.
Because he's a citizen by birth. Can you
go through it and answer the question of whether their argument about the assumption the left is making that the Article 2 judge meant El Salvador and the legality of their claims and attempt to change?
I mean, not on a Karen Reed show.
There's nothing happening. I mean, it's not that hard. First of all, it doesn't matter. This whole withholding order to Guatemala or El Salvador, it doesn't matter. If the order, so for those who don't know, this guy had a final order of deportation. Our good friend Kilmar Armando Abrego Garcia MS-13 terrorist, spousal abuser, human trafficker. He had a final order of deportation in 2019, approved on appeal by an appellate court, immigration court, appellate board. And he was still here in 2005. Now, as part of his order of deportation, he got an order of withholding. There's a little, which simply means you're still deported. We can deport you to any country that'll take you. But an order of withholding means we're not going to deport you to this particular country. Maybe you're afraid of the government there or of gangs there or whatever. And there's some ambiguity about whether the order of withholding was for El Salvador, his nation of citizenship, or Guatemala. It doesn't matter. If it's for Guatemala, and the reason this is an issue is because we ultimately sent him back to El Salvador, deported him to his nation of citizenship, as you normally do.
Bye, guy.
So there's two, and people are saying, well, he had an order of withholding to El Salvador. You can't send him back there because of this order of withholding to El Salvador. Well, either the order of withholding was actually for Guatemala, in which case sending him to El Salvador was fine, or the order of withholding was for El Salvador and sending him there was still fine because Armando Abrega Garcia's status changed before we deported him. He changed, he graduated from being a typical illegal migrant to being a terrorist. In February of this year, Secretary of State Marco Rubio said, I am designating MS-13 to be a foreign terrorist organization. That means every member of MS-13 is a terrorist. Abrego Garcia had been adjudicated by 2 courts to be an MS-13 member back in 2019. And now in February 2025, he's graduated to being a terrorist. Guess who is not eligible for an order of withholding? Terrorists. They don't get it. So the fact that he had one in his pocket for 6 years, he should have used it during the 6 years. The moment he became a terrorist, that order of withholding became null and void as a function of law, and we could send him anywhere. So where'd we send him? Where we normally deport people back to their nation of citizenship, El Salvador.
And so immigration laws are really, it's simultaneously really complicated and really simple. The interesting thing is these district court judges muddying up immigration and the court's role in it. The court's role is not to step in front of the president's decisions on immigration and deportation, because these are matters of foreign relations directly. I mean, if Trump's bringing the president of El Salvador into the White House to explain why this is a foreign relations issue, you're already in the purview of the president, and he is, according to the Supreme Court's own doctrine, he's the sole organ of foreign relations, and decisions that are made by the executive in regards to foreign relations matters are plenary, and the court's ability to step in and have any discussion on them at all is limited. The only thing the court is able to do is to recognize the potential that a deportation back to a home country could have some, I guess, some violation of someone's rights because their home country is so terrible. But there's an amnesty process, but that amnesty process is run by the executive. And the Supreme Court's job in this field is really to make sure that constitutional rights that are due to a person are being respected. And that's a weird balance, but the judiciary has overstepped so far into immigration, which is, again, matters of foreign relations are the president is the sole organ there. Congress has plenary authority to set immigration naturalization standards. So between those two entities, the judicial branch really shouldn't be making any of these decisions. I mean, I cannot figure what the Supreme Court has to say about, again, about MS-13, unless there's some finding that naming them a terrorist organization is somehow incorrect. But Congress has the authority to do this, and Marco Rubio is going through the process, or the executive has the authority to do this, and Rubio is going through the process of doing that under his delegated power. So where's the court coming in here to say, well, no, these guys can't go here?
Well, they have, so the general jurisdiction, federal district courts have a role here. It's just a very modest role because Congress took immigration away from the district courts as a subject matter jurisdiction. Congress created separate courts, immigration courts. General district trial courts don't have immigration authority. What that means is all the findings, the factual conclusions are made by the immigration courts. Are you a terrorist? Are you deportable? Do you get asylum? All these things. Those are findings made by the Article 2 immigration courts. What you can do is you can go to the federal court and say, well, that finding was never made. There's a mistake here in my deportation. I'm not a member of TDA, so I don't fall within the scope of the Alien Enemies Act. I'm actually a U.S. citizen. I'm not deportable in this way. So you can have the federal district court just look at the record and say, well, was a finding of deportation made? But if it was, that's it. It's over. The federal district court doesn't get to redo the finding. They just get to verify that there's not some miscarriage of justice happening here. Just like they can do habeas. That's basically what habeas is. Someone's grabbed by ICE. They're detained. They're going to be deported. They have a right, even under the Alien Enemies Act, they have a right to demand to be presented in a court, maybe not physically presented, but their case to be presented to a court and challenge the conditions of the Alien Enemies Act. Are you 14 years of age or older? Are you a Venezuelan citizen? Are you a member of TDA? Are you not a citizen of the U.S.? But if those things are true, the federal district court has nothing more to do with you. You are deported subject to the Alien Enemies Act. The habeas is only to save people from an actual error. I am an American citizen. I'm not a member of TDA. Well, then, of course, you shouldn't be deported under the Alien Enemies Act. But you'll see how few of these TDA guys demand their habeas rights because it's pointless. They are 14 or older. They are TDA. They're not American citizens. They are Venezuelan citizens. So demanding habeas, which, by the way, can be an extremely efficient process, just a few minutes of paperwork filing, it doesn't help them.
The going back to just to I guess a philosophical level about the approach here and the interplay of government organizations as well. Imagine the president is dealing with Venezuelan gang members in the United States, and he goes to the president of Venezuela and says, "Hey, we've got an issue," and the president decides to play tough on the Venezuelan president and maybe refuse to deport, for example, refuse to deport some of these guys for a while. And Venezuela really wants to bring these guys back and put them in their prison and do whatever they're going to do. Who cares? This is a matter between two heads of state, and the president negotiates it out. Now, let's say after negotiations, president gets whatever he wants out of Venezuela and agrees to the deportation of these back to Venezuela rather than to El Salvador. And the Venezuelan president agrees. Now you have two heads of state making a subsequent agreement, right? We're all in good territory. Now Trump goes to fulfill his end and deport these guys back to Venezuela. And it's a matter of executive concern with another head of state. And some asshole judge somewhere in the country just says no to the president and now has interfered directly in foreign relations. Speaking of non-foreign relations, hey man, how's it going?
Great. How are you? Let me make this. I'm trying to figure out how to do this.
If you're trying to figure out how to stream your own,
yeah, I'm doing this wrong. I'm doing that wrong.
You're doing everything wrong, Joe.
I'm doing everything wrong. Because I'm in the middle of my own stream and I was sniping you, and now I tried switching over. If I share StreamYard, that's not going to be good. I should just show your stream in YouTube regular.
Yeah, if you I don't think you can merge into your existing stream from here.
Yeah, I think I need to go into YouTube, watch one of your channels, and then just bring that up on my own screen.
Maybe.
Yeah, that's part of it. The question is who? Do I go to you? Do I go to Andrew or Nick? Andrew or Nick?
I want one more viewer from you, please.
Yeah,
Joe,
Nick needs the views. Nick needs.
Joe, every time I travel, I send you a picture. I know your people are watching me already.
He does. The same. I'm convinced it's the same picture. Every time he goes anywhere, this is true. Anytime he goes anywhere, he invariably will send me a picture of some Hasidic Jews and claims that my folks are following him around.
They're always there. It's always like a group of them just off to the side of the frame. It's like, what are they doing there? How'd they get here first?
Yeah.
You always know where I'm going.
Yeah.
Oh my God.
Yeah. Anyway, yeah. So I'm getting very confused watching myself my own stream. I brought up Nick's stream basically as if it's on my own and using that to block the whole whatever. Hopefully this works. Anyway, how you guys doing? I hear you talking about you're talking about Kareem Garcia.
Yeah, Kilmar, Armando,
Kilmar,
Abrego,
Kareem-
Garcia.
Kilmar Abrego Garcia. Yes.
Maryland
Yes.
man. He's so multifaceted. Maryland man, wife abuser, human trafficker, terrorist. Is there anything that Abrego Garcia cannot do?
Oh, he is quite the man of many talents. Many talents. He's able to move lots of people at the same time in a van. He's able to do that too. Don't forget.
Did I see a picture of this guy? And he like, I swear I saw a picture of him. He looks like a guy in like a construction vest. He looks,
yeah.
He doesn't like, he's not 800 pounds of jacked muscle with face tattoos all over the place, right? He looks kind of more normal.
Yeah, he does look relatively normal. But he was arrested in Tennessee in 2022. Well, not arrested. He was pulled over by cops who were suspecting that he was literally caught in the middle of engaging in human trafficking.
Listen, it was
the Biden DOJ said, let him go. They were like, we think he's human trafficking right now. And he's like, and they're like, he called up the FBI and they're like, what do we do with this? We're Tennessee state troopers. We don't know what to do with this. And they held him there for like 45 minutes while they worked the back end. And Biden's like, let him go. Let him go. Just let him go.
We don't know it was human trafficking. I mean, he was just driving between Texas and Maryland with 8 people in his car of apparent Mexican descent, and he didn't know any of their names. He's driving with 8 people he doesn't know. What are these people's names?
None of you have been on a road trip with your Mexican best friend's family, I guess. No, my point in that is like, I like how the media is like, oh no, look at this guy. Does this look like a gang member? It's like, guys that look like that cut people's faces off. Like, yes, he looks like a gang member because gang members could look like anything. You can't have every single person look like they just came out of 3 prisons at the same time. Like some of the guys have to look normal to do drug deals or to drive people, in a car across state lines for whatever purpose. But it's always how they look. And look at this picture in this photo. It's like, oh yeah, a photo of the guy with his kids. Well, yes, he's not lighting someone's feet on fire with a butane torch right now, but he's still a bad person some of the time.
So here's a funny thing. My thumbnail guy was making thumbnails for me. Every time I did an MS-13 story, there'd be a dude in the thumbnail who had the whole face tattoo, neck tattoo thing going on. And last week, my thumbnail guy calls me and says, hey, ChatGPT will no longer generate Hispanic-looking men with face tattoos.
I wonder if you can do like white-looking men with face tattoos and then just say, now give them a tan.
Oh, it was so funny. It was like, it will not do Latin-appearing muscular men with face tattoos. That was it's like, what? This isn't a gay bar in Havana.
I don't know, man, who would not do Latin-appearing muscular men. Here we go.
Do you have any idea what time they're supposed to be getting back and if there's actually going to be testimony later?
No, I watched from when court started this morning and they didn't say anything about when they would get back.
Mm-hmm. No, I was just catching up on that. I had a Verizon issue, so I started like at 10:30 and saw that there was no testimony at all. They just went, they just told the jury that we're going on The View, and I was like, I hope Whoopi and Joy Behar aren't there, and and then they just packed on out of there. A lot of people forget that in the Murdoch trial, it was when they went for a viewing. They went for a viewing in the Murdoch trial, and that was one of the occasions. There was all these issues that came out after the trial had concluded. There was all these different issues related to the clerk who was in the middle of writing her own book about the guilt of Alex Murdoch, who was basically interacting with them on that viewing. So when they have that swearing in of the bailiffs before they go down there and bring them down there, we'll make it like it's a joke and like, okay, fine, everyone's swearing. I mean, the people just saying what they're saying, but there actually is potentially issues that can and have arisen in the past, certainly in other jurisdictions, if not in this one. And the fact that they're making an oath about it actually could have repercussions if they end up violating that oath. So in that sense, those pro forma activities they undertake are actually have some sort of level of significance.
Hey guys, so my feed from the courtroom, the ceiling fan had turned off and it just turned back on again. So maybe something will happen imminently. Who knows?
So I have to do the worst thing ever. Actually, it's not the worst thing ever. I'm just annoyed because I was late to the stream and it had tech issues. My Lady Rackets is out right now, and I have to drive one of my kids to an activity real quick. I'll be back as fast as possible. It's about 15-minute round trip. So I'll be back in just a minute. Joe, it's great to see you, brother. I hope to see you a lot more really soon.
Indeed. Awesome. Great seeing you.
See you guys in a sec.
All right. Doesn't he look like way healthier now? This is so good. I'm loving watching. I watched the two of you a couple of times, and he looks like much better. He
looks better than this.
Yeah, a lot better.
Yeah,
I lost.
Keep my fat, beautiful body on screen. No, I'm just kidding.
So how?
Hey, now that Joe's here, I would just like to remind everyone. Go open up another window. Make sure you have Joe's YouTube channel open too, and subscribe. That's why we're here, folks, because we live off of subscriptions. They are tasty. I'm getting close to 200,000. Pop it up right there. I'm only 1,906 away from 200,000, and at 200,000, I will do a live no tie based AF live stream for all of you in appreciation. So go to if you're watching on Nick's channels, you should do that. But open up another window, go to lawofselfdefense.com on YouTube, hit that subscribe button like it is John O'Keefe, and you are a drunk ass Karen Reed driving a Lexus in a Boston blizzard, and then do the same with Joe's channel. Where can they find you, Joe?
At Good Logic. I'm on YouTube. I'm on Rumble. I'm even at goodlogic.locals.com. Spelled LAWGIC. It's like logic. Get it? See, Good Logic. And there you go. And you can find me on X. You can find me at The Following Pro, just to be difficult. That's what that. Yeah. You have a similar thing where you have Law of Self-Defense some places and The Law of Self-Defense others. So like every time I'm like, wait, which one is it over here?
So when I got on Twitter, which was 12 years ago now, when I started my Twitter account, they wouldn't let me use the word "of" in Law of Self-Defense. So on Twitter, it's just Law Self-Defense. I don't know why. I've looked at it since, and now if I wanted to create that handle, I could. Law of
I think you can change it. I changed.
Can you?
I used to have Good Logic. What ended up happening with me was I had Good Logic on X, and then there was all sorts of family issues because basically no one in my personal circle of people was supposed to be able to know what I do for a living, because that would be bad from societally. So I ended up, and my wife wanted me to just kill X altogether. She's like, you said so many things on X that I'm embarrassed. No, it wasn't even a matter that she was embarrassed. It's a matter of at the time my kids were looking to get married, and it was impacting them. It was in my social circles, like how the parents are and who they are is a big deal. And people would do research on me, and basically they'd be like, no, I'm not dating that guy's kid. I'm not having my kid date that guy's kid. And it bothered my wife. And I was like, all right, well, they're losers. They're idiots. I don't care. But my wife was freaked about this. She was really outraged, and she wanted me to shut down X altogether. So I ended up saying, okay, this is what I'll do. Since the name Good Logic is associated with me, on X, I'll change the name to @TheFollowingPro. The upside of this, as why I'm telling you this now, is I ended up changing that same account, didn't lose any account holders. I just changed it from what it was from Good Logic to @TheFollowingPro, which I picked that because I have my show at night called The Following Program, where I have my nightly live stream. So the following program didn't fit. So it's just The Following Pro. And yeah, but I recommend to you definitely should grab that before someone else.
So I just tried to change it. And when I add "of" it, I go over the 15 character limit for a username.
Oh, that's the problem.
Yeah.
That's the problem. Okay, that makes sense.
Here's a super chat, a generous one to me, $20. Thank you, Robert Norwood. Said this is a general thank you for everyone. Just keep sending the money here. You can thank everyone, verbally. These trial streams giving me plenty to listen to while I'm working for the foreseeable future. Yeah, I'm also working for this foreseeable future, by the way. I had my last kid at 50. I'll be working forever.
It's no joke what you're saying, by the way, as far as these trials, that the reason I stream these trials is not for the views or for the super chats. It's purely for my own channel's viability, because YouTube hates me and invariably will pull 20 to 40 people away from my channel, unsubscribe them every single day. And it's impossible for that to be organic. That never happens. But to any channel, unless they're literally, and people tell me they get unsubscribed all the time. So I was at 102,500, and just after the last trial I did, and then since then I've been slowly drifting away till now I'm barely over 100,000. I've lost over 2,000 subs since that trial, and that was the Alec Baldwin case. And I never grow. I just lose and lose and lose, and then I'll have a trial and I go back up. So the only reason I do these trials is literally so I have a channel, because if I don't do a trial like this one, it's like my channel ultimately will just wither away in atrophy into being nothing. It's ridiculous.
If I were you, I would blame the Jews.
I do. It is. It's all the Jews' fault. It's yeah. So I'm not asking for money, but I am asking for your subscription. So
that's why we're here, folks. That's why we're here. Let's see. I keep going up. It's very slow. I have to say, it's not quick, but it goes up a little bit at a time. We just hit 100,000 in New Year's Eve.
Wow, that's great.
I was stuck at like 50,000 for like a decade. It wasn't going anywhere.
No, dude, you should have 1 million.
That's my goal. A million. That's what we're looking for. So I'm 19.8% of the way there right now. Steakus, $5 says, have you considered Chattanooga for your Tennessee move? My brother lived there for a few years and he loves it. We've considered Nashville, not the city, but the suburbs, Brentwood and Franklin, south of the city, and Knoxville. We haven't looked closely at Chattanooga yet. There's certain attractions. Well, I have 2 young kids who are in school. So the most important thing to us is the quality of the school we can get them. And we found some really good ones in the Nashville area. So that's definitely possible. Knoxville, we're not sure yet. We have to go visit schools there. I'll take a look at Chattanooga. And there's advantages to living, in a wealthy suburb of a large city. There's a big airport right there. There's nice restaurants to go to. You're not actually in the city, so you don't have to deal with all that nonsense. So it's probably 90% chance it'll be Brentwood or Franklin outside of Nashville. But we're not committed. We have another year, so we'll be moving in about a year.
A lot of Jews moving there also. You can move in with Ben Shapiro.
He went to Florida, I think.
Oh, did he?
Daily Wire went to Nashville, but I think Ben himself went to Florida.
Oh,
I hear there may be a Jew or two in Florida too.
there may be. It's possible.
I think for Ben, it's like, well, your situation is much the same. He wants a substantial Jewish community for his family to live in.
Yeah. You need to have. The reason why we tend to congregate into communities, Orthodox Jews specifically, not irreligious Jews, they'll go anywhere, is because for religious reasons, we need to have like 10 men for prayer 3 times a day. And that means you need to have much more than 10 men, because not everyone's going to be coming at the same time. So you need to be living in groups of hundreds, if not thousands, if you want to be able to have that and have a normal schedule. And plus, you don't have to get kosher food and have that brought into you. You need to have enough of a community that's commercially viable, that you can have food there. So these smaller communities, they'll get like shipments of food every once in a while, but it's a much different lifestyle than what if you're living in New York. You're used to there's so much of a Orthodox Jewish network here that anything that you might need, you can find. Outside of that, you move to smaller areas, it becomes more and more difficult. So that's why we tend to congregate together, because it's necessary for religious reasons. But, yeah. All
right, here's a super chat. I think from earlier, Nick and I were talking about computers. Oh, no, Nick addressed that one. I clicked the wrong thing. Of course, I clicked the wrong thing. Misogyny and Mac worship. Misogyny Misogyny? There's no misogyny. What are you talking about? There's no misogyny here. You're crazy.
Powered by Charles. Full custody, women's shelters, child's tax, OnlyFans, Sims, not drafted, shorter jail sentence, favorable court rulings, and vast community support. Yeah, it's much harder to be a woman. You have to deal with all of those headaches. All of those headaches. That's great. That's really great.
Using a Mac is like bowling with bumpers. Yeah, okay. I don't want my computer to be hard for me. I want to focus my energies on things that make me money, not fighting with my computer. Let's see. Here's one. Parathion, $5. During the first trial, Jeff from Legal Vices always referred to the ceiling fan. They're talking about this ceiling fan from the Karen Reed courtroom, where they pan the camera by default when they want it off of things. He referred to the ceiling fan as Ceiling Dion. So we should keep the tradition alive. Rip Lorex. Indeed, I miss Jeff terribly. Great guy.
We all do. He was amazing.
Let's see if there's anything else. Most of these. Oh, here's one. Where am I getting so many? Not Cupcakes, $20. Thank you very much. The most cringe text messages are yet to come. Wait until ATF agent Brian Higgins testifies. He was trying to bang Karen. His texts make me want to hand in my man card. In all fairness, she did reach out to him. Of course she did. Come on, we all know Karen Reed.
Yeah, she did. You were watching yesterday, obviously.
Yeah.
That text exchange. Oh my God. I was sitting there and I was just like, this is a conversation every man has had where they're like, all right, just leave me alone. Stop pestering me.
Who is your
Stop
next
calling.
witness?
Your Honor, the call will call Dr. Gary Fowler to the stand.
Thank you.
We're back. We're back.
I got my own thing here.
Dr. Fowler, his expertise is like blood analysis stuff. He's probably going to give blood alcohol analysis
You
of
solemnly
Karen
swear
Reed.
that the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Sure. Witness number
Good morning,
9.
doctor.
Good morning. Good morning, Lorna.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Good morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
My name is Dr. Gary Fowler, F as in Frank, A-L-L-E-R.
And what is your occupation?
I am a physician pathologist.
And where do you work?
I work currently at Signature Healthcare in Brockton.
And how long have you worked at Signature and in what capacity, sir?
Signature, I started, it's probably 6 months. I took a new job 6 months ago. I am the chief of pathology and the laboratory medical director at Signature.
And where did you work prior to your work at Signature about 6 months ago?
Prior to that, I was at Good Samaritan Medical Center in the same capacity.
And how long did you work at Good Samaritan for?
Since 2015, late 2015.
And did you work in any capacity similar to that prior to working at Good Samaritan?
Prior to Good Samaritan, I worked at the Kearney Hospital, which is in Dorchester. Started that job in 1996. So I stayed on staff at Kearney Hospital up until actually closed 6 months ago. So I've been on staff at Kearney's for quite a long time.
Where did you go to school and what degrees did you receive?
I went to college at Tufts University in Medford, graduated in '87. From there, I went to Tufts Medical School and graduated in 1991.
And following your graduation, where did you go from there?
After medical school, I did a residency at Tufts Medical Center in 1991 to 1996.
And then where did you go following your residency?
And right
So
from
this
there,
is
I
actually the
I
first
stepped
appearance
into
of
the
Prosecutor
County
Lally,
Hospital,
Adam
which
Lally, in this trial so
previously
far.
mentioned, so 1996.
And doctor, are you board certified?
I am board certified in anatomic pathology and clinical pathology.
And what is a board certification?
Board certification is something we need to show that we are actually qualified to perform our the job that we need to do, both in anatomic and clinical pathology. It's a written exam that we take and we need to pass to demonstrate that we're competent and know what we're doing.
First, in just general terms, if you could explain to the jury what is pathology?
Pathology is, well, there are two basic branches of pathology: anatomic pathology and clinical pathology. Anatomic pathology is basically, an anatomic pathologist is a physician or MD or a DO trained to make diagnoses on patients via looking at tissue biopsies, organs, tissue fluids, and we're also trained in autopsy pathology as well. So basically, an anatomic pathologist, we look at tissues via glass slides. Slides are made, and we every day make the diagnosis of, somebody has a cancer or somebody doesn't have a cancer, benign. Look at colon polyps, breast biopsies, pretty much anything that comes out of the operating room or a physician's office, any sort of biopsy. Clinical pathology, on the other hand, is basically a clinical pathologist is a physician, an MD or a DO, who specializes in the clinical lab, which basically is any fluid specimen, including blood specimens. When you go to the hospital and you have your blood test and it gets sent to the lab, the clinical pathologist is ultimately responsible for the quality of your lab tests and quality, and basically that's it.
And so the time that you worked at Good Samaritan, did that cover the date of January 29th, 2022?
Yes.
And again, what was your title and what was your job at Good Samaritan in the month of January 2022?
I was the chief of pathology at the time and laboratory medical director.
What did you do as the laboratory medical director?
Laboratory medical director, basically, the laboratory medical director is responsible for the ultimate quality of any, either whether it's a biopsy, somebody's biopsy, or lab result. The laboratory medical director has to make sure that the final result is of excellent quality. So there are many different things that we need to make sure that things that are in place, as far as need to make sure we have the correct amount of workers. You want to have enough workers. You want to make sure they're competent. So as many, there are policies for competency for all the lab techs and phlebotomists and even pathologists. So basically, the laboratory medical director, if something goes wrong, it's ultimately his or her fault.
And the lab at Good Samaritan, is that lab accredited?
Yes, it is.
And by what body?
We are accredited, or Good Samaritan is accredited by the, we call it the CAP. It's a College of American Pathologists. They are considered the preeminent accrediting body for hospitals. They've been around for probably 70 plus years or so.
What is accreditation? What does that mean?
Accreditation is basically something that says that your laboratory is following guidelines and providing excellent quality. To be accredited with the CAP, every 2 years, we have a laboratory inspection. They don't tell you when they're coming. They will give you a 3-month window, and they'll come and inspect you to make sure we have a good quality lab. Each section of the lab, pathology, the clinical lab, microbiology, chemistry, hematology. The CAP has a checklist with numerous requirements that one needs to fulfill. There are probably over 3,000 items that they look at.
And was your laboratory at Good Samaritan, was the accreditation up to date on January 29th, 2022?
We were accredited, still are.
Now, in Good Samaritan Medical Center,
Does the microphone have to be in his nostril? Is that a requirement of the court?
Lab testing for.
Did you get this guy's name?
I think the most common test
Gary Fowler, F-A-L-L-E-R.
Performed when you go and you have your blood tests is one is chemistry, a chemistry test where we sodium, potassium, chloride, glucose. We also a common test is a CBC or a complete blood count, where we look at your red blood cells and your white blood cells and your platelets. Those are the two most common tests.
And why is blood testing ordered in the course of medical treatment at a hospital?
When you're admitted to the hospital, usually you're sick, so the physician is usually a standard, ordering chemistry and CBC to see if there are any clues in those tests that could help the doctor take care of you. If they look at a BUN and creatinine, maybe if they're elevated, you either could it be dehydrated or have renal failure. If you look at liver function tests, maybe there's something wrong with your liver. So it's just a general, a good look at the patients to see if there are any clues that could help them.
And as far as the blood testing results are concerned, how does that assist either a doctor or a clinician in treatment and diagnosis?
Basically, what I just said. If there's nothing, if the results,
they should have a button like they have for Netflix when you're watching a series and you can skip the intro. Right? Just go right into the show.
Just stipulate.
Look
Just
at the
stipulate it out.
hemoglobin and it's low and patient's anemic. Maybe the patient might need a transfusion. So there are many different case scenarios where the results can help the provider, the clinician.
Now, with reference to alcohol, does the Good Samaritan Medical Center, do they also test alcohol within the blood?
Yes, we do.
And why would that assist medical treatment and diagnosis?
I think if a physician is wanting to know if somebody's been drinking or has alcohol on board, or maybe not, maybe that patient has ingested maybe drugs of abuse. So they'll test for alcohol to see, one, if it's positive. And if it is, then it helps confirm that the patient has been drinking.
Now, are there any policies and protocols at Good Samaritan Medical Center with reference to how blood is taken and how blood is tested?
He really is a heavy breather.
Yes, we have numerous policies. We have one policy specifically for phlebotomists. Those are laboratory technicians who draw the blood. So we have a policy for them to explain exactly what they need to do. And also in the laboratory, we have numerous policies basically for any tests that we provide. And so we have a policy for alcohol testing as well.
May I approach the witness, Your Honor?
I have looked at North Idaho, but we need good schools for the kids. They're hard to find in Idaho.
Just ask you to review those generally when you're finished. And do you recognize what those are, sir?
Yes.
And can you explain to the jury what is contained within each of those two sets of documents?
Okay. The first one is a patient preparation for specimen collection. This is the policy that I was mentioning, specifically designed for our phlebotomist to detail the procedure of the blood draw. Basically goes through one of the most important parts of the process is correct patient identification, where we need to correctly identify the patient. We have the patient state his or her first and last name and state it out loud to make sure it matches which the patient that we're trying to draw. And then we also match up the bracelet to the medical record number on the patient's bracelet. So one of the most important things is correct patient identification. The rest of this policy goes on and just pretty much details what to do next, including finding the veins, cleaning the site. It has some information on if there are any complications. So it's basically the entire process of the blood draw. The second one is our alcohol policy, which pretty much details in detail what goes on behind the scenes for an alcohol blood test in our hospital.
May I approach again, Your Honor?
Yes.
Your Honor, Commonwealth will seek to introduce in the minutes the next two exhibits.
All right, thank you.
Your Honor, for the record, it would be the patient preparation for specimen collection, the next exhibit in line.
All right. Exhibit 35.
Submitted as
And
exhibits.
the ETOH policy would be the next exhibit number 37.
Exhibit 36.
Excuse me.
That's-
Thank you. Now, doctor, what types of precautions are in place at Good Samaritan with respect specifically to alcohol testing in the blood? Or I should say taking the blood sample from the patient.
Yes, one of the major things we need to do with taking somebody's blood for alcohol is to obviously not use an alcohol swab. Normally, when you have your blood test, they cleanse the area with a swab that contains alcohol. So in our policy is a specific statement that says, do not use alcohol swab because potentially when you're drawing the blood, if you suck up some of that residual alcohol, you could
And everyone's
cause
drunk.
a false positive. So we have in our policy, and it's every hospital should have the same policy where we use a swab, a swab that has no
That
alcohol.
person in the background looks like
We
the
call
Secret
them,
Service agent from
a
Trump's
moist
assassination.
towelette. That's what we refer them to.
She lost some weight.
Also, in the emergency room,
Not much,
my
but a little bit.
supervisor pretty much removed probably 95% of all the alcohol swabs. So just in case a phlebotomist forgets to not use an alcohol swab, they are hard to find. We need to keep a few there because we need to use alcohol wipes on certain tests like blood cultures and stuff like that. So
When were the alcohol swabs removed from the emergency department?
it was before my time.
So fair to
Not
say
sure.
prior to January 29th, 2022?
Correct.
What is a phlebotomist and what do they do?
So a phlebotomist is a healthcare professional who specializes in drawing blood. So they're the ones who are trained,
That's not what I would have guessed.
and know what to do when they draw a patient's blood.
What kind of
Imagine
training
this
do
guy's leather
phlebotomists
chest
receive at Good Samaritan?
bondage gear he wears at parties. It's
When
like,
I hear from
We try to
phlebotomists.
hire phlebotomists who have been trained. It's just easier. So they can have a high school background. But if we train on site, they just need to be trained on, the proper protocol, proper procedures, and demonstrate competency.
Is there any sort of proficiency testing related to phlebotomist at Good Samaritan?
There's no proficiency testing for phlebotomists, but there's competency assessments. So with phlebotomists or any laboratory technician or even pathologists, there are strict guidelines for competency. We have to always make sure people know what they're doing. And it's a CLIA or a federal government regulation or requirement. So when anybody first starts in a hospital, the requirements are, one, initial training. You can't let anybody come in on their, without not knowing what they're doing. So we have to document that they have the initial training and they're competent. And then the law says 6 months from that, we do another competency assessment where we look at 6 elements of competency defined by CLIA, and 6 months from that, 1 year from the start date, is another competency, and then after that, it's annual thereafter. And that goes for phlebotomists, and it goes for any laboratory technician.
Doctor, once the blood is drawn by the phlebotomist, what happens then?
So the phlebotomist will draw it at the time. They need to have the specimens labeled in the patient's room, because you don't want the phlebotomist to mislabel. So everything gets labeled at the patient's bedside with an initialed and with a phlebotomist's initial and date and time. That blood test will then be sent to the lab. In this case, the blood was drawn in the emergency room. So it gets packaged into a plastic bag and sent in a tube up to the laboratory.
And once it's sent to the laboratory, what happens with the sample from there?
Once we receive it, it's called receiving the specimen. There will be a technician who then goes into the computer, enters the phlebotomist's name from the tube into the computer system, enters the time, and the technologist will look and see what was ordered, and then do the appropriate next step based on what was ordered.
And in a case in which alcohol is one of the items that are ordered, what is the next step as far as the testing goes?
So the next step with alcohol testing, we use a specific tube, so the phlebotomist would know what tube to use. It would be a light green tube that
it's
has
just a logo.
lithium heparin in it.
Yeah, hey, what's up, guys?
We don't want the blood to clot.
Sorry, Nick, didn't know what that was.
So that's why we use an anticoagulant. So the first step when testing for alcohol is that the test is designed to be performed on serum or plasma. And to get that, the next step would be to centrifuge the blood. The centrifuge is
background noise, Nick.
Yeah, we're getting feedback.
Oh, okay. I'll mute. Hold on.
Spin it at around 3,300 RPMs, which is
I'll mute unless I'm going to talk.
Rotations per minute. And the reason why we spin it, because centrifugation will allow it to separate the blood components based on the density. So heavier stuff like the red blood cells will go to the bottom, and the lighter stuff like the watery component of the blood will go to the top, and some of the white cells go into the middle. But for alcohol testing, we are targeting the top part of the blood component, which would be plasma.
And then once it goes through the centrifuge process, what happens then?
So once it's centrifuged, we have the separation of the blood components. We have the plasma ready to be tested, so that technologists will walk the specimen over. It's probably 10 feet from there, and put it onto our Roche Cobas machine. That's our machine that performs our chemistries as well as alcohol testing. It goes onto a machine. All the testing is basically inside of a black box. And the label present on the blood tube will dictate what the Roche machine will test. So based on the barcode label, once it's on our machine,
Roche, a good German company.
knows what test to do, and it will
Roche
perform
Diagnostics.
an alcohol test.
And Doctor, for our stenographer, do you know how to spell that Roche Cobas machine that you were just referencing?
So ROCHE, Roche, and Cobas, COBAS.
Thank you, sir. May I approach, Ron?
Yes.
A lot of times they want to go through the qualifications the guy has extensively, so the jury has more trust for them, even if they want to.
I trust this guy's qualifications just because of how bored I am listening to him.
Do you recognize those records, sir?
Yes.
And what do you recognize those to be?
These are the medical records of Karen Reed.
And sir, is there an indication within those records as far as the date of treatment for Miss Reed?
Yes, there's a bunch of dates in here.
As far as the treatment is concerned, sir?
Yes.
And what is the date of treatment?
Oh, 1/9/22.
Sorry, is that 29/22?
That's what it says on this.
Should have gotten it in Braille. Rookie mistake.
What's he doing?
Admit date, it says 1/29/22.
Hey, law self-defense members, I'm starting to put your comments at the bottom of the screen.
If I could direct your attention further into the document to a previously tabbed portion, do you see any indication in there as far as a result for alcohol testing?
What the hell?
Like, I know the guy
Sorry.
just needs, I don't know what he's. It's always funny when like a tech guy gets on the stand, does something weird, like punches over the reading like that.
Result, have you reviewed these records prior to today?
Yes, I did.
Yes, I did.
And if you
Looks like a
could,
mad scientist.
Explain to the jury sort of the timeline from this blood sample as far as, let's start with first when it was ordered.
So when it was ordered, it was 9:03 in the morning.
And when was it taken, sir?
The blood test was taken 5 minutes later, so 9:08.
And then what happened, or what is the next time that something of any significance happened with it?
5 minutes from that, 9:13, we received it, and 9:53 in the morning, the result was entered into the computer. So it was ordered at 9:03, and I believe it was 9:53. The results were in the computer.
And may I approach again, Your Honor?
Yes.
I'm about to seek to introduce and admit as the next exhibit.
Any objection, Ms. Little? Objection. All right, thank you.
Oh, I guess Little will do the cross then. That'll be nice. We haven't seen her yet.
On cross, sir, what percentage of blood samples go missing on a daily basis while you're taking them in?
How many do you personally consume?
Doctor, what was the result of the testing for alcohol in the defendant's blood when it was taken shortly after 9 a.m. on January 29th?
When I drank it, I got drunk.
Milligrams per deciliter.
Thank you, sir. Nothing further, Your Honor.
Okay. Ms. Little?
So we're just here for the
I'm
report?
going to pause it for a second because Nick managed to talk over the blood
Nothing
alcohol
further.
level.
Per deciliter.
On January 29th.
93 milligrams per deciliter.
Okay, there we go.
Nothing further, Your Honor.
Okay. Ms. Little?
Little. Come on, baby. She got her nails done today.
Does that mean anything to you?
Good
93
afternoon,
milligrams?
Dr. Fowler.
Oh, good afternoon.
They'll
The
translate
Good
it.
Samaritan lab is a clinical
That
lab,
should be on direct.
not a forensic lab. Is that right?
Correct.
And hospitals are not in the legal business of calculating an individual's blood alcohol concentration. Is that right?
I would say 99.9% of the time we are not in the legal business. We are testing alcohol for the diagnosis of alcohol intoxication. But occasionally a case may come, very rare, to a hospital and it ends up being a legal case. It's not common, I think uncommon.
And you'd agree that there are different
Did you say I think I'm common?
tests that are conducted in hospitals and forensic
uncommon.
tests that are conducted by law
Ram.
enforcement, right?
Yes.
The purpose of testing in a clinical setting is to assist in the diagnosis and treatment of a patient, right?
Correct.
And physicians need to analyze blood quickly. They need to get the results so they can see what's in a patient's system and then effectively and efficiently treat that patient, right?
Correct.
Whereas in a forensic setting, tests for blood alcohol concentration are designed to produce results that are reliable and credible for use in court. Correct?
Correct.
You testified earlier today that your lab is accredited by CAP, which is the College of American Pathologists. Do you recall that testimony?
Yes, I do.
But CAP is a clinical laboratory accreditation, not a forensic accreditation, right?
We don't have the forensic accreditation for Good Samaritan.
In fact, Good Samaritan has never been investigated or accredited by any forensic accreditation team to ensure that you perform all of your tests with the integrity necessary to support results in court, right?
We've never had the forensic accreditation, but we have very good quality lab results, which I could go into further.
No.
But you've never been accredited by a forensic accreditation team, right?
No.
And the lab at Good Samaritan has never been accredited by the ANSI, which is the National Accreditation Board known as ANAB. Are you familiar with that organization?
No.
Are you aware that ANAB is the forensic accreditation body that in the United States that ensures that laboratories' procedures meet the minimum standards necessary to ensure results are reliable and credible for use in court?
Sustained.
Now, the
Assumes
most
facts, not
reliable
evidence.
method of forensic ethanol
What
testing
was-
is called headspace
what was the objection?
gas from
I think
HSGC.
assumes facts,
Are you
not
familiar
evidence.
with that process?
She just asked if he was aware of that.
And HSGC is the method that's used by forensic labs to test
Would you
for
agree
blood
or
alcohol,
disagree?
right?
Correct.
And that's because forensic tests require the testing of whole blood for the presence of alcohol, right?
Correct.
Can you briefly, just for the jury, describe sort of the difference between a whole blood test and a serum test?
Sure. So whole blood, to put it simply, when you have your blood drawn, you see the fluid coming out all red.
Delicious.
That's whole blood. We don't do anything to it. We don't spin it down. We don't centrifuge it. That is whole blood. That is the specimen of choice for forensic blood ethanol testing.
Specimen of
Hospitals,
choice.
on the other hand, our methodology, which is just as good as the forensic headspace gas chromatography, is based on looking at the serum or the plasma. So we don't, that's what I went when I explained that we need to centrifuge it, take the liquid portion off the top. So in the hospital, we test it on the serum or the plasma. Now, did you ask me the difference? You want me to go into the difference?
That's enough, doctor. Thank
Okay,
you.
all
I'll
right.
ask some additional questions
Okay.
to kind of clarify. And in a forensic lab, they actually require the testing of whole blood, correct?
Correct.
And HSGC directly measures ethanol in the blood.
Correct.
And this method is designed to be accurate and reliable for forensic purposes for use in legal proceedings, correct?
Correct.
But the testing in this case was performed using the hospital's clinical chemistry machine instead of a forensically defensible method like HSGC, right?
Correct.
You did your test in your kids' 10th
And
grade
that clinical
kids.
chemistry machine
home lab.
performs what you just testified to, a serum test, right?
Serum or plasma.
Serum or plasma. And hospitals use serum or plasma testing because it's actually quicker and more efficient than HSGC, right?
Yes, it's less labor intensive. It's easy to automate, but at the same time, very, very good and very accurate.
It's good though.
Serum testing does not actually measure alcohol directly. It instead measures the presence of what's called NADH, right? Yes, I'll repeat that. That was my fault. Serum testing does not actually measure alcohol directly. Instead, it measures the presence of NADH. Is that right?
Almost.
Well, NADH is a byproduct of alcohol, right?
Correct. I can go into the testing how methodology that we use to explain it if you want me to.
Well, serum testing measures the presence of NADH, correct?
It measures the rate of change of NADH production, so it doesn't actually look at just NADH, and it measures the rate of production, and I can go into more detail on that. Alcohol testing in the lab is correct.
I'll ask you some additional
Okay,
questions
sure.
about NADH and we'll
Sure.
get there.
Yeah.
You'll get there, buddy. Calm down.
You can do
Take
this
it
now,
slow.
but let the doctor answer his question fully. Next question, okay? And the following question.
Doctor,
But he did
higher
answer the question.
NADH in a patient's system, the higher the serum test result, correct?
That may not be correct, no. It's the rate of change of NADH production based on our methodology. I can go into that. So our test system is a little bit different than the forensic testing system, but it's also very good and very accurate.
He's not actually going into it.
When we compare our methodology to the Headspace, we get the exact same results, and when we compare and with peer laboratory comparisons. But what we do is and I think the jury needs to know this. Maybe some of you might.
How long does he get to just exposit?
Behind it. But we do. We take the patient's sample, and it's based on. We add.
Can you adjust Nick's volume down a little bit?
Because
I don't know. Can I?
When there's alcohol in the specimen.
I'll be back on camera in just a couple minutes.
Test system, alcohol dehydrogenase is the same enzyme that's in the patient's body. In addition, we add a surplus of NAD to it. NAD is similar to NADH. They get converted back and forth. So when we put it on our test system.
Thanks, Joe.
It's alcohol dehydrogenase is in there. And what happens is when there's alcohol, it combines with NAD that we add to it. It creates NADH. And then in our machine, there's a spectrophotometer, which can monitor the rate of NADH production over baseline. And we use, there's something that measures a photometer that measures the NADH production. It looks at light in this physics and looks at 340 nanometers. And it's pretty accurate. It will monitor, it will tell you, give you tell the system how much NADH is produced. And that amount is directly proportional to the alcohol in the patient sample. So it's a very, very accurate test, but there are some limitations that I can go into.
So wait for another question.
Okay.
Pretty accurate. Doesn't sound like reason.
Serum testing can be subject to errors, right? Subject to errors, right? And there are limitations.
There are some limitations that I can explain, just like headspace gas chromatography may have some limitations too. But
Jurors don't know
go into that.
what spectrometry is.
What are some of the limitations of the serum testing?
Okay. So the serum test, as with many tests in the laboratory, different things can interfere with our laboratory tests. And the three most common ones, which are unlikely to affect ethanol testing, is we abbreviated HIL. We want to look at those three things. One is hemolysis, which is H, and the other one is icterus, which is high bilirubin, and the third is L for lipids. High lipids will interfere with alcohol testing or with any testing based on that same methodology. Our machine, the Rose Kobash machine, and all the machines out in the market today are very sophisticated. If we have elevated levels of any H or I or L, it will flag it and raise the potential for a problem. The next thing on the list is that our alcohol testing is not absolutely specific for ethanol. There are two possible other alcohols that can cross-react. One is propanol and butanol. But then it goes clinical history. Did the patient ingest those two alcohols?
All right, be right back down to my office.
And third is there's some unusual hematologic malignancies like Waldenstrom's macroglobulinemia that can interfere. So it's always have to correlate with the clinical situation. The next one, sometimes there can be patients who make endogenous make their own alcohol. So very rarely, some patients may truly have a positive result. That could be from our test or Headspace. They make their own, so we have to rule that out. It's a rare condition. And the next one is one that's in the literature, which is LDH and lactic acid. If a patient has a markedly elevated LDH or lactic acid, those one is an enzyme, and the other one is an acid. That can cause false positives. Now,
if I could stop you there, Doctor, I think those were the four that you identified, the four limitations: the lactic acid, the hematology.
Yeah.
If I could just
go ahead and ask your next question.
If I could ask you a few more questions about LDH and lactic acid.
Sure.
You're aware, Dr. Fowler, of the medical literature establishing that the presence of LDH and lactic acid can lead to falsely elevated serum readings, correct?
Correct.
And that's because lactic acid or LDH actually forms NADH.
Lactic acid, I'll have to go into a little bit of chemistry. Lactic acid and LDH, lactate dehydrogenase, they both act on each other. And LDH and lactic acid needs NAD plus to break it down. So in theory, when you're testing a serum, a plasma for blood alcohol, if there's extra LDH or high levels of LDH, high levels of lactic acid, you add it to the test system, and then Roche throws in, or Siemens throws in the NAD, it will form NADH. That was first documented, I think, back in the older versions of these ethanol testings back in the 1990s, when they stumbled on, they were looking for biomarkers or reasons in kids with SIDS, little babies, and they found that two of these babies had a positive alcohol. But
Doctor, if I could just ask the next question, if that's okay.
Sorry.
So in other words, NADH, studies have found, can actually be formed by certain biomechanical processes other than the presence of alcohol, right?
Yes.
Are you aware that the National Institute of Health has found that liver diseases, kidney diseases, muscle injury, trauma, and even anemia are some of the health conditions that can lead to a rise in serum LDH levels.
Yes.
Are you aware that Ms. Reed was severely anemic in January of 2022?
Sustained.
Assumes fact, not
Are
evidence.
you aware that the medical literature has also found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
I'm going to allow that.
I haven't read anything specifically related to the NADH level, but but I want to go back to the point where our laboratory, our testing is not based.
Let him finish his answer.
It's not. It's the rate of change of NADH. So if somebody has NADH on board, I believe it's not going to affect the result. It's the rate of change, and it basically, you know, back to the anemia. I haven't read or heard of that.
That was stricken. That was not allowed.
It all goes back to the lactic acid and the LDH. The NADH doesn't matter. So looking at multiple sclerosis patients, they can have elevated LDH and lactic acid, but it's not to the extent that it can interfere with the alcohol levels. There was a study, maybe
Is Nick background?
7-10 years
okay,
ago.
Your Honor, there's no question pending.
You asked him about a study, if he was aware of the studies.
I asked, and that's a yes or no question.
Yeah,
And
she's just.
All right.
The judge is just letting him ramble on these
Ask the
long
next
things
question.
without any questioning going on at all.
Doctor, have you reviewed the August
I think most of the
21st,
biochemistry
2013
conversation
peer-reviewed
goes over the
article
jury's
entitled
head.
Serum NAD through disease course in multiple sclerosis, which was sponsored by the Center of Healthy Brain Aging by the University of New South Wales? Which, sure. Doctor, have you reviewed the August 21st, 2013 peer-reviewed article entitled Serum NAD Levels through Disease Course in Multiple Sclerosis, which was sponsored by the Center for Healthy Brain Aging by the School of Psychiatry at the University of New South Wales in Sydney, Australia, which specifically found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
To what? What's the objection?
I'll strike the part of what the article held. Is he aware of the article?
No, I'm not, to be honest. No.
I think when
Dr. Fowler, did you consider Ms. Reed's anemia and multiple sclerosis condition when you conducted the alcohol test on January 29, 2022?
No, we don't. No.
And again, serum tests like the ones conducted in this case don't test for ethanol. They only test for NADH, right?
We test for the rate of change of NADH production.
And Doctor, you did a number of other tests on Ms. Reed on January 29, 2022. You tested for additional drugs, not just alcohol, correct?
Correct.
And all of those results were negative.
Correct.
Thank you. No further questions.
Okay.
When it's that technical, it's more important to look like you're winning than to actually win. Because that's what most of the jury is probably not going to understand a lot of what was just discussed. But if you look like you got some hits on him, whether or not you did is almost more important than actually getting the hit.
Doctor, are you aware?
We got them
I know
34
your lab,
nanometer
Good Samaritan did not do
spectrometry
this process, but are you aware through your training and experience of any sort of mathematical conversion that can be done from a serum reading in milligram per deciliter to a blood alcohol concentration of whole blood?
I'm going to allow it. The door was open.
By what?
Go ahead, sir.
He should have done this on direct.
Yes, I am aware. Yep.
And please describe what you're aware of with reference to that.
Well, with blood alcohol.
0.093. That's all you need to know.
Goes to,
0.093.
when it's in your blood, it goes more to the watery components of your blood. So when I described the process,
the ones that are
earlier,
removed in the
whole
plasma
blood
serum
is
testing.
before we spin it, and when we test the plasma, which is specifically testing the watery component. Now, people have done studies like how much percentage of water is a serum versus whole blood. Basically, to put it simple, there's a higher percentage of water in the serum versus whole blood. So a hospital result will always be a little bit higher than a test on whole blood. It can be, I think the ratio, the conversion factor is anywhere from 1.1 to 1.18. It's always could be 18% or 11% higher in serum versus whole blood.
But that puts her
we
below
don't
the
do
legal
it.
limit if
That's
it can
what
be
I read.
18% higher.
We'll defer that to the experts.
Now, doctor, you were referencing in your
That's kind of fucking
cross-examination
important.
about a study that you were aware of about 10 years ago or so regarding MS and alcohol testing. Is that correct?
It was more on MS, looking at the results of lactic acid and LDH to see how high the levels of lactic acid can go in a group of multiple sclerosis patients. When reviewing that, we found that the range went from some normal range, 16% of the multiple sclerosis patients had normal lactic acids, but the remainder had elevated levels. But those levels were not anywhere near the required levels to produce a false positive. Our package inserts and for the Roche testing system, the Roche has, it's an FDA approved test, and they have to do in-depth detailed testing before they allow any hospital to do a test. And they have listed levels of lactic acid beyond which the test would not be reliable. But the results based on this study of 600 multiple sclerosis patients, 2 big centers in Italy and 1 in the Netherlands, show that the highest level of lactic acid in the MS patients did not achieve, didn't get close. Usually patients with MS that are asymptomatic can have normal or low normal levels, and slightly elevated. It was the ones that had more symptoms that had elevated levels up to, I think the highest was 6.5 millimoles per deciliter, which is not high enough to interfere with our result.
Now, with respect to the lab at Good Samaritan Medical Center, the interference that you were speaking about earlier on cross-examination, what would happen if any of those types of interference were to occur during the course of the testing?
No, I'll allow it.
The 3 main ones, which I detailed earlier, is the hemolysis, icterus, and lipemia. Machines are sophisticated. It will detect it and say, it will flag it and say, please do not result it, or we'll have a disclaimer saying, interpret this result with caution. The results may not be accurate. It hardly ever happens with alcohol testing. But if it did, we would get a result like that, and we probably wouldn't report it.
And from your review of the defendant's medical
0.788,
records,
by
specifically
the
her
way.
testing from January 29th, did you notice any interference or any reports like that in her record?
No.
Now,
But she
the
could have gone
testing
home and
that you're
drank
doing
a
at
whole
Good
bottle when
Samaritan
she got
is
home.
in relation to patients such as that might have cancer or heart disease or something like that, correct?
Correct.
Now, you were talking or started to speak on cross-examination about the good quality lab results that you have from your lab, and you wanted to go into that further. Could you please expound upon that for the jury now?
We have you mentioned proficiency testing before. So all hospital laboratories accredited by the CAP or have to participate in proficiency testing. What that means is that every 3 times a year, and they give us 5 unknown samples. And we have to test it, report it back to CAP which also reports back to the government. And we have to basically get the correct answers. And with alcohol testing, it's probably one of the best tests in the laboratory. Always have right on the money results. But at the same time, we're also able to look at results of all the other labs that participated in this proficiency testing.
How much money would
So
this
we can look
comment
at
save?
different methods. We can look at labs that had the same method as us to see how we're doing. And usually with this proficiency testing, we have 3,000 labs across the nation that have the same methodology as us, so we can compare to them. And also, interestingly, we can see the labs that are using headspace gas chromatography. And out of interest, we can see, how do we compare? And we have pretty exactly the same results on these proficiency testings. We also look at some statistics as well, not going into them, but we can look at some stats like standard deviations and SDs. And actually the hospitals with enzymatic testing have slightly better stats with that compared to Headspace. Pretty close, but a little bit better.
People
Doctor,
think
from your review of the
drug and alcohol
defendant's
testing
medical
is like
records and
this
the blood testing
magic
in
button.
this case, was that done in
Just
conformity with the
it's not.
policies and protocols at Good Samaritan?
We have policies in place to be followed, and there's no reason not to think that somebody didn't follow policy.
Thank you, sir.
Anything else, Ms. Little? No questions. All right, doctor, you are all set, sir.
Oh man, she
Thank
should have
you.
gone back. An 18% higher result on a 0.093 blood alcohol content, 18% higher than the real number, comes out to a
Witness, Mr. Brown.
0.0788,
Call
which is
more
under the
calls,
legal
Jason
limit.
Becker.
Their argument is that she's over the legal limit in alcohol, with blood alcohol, but she may not be. Like they used the wrong test, a test that would not be accepted if she tried to introduce it in her own defense. Like, sorry, this doesn't rise up to the level of our forensic laboratory specifications. But when the government wants to use it, they always can.
Looks like another cop.
Do you solemnly swear that the testimony you shall give to the court and the jury in the matter now pending shall be
Dude looks like he installed his required anal rod today.
Good afternoon, sir. All right, Mr. Brennan.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please introduce yourself to the jury?
My name is Jason Becker.
How old are you?
I am 36 years old.
Do you live in the area?
I do. I live in Canton.
Tell us a little bit about your education.
My education, high school and college UMass. And I went to EMT school a little over 10 years ago and paramedic school.
Oh, that accent.
Tell me a little bit about EMT school. How old were you when you started EMT school?
This guy's eyes are more sunken than mine were.
Roughly 21 years old.
Why did you decide to go to EMT
T
school?
test this guy right now.
Wanted to save some lives.
Tell us a little bit about EMT school. What did it require?
EMT school was a couple months of classroom stuff, and then you do some ride time on the ambulance. Paramedic school is a little different. It's a little extended. 2 years worth of training. You're doing hospital, ER time, and ambulance time also.
How long did you serve as an EMT before you went to paramedic school?
I worked as an EMT for approximately 5 years.
Can you estimate how many dozens or hundreds of calls you were on during that time?
Hundreds.
Why did you decide then to go get paramedic training?
Oh, I wanted to be on the fire department, and it was a prerequisite.
Did you complete paramedic school successfully?
I did.
Were you still working as an EMT at the time?
I was.
And inevitably, did you seek to have a different job? Did you try to be a firefighter?
I wanted to be a firefighter, correct.
Were you successful in doing that?
I was.
Tell us a little bit about that, sir.
On the Canton Fire Department. So I got on the Canton Fire Department, and then they send you to the fire academy.
Look at all that suppressed anger.
So you had EMT training, paramedic training, and then firefighter training.
That's
No
correct.
lips.
On the Canton Police Department, did you serve dual roles as a paramedic and as a firefighter?
Fire department?
Yes.
Yes, sir.
department, sorry.
Yes, sir. Firefighter and as a paramedic.
You served as a firefighter and a paramedic.
Correct.
In the Canton Fire Department, does it have more than one station?
There's two.
Is there one station that's larger or smaller than the other?
Station 1 is the headquarters, which is larger.
Had you ever spent time at Station 1 as a firefighter or a paramedic?
I have. We rotate through both stations.
I want you to take us back to January 29th, 2022. Were you working that evening?
I was.
What station were you assigned to?
Canton Station 2.
Canton Fire Station 2?
Correct.
And that's the smaller of the two stations.
It is.
Were you working with anybody at Fire Station 2 that night?
My ambulance partner at the time was firefighter Dan Whitley.
Was there anybody else who was working at Fire Station 2 in addition to you and Dan Whitley?
Correct. There was an engine company with 3 guys on it.
3 people were assigned to the
The engine.
I thought he was
Correct.
just being racist when he said that.
Were you and Dan Whitley assigned as partners for the day, the week?
Correct. Yes, we were.
Which was it, the day or the week, sir?
The week.
So for the entire week, you're partners with a person, and does that rotate on other assignments?
It does. It rotates.
So on this particular week, you were assigned as partners with Dan Whitley.
I was.
What were your roles between the two of you?
Well, at the time, he was my preceptor. I was a new paramedic at the time. So I was more or less the lead tech on all the calls as part of my training. And Dan's been a paramedic for a long time. So he,
So he's the
he
top.
was there to teach me.
So would Dan Whitley be the lead on the call and he would help you?
I would be the lead.
You would be
And-
the lead.
Correct.
Did you get a call that early morning hours of January 29, 2022?
We did.
What was the call assigned for?
It was a call for Section 12 psych eval.
Very briefly, can you tell us what a Section 12 is?
Sure. It's a transportation order filled out by police, doctor, basically for us on the ambulance that we have to take the patient, whether voluntarily or involuntarily, because they're a threat to themselves or someone else.
When you received the call for a Section 12, were you aware that there were other calls that Fire Station 1 had responded to that morning?
We were aware. You can hear the calls going out each station.
Were you or Dan Whitley any part of that earlier call that Fire Station 1 responded to before you got the call for the Section 12?
We were not.
So your efforts were after?
We were after, correct.
After you got the call to respond to a Section 12, did you head towards Fairview Road?
We did.
Tell us a little bit about the trip to Fairview Road.
It was a little extended because of the weather conditions at the time. Snowing heavily, windy, low visibility.
How long did it take to get from Fire Station 2 to Fairview Road?
Approximately 8 to 10 minutes.
Who drove?
Firefighter Whitley.
Now, on the way to Fairview Road, do you sit in the front of the ambulance?
We do.
Take us to when you arrived to Fairview Road. What do you see?
You see a bunch of police lights. Canton Engine 3 was already on scene, so we parked behind them.
Did you have it, without talking about what you spoke about, did you have a chance to speak to anybody at the scene?
We briefly spoke to the Canton police, and they briefed us and sent us to where the defendant was at the time.
Why do you have a conversation with other first responders at the scene before you do anything?
They're making sure the scene is safe to begin with, and they're unseen first, so they have a little more info than what our dispatch would have.
After you had that debriefing with colleagues, were you directed to approach any certain person?
I was.
Where did you go?
I went to the defendant who was sitting in a black SUV type car.
Were there other persons inside the car with the defendant?
From my understanding, there was one person in the driver's seat.
And what seat was the defendant in?
She was in the front passenger seat.
Did you have a chance to speak to her?
I did.
She was in the
person you
murderer's
spoke
seat.
to who was in the passenger seat of that car. Do you see that person in court today?
I do.
Could you point out and describe an article of clothing, please?
Miss Reed.
It's a crazy drunk broad at the table.
Navy blue.
How long was your conversation with the defendant while she was still seated inside the vehicle?
Approximately 5 to 8 minutes.
Oh,
At some point, did you
a
and the
5.
defendant move to another location?
We did.
Where did you go?
So we went back in the ambulance.
After having a conversation with her, was she cooperative going back to the ambulance with you?
She was.
And did you ask her to be seated in the ambulance?
I did.
Was she cooperative with that as well?
She was.
After she was seated in the ambulance, did you close the doors and get in?
We did.
When you say we, who was with you?
Me and firefighter Whitley.
So you and firefighter Whitley were in the back of the ambulance with Miss Reed. Who was going to drive the ambulance?
Firefighter Sam Park.
Where did he come from?
He was on the fire engine that was already on scene.
I want to ask you questions now about what you did in the back of the ambulance and some of the conversations that you had. Tell us what your role is once you have a patient in the back of the ambulance. What do you do next?
I mean, each patient's different. Depends on what the call is for. In this specific situation, it was more a psych eval, because that's what we'll call for. Initial triage questions: is the patient cooperative, uncooperative, combative? I asked her name, her mental status, where she was. I asked her if she was suicidal, and if she was, did she have a plan? Did she want to hurt anyone else? Those are kind of the initial triage questions that I would ask.
Why do you ask those questions?
Just to get a kind of a judgment on the patient, reading the patient.
What's your role at that point? Are you an investigator?
I'm not.
Are you in any way law enforcement?
I'm not.
So what's your focus when you're speaking to a patient?
It's basically hearing them speak in their story. In this specific situation, we didn't know circumstances. We just knew that Miss Reed had found her husband, which she was gone dead on the side of the road. So it was a traumatic call.
So when you were there, you knew nothing about what had happened before you got there.
We did not.
And your role had nothing to do with any of that investigation?
We did not.
You were solely focused on caring for the patient?
Correct.
Did you have any other role other than caring for the patient?
Just making sure she got to the hospital safely. She didn't hurt herself.
During those conversations, are you and firefighter Whitley doing the same thing or different things?
Again, it depends on the call. I was the lead tech, so I'm the one documented, giving a report to the nurses, the staff. So I was more kind of getting that information, my initial triage questions, and then just kind of sat and supported Miss Reed. And
were you writing down information, technical information about status and health on a report?
I was, yes.
While you were doing that, was your colleague speaking to Miss Reed?
He was.
Did you have a chance at times to hear what they were speaking about?
Yeah, and no.
At other times, did you speak directly to Miss Reed?
I have.
Can you describe her demeanor or temperament?
Initially, she was agitated because she didn't feel like she needed to go to the hospital. She said the statement she made, she didn't. She didn't.
They just must not have.
She just kind of said in jest because of the events that she went through. So she, but then there'd be periods of which she'd be calm, and then it would fluctuate. She would have like pressured speech, repetitive, but all in all, she was cooperative.
At some point, did you have a chance to speak to her directly about her mood?
About her mood?
About her mood.
I don't know if I understand the question.
Okay. Did she say anything to you about her last interaction with what she referred to as her husband?
Sustained.
Did she make any statements to you when you were giving her treatment or speaking to her about her husband?
I'll allow that, Akina.
One of the reasons why she was saying suicidal stuff is because the last conversation she had with her husband at the time was an argument. I didn't feel like it was my role to really find out the details on what was said. But that's what she said to me.
That the last thing she said to him was an argument?
Yep.
Sustained.
Did she tell you what the argument was about?
She did not.
Inevitably, did you get a chance to bring her to the hospital?
We did.
Did you stay in the back of the ambulance with her?
I did.
Did you continue to have conversations with her?
Yes, I did.
Did you hear conversations or parts of conversations she was having with your colleague?
I had parts.
When you got to the hospital, what happens next?
So we brought Miss Reed into the hospital, registered her, bring her to the psychiatric section. Is it?
Thank you. I have no further questions.
Okay.
Well, thank God.
Who's on cross?
No, what's on cross? Gosh, this guy looks strung out.
Yeah. He's stressed. I wonder if he's currently dating Karen Reed.
Pop 9 oxys in preparation for this testimony.
Firefighter Becker.
Good afternoon.
Alan Jackson.
When you first arrived at the
I love
scene,
this guy.
Yeah.
there was at least two Canton police officers there still.
Correct.
Do you remember their names?
Officer Saraf and Officer Mulvaney.
Okay. Their cruiser was there. You said that an engine was still there.
Correct.
And was there another ambulance there, or the other ambulance had already left the scene? They'd cleared.
They had already transported to the hospital.
Remind me, you were in ambulance two.
Two. I was ambulance 2.
Got it. You parked behind the SUV where you ultimately made contact with Miss Reed, correct?
I think it was more in front of the SUV because the way the SUV was parked.
Got it. Got out of the ambulance, ultimately made contact with Miss Reed through the passenger door.
Correct.
Had a short conversation with her there.
I did.
You said it was maybe 5 to 8 minutes.
More like 5 minutes because of the weather conditions.
Okay, nothing of great consequence. I'm guessing just an initial, I think you called it sort of a triage assessment.
Well, it's more of just introducing myself and asking her how she was doing.
Got it. And then there was one other person in the cab of the vehicle as well.
There was.
Female, male.
Female.
So there are 2 females, one Miss Reed, one another female. Did you see any other civilian females out there?
I didn't see.
Okay,
But
so at least
This guy's
where
not
you
seeing
were,
civilian
the
females.
contact that you had with Miss Reed and this other female, there's just 2 of them, not a third one.
from what I saw, correct.
Did you get the other female's name?
I not at the time. I did not.
Okay. By the way, have you since gotten her name?
Based on a conversation, Firefighter Whitley and Miss Reed had back in the ambulance.
Got it. Okay. And who is that other person? That other
Miss
female?
Carrie Roberts.
Okay.
So he didn't see
When
Jen
you
McCabe.
first observed Miss Reed, did you note whether or not there was anything unusual about her physical appearance, meaning anything on her?
She did. Yes.
Describe that for the jurors, please.
She had some blood around her mouth, her neck area.
At that point, were you concerned about, obviously you're concerned mainly about her safety and getting her safely to the hospital, correct?
That's correct.
Were you worried that that might be her blood?
Well, she had said that she had given CPR to her husband.
Okay. You jumped a question ahead. I was going to say, did she tell you that it was in fact not her blood?
She did. So that kind of, in a way, ruled it out. No
Okay.
injury for me.
And you didn't indicate, you didn't notice anything about her that looked like she was physically injured or physically in harm?
I did not.
Okay. She indicated that she had given CPR, mouth-to-mouth, attempts at mouth-to-mouth resuscitation to Mr. O'Keefe, correct?
She did.
And that would account for the blood on her face and in her hair and on her neck.
That's what she told me.
Okay. And based on your observations of her, you didn't have any reason to quarrel with that.
Correct.
Okay. You indicated that her tone was somewhat rapid and repetitive. Is that right?
It fluctuated. So at times it was, yes.
Did it appear to you at that time that she had gone through a pretty significant trauma as best you were trained at the time? Objection.
A little bit more of a foundation. I'll give it to you.
Sure. Have you ever, in your course of training, seen individuals who have gone through some sort of a traumatic event?
Frequently.
Frequently.
Everyone's different though.
Understood. Obviously,
Usually right after I ask him for a phone number.
Of dealing with those things, right?
Sure.
have you been able to, through your training, assess whether, at least in your belief, your observations, if someone has gone through a relatively traumatic event, as opposed to just someone whistling down the sidewalk?
Yeah.
Okay. Did it appear at that time when you're interacting with Ms. Reed that she was showing the signs consistent of having gone through a trauma?
At the time, yes.
Okay. So hence the rapid speech, the repetitive speech, things of that nature.
Correct. For her, for the defendant, some people don't have rapid, repetitive
Understood. I'm
speech.
just talking about your observations of her at that time.
Yes, yes, sir.
Her demeanor was consistent with having gone through a significant trauma.
For the situation, sure. Yes.
Okay. You said that she went from calmness to agitation. The agitation you accounted for being, I don't necessarily want to go to the hospital. I don't want to be sectioned, correct?
She felt like she didn't need to. It wasn't, she wasn't going to act on her comments about wanting to harm herself.
You called it, I think in a report, it's SI, suicidal ideation.
Correct.
That's obviously of great concern to you and your partners when you're assessing a patient, correct?
That's right.
You don't want to leave someone on their own if they're going to self-harm, correct?
That's correct.
You pretty quickly assessed, I'm guessing, Firefighter Becker, that she was not, in fact, in the position to self-harm, that I think you said that the statements that she originally made, if John dies, I don't want to live, were not necessarily at the level of actual suicidal ideation. Is that right?
Yeah, I mean, at the time I believed her because of the information we got and what she went through.
I'm sorry, I didn't quite understand your answer.
Sorry, can you repeat your question?
Of course. It's probably my fault. At the time that you assessed her, even though she had made some comments about if John doesn't live, I don't want to live either, you did not elevate that to the level of her being suicidal at that moment.
So I couldn't rule it out, but
okay.
I didn't think it was a huge threat at the time.
Understood.
But
That's
we
what I was trying to get at.
couldn't rule it out, so that's why we had to take her to the hospital.
Understood. I mean, you had a Section 12. You had to take her irrespective of what you ruled in or out, right?
Right.
Okay. Firefighter Whitley was with you in the back of the ambulance the entire time you were with Miss Reed, correct?
Not the entire time. He was before we decided transporting. He was kind of in and out, trying to find more of, talking to the police officers, find more of a story of, what happened, why we're taking the defendant on a Section 12.
Once you and Miss Reed were in the back of the ambulance, Firefighter Whitley then joined you in the back of the ambulance?
He did.
How much time lapsed?
It was a couple minutes at the most.
Okay, so it wasn't a lengthy amount of time.
It wasn't lengthy.
And he was with you during the transport, along with Miss Reed, for the whole transport back to Good Sam.
Yes.
And you said on direct examination, I think your phrase was, all in all, she was cooperative with us.
For the majority of the transport, yes.
Okay. Never became combative, never got physical, nothing like that?
No.
Okay. She did refer to Mr. O'Keefe as her husband or her spouse?
That's correct.
You're aware of HIPAA rules, obviously. You're in the medical field, correct?
Correct.
You were aware at the time that HIPAA rules would demand or dictate that unless you're a spouse or a parent or a child, there's certain rules against getting or providing information to someone who isn't one of those close family members, correct?
That's correct.
Okay. You previously indicated on direct examination that, I think your words were, that Ms. Reed indicated that her last conversation she had with her husband was an argument, correct?
Correct.
You've previously testified about that statement in other particulars, right? Other hearings.
I have.
You're paraphrasing. You didn't write down what she said about her previous interactions with Mr. O'Keefe, and you didn't record those on a tape recorder, correct?
I wrote down in my report that she said she had an argument.
Right. You didn't write them down at the time. That was a bad question on my part. You weren't taking notes as she was speaking.
Yeah, it could have been. I mean, it's kind of for every call, we jot down notes on a notepad, just so, when we give the staff a report, we can read off it.
Do you have those notes?
I don't.
Okay. Do you think you took notes or no?
To be honest, I'm not sure. I could have been typing them on the computer. That's what we typed the report on
Okay.
at the time.
Do you have an independent recollection of taking notes, either handwritten or on a computer, as you sit here right now?
I couldn't tell you if I did one or the other. Sometimes
Okay.
I write on the computer, sometimes I don't.
Or you might not have written
Honest
anything,
answer.
right?
Good.
Correct.
Okay. So in any event, you weren't taking down, even if
He'll
you
be
were
punished
taking-
for that
you weren't
later.
taking down verbatim quotes of what she was saying. You were paraphrasing the information that was coming to you, correct?
That's correct.
All right. You had previously said or testified that the last time, let me rephrase that just a little bit. You previously indicated in recounting what it was that Miss Reed actually said to you was something along the lines of she was upset because her last words to him were because of her last words to him being in anger.
I object.
I'm going to allow the question.
Is that correct?
Well, I probably phrased it a little wrongly.
No.
The last words, it was the last conversation.
That's a different.
Okay, that
thing.
wasn't my question. My question is a simple one. In a previous hearing, did you use the phrase "her last words to him"?
Yes,
were
I
in
did.
anger?
I did.
And that was at a hearing where you're under oath, just like you are now, correct?
Correct.
That was a little closer in time than we are now. It was maybe a year ago, correct?
Correct.
Actually, my mistake. It was about 2.5 years ago. It was a grand jury, correct?
Grand jury, yes.
Okay. And the phrase that you used was, and I want to concentrate on that for just a quick second, Firefighter Becker.
Sure.
The phrase that you used at that time was that she said, quote, like her last words to him. She was upset about her, quote, last words to him. Is that right?
I object.
All right, can I see counsel at sidebar, please?
There's a very big difference because if you're in a massive fight versus just like one quick blurb at the end, it sort of changes the nature as to like, is she likely to be, running him over, which is what the state is accusing her of.
When we read those, they read the text yesterday, and yes, they were having an ongoing argument, but none of it looked like violent animus towards the other. It doesn't look explosive. At that point, it looked fizzled out and tired. And it's like, let's just like, oh my God, this is still going. I thought you were going out for a drink. Now the guy's plumbing. Like, how long is this going to go on? It's not, okay, you motherfucker, this is the last time. Like, this is it. I can't believe you did this. Like, none of the explosive stuff we would expect.
But she did come across as clingy. I mean, she texted him 400 times in the span of 3 minutes, called him, and he's like, stop calling me. I mean, she seemed clingy and afraid of losing the relationship. But that was earlier in the day. And then when he said he sobered up, he started being more welcoming to her. And it seemed as if, like, he said, I sobered up now. And his whole tone was, what, you're not going to be sleeping over here tonight? You're not coming? Like, he was still into her. He displayed signs of jealousy at the plumber coming, even though he was trying to, it seemed to me, at least, when I was reading those texts, that he was trying to mask it by saying, well, you don't need to waste money on a plumber. And that's what he told Mike Camerano. But it seemed, he's asking, is he sexy? He seemed like he was concerned about the male presence there, which is someone who's not looking to dump her. All these things are telling me he didn't dump her in the car there and her running him over. That's the thought I was taking. I don't know if you guys had a similar take.
Well, not just that, like with the jealousy stuff, it's like,
yes, thank you.
All day you've been asking to hang out with me, and now we got to wait on the plumber. Like, it's just annoyed.
The conversation that Miss Reed indicated that she was upset about. You also indicated, in addition to using the phrase her last words to him, you also said that it was earlier in the night, correct? They had an argument earlier in the night.
I don't recall.
May I have just a moment, Your Honor?
Yes.
The other thing that keeps getting confused in the questioning of these guys in particular, did you say this? Well, that's not what she said. That's not the question. The question is, at grand jury, is this what you said?
May I approach?
Yes.
Not what you think now, not what she said, not what the prosecution told you to say about what she said back then, but at grand jury, you said this. And they're really simple questions.
Paragraph, very, very small print. Let me know when you've refreshed your recollection.
Yes.
Right. May I approach?
Yes.
He finally got his case of amnesia.
When you wrote the report, you had indicated that when she was describing the argument that you testified to on direct, it was about an argument that was, quote, earlier in the night.
Earlier in the night, correct.
Okay. And then you recounted that statement, that same statement in the grand jury later on as at least including, quote, her last words. Is that right?
Her last words.
You were talking about an argument that they had, and then she was upset, and you were paraphrasing her. And one of the things that you paraphrased was, in fact, your statement was she was upset that was like her last words to him, correct?
She said that.
Yes.
Correct.
Okay. Were you also made aware, did she tell you that her last words to him were in voicemails? Did she say that?
She didn't give any details.
Did you ask her, what were your last words to him?
I did not.
Did she ever say whether or not she believed he ever received her last words to him?
There's no other details than
Say that
there was no
again?
other details other than what she said.
Okay. But she did, when she was having this conversation with you about her last words to him, she did actually take out her phone and show you a bunch of missed calls to him at the same time, didn't she?
She tried to, yes.
Okay.
And she tried to, or she did?
Did you put two and two together that what she was actually talking about were the missed calls and her being upset about her last words to him, being very angry on those missed calls, those voicemails? Did you put those two things together?
I didn't.
Okay. Thank you.
I just want the jury to put that together.
Hey, Mr. Brennan.
He doesn't care about he's using the witness as a prop there.
So did the last four
So
women who
Ms.
spoke
Reed
to him.
told you that she was sad because her last conversation, her last thing that she had said to him was an argument. Did she ever suggest that was in a voicemail?
Objection.
Did she ever suggest it was in a voicemail?
She did not.
Did she ever suggest that she didn't actually speak to him, but instead it was some type of message?
Objection.
Did she ever suggest that?
She did not.
In fact, you wrote a report saying that there was an argument earlier in the night, didn't you?
Objection. Your Honor.
Sustained.
This is insane.
You then were interviewed, weren't you? Were you
Yes.
interviewed on February 14th, 2022?
Yes.
And you referred to the fact that she told you there was an argument earlier in the night?
Argument early in the night.
And she was telling you this when you were speaking to her that morning?
Correct. Around 6 a.m.
Correct.
Yes.
And earlier in the night, do you know if she was referring to 12:30
I did not know.
or 12:15
No,
or midnight?
I didn't know the time.
So his answer is he doesn't know.
You
Say some more
testified in
times,
the grand jury, and Attorney Jackson just asked you some questions about part of the statement you made to the grand jury when he said, like her last words. Would you like to put that in context of the whole statement you made? Do you remember
Her last words.
Do you remember the entire statement that you made in the grand jury about the statement that was made to you?
I'd have to.
May I approach?
Yes.
So someone in the chat said are they all expected to have eidetic memories? No, they have a transcript from the grand jury. These statements were made under oath.
Yes, sir.
They can refresh the recollection of the witness. They can allow him to read it.
I would
Remember
ask to
this
be
now.
refreshed for every question. I don't trust my memory. Show me the transcript.
Who remembers the exact words that they said 2.5 years ago for damn near anything? I mean,
They seem
very
to-
unlikely.
Their memories seem to consistently make her look worse and worse every time. None of
Now,
them
when
make
you
her look
made that
better
statement you were
when
asked
they're,
about
when
in
they're
the
saying
grand
it the
jury,
second
you
time
didn't
through.
just say, like her last words, did you?
Well,
No.
they couldn't
Did you
get her to be
explain
guilty
your
last
memory
time.
to the grand jury?
Objection.
Ask him what he told the grand jury.
The grand jury, do you know it was on April 21st, 2022?
Yes.
Okay, and did you tell the grand jury?
Are you
So
telling me it was?
she
So I'm going to see Counsel at sidebar for a second, please.
I really want him to say this one thing, and he's just not doing it. He's trying clearly, like he's trying desperately to get him to recount some portion of the statement that he made that's on the page that he showed him.
Yeah.
But he can't say that. And he can't say, didn't you say this? Because he can't lead. Now, if he were on cross, he could lead him into what he said. You said this thing on this date. Isn't that correct? Yes, no. But on this one, they're like, how do we get him to read the thing we want him to read? It's great.
Subscribe, everybody. Law of Self-Defense on YouTube. What is it? Is it Good Logic?
Good Logic
on YouTube and Rumble, and Ricada Law on YouTube and Rumble. Subscribe, everybody. My mission is 1 million subscribers. I can only get there with your help. We're 19.8% of the way there. We can do it with you, with your support.
Almost as high as Karen Reed's blood alcohol content. Now, don't get me wrong, guys. I don't think she wasn't intoxicated. But the state can only prove what they can
Showing
prove.
you that statement that you made that includes last words, but there's more to the statement, isn't there?
She was upset.
I'd like you to read
Oh,
your
sorry.
entire
Sure.
statement, 1 through 5. You can read that out loud.
So she was also she was upset also because she said they had, the last time they had talked, she had gotten into an argument. So she was upset that that was like her last words to him.
And so when you were speaking about her last words to him, were you referring to the argument?
Correct.
Which
You
argument?
testified again regarding this issue, didn't you, in May 3rd, 2024?
Correct.
And at that point, did you think or believe that the conversation she was relating to you was about a voicemail? Objection.
I'm going to sustain the objection.
Did you use the
Already
word
asked the
again
question.
on May 3rd, 2024, argument? Objection.
I'm going to allow this.
I used argument.
May I approach, Your Honor?
Yes.
Your Honor, I know we've now had what, 2 sidebar. Oh wait, sorry.
Prior statement on page
He's just approaching the witness.
line 9 through 13.
Like he did. I won't say.
I'm going to see you at sidebar again and bring these documents, please. Bring all of it.
I didn't make any starred notes on what I want you to read to bring this back up to you this time.
Well, this isn't cross. This isn't impeachment. This is his witness. He just has to
Right.
get the witness to testify. He can't get the witness to read off the grand jury transcript. What's the point of that? The witness is sitting here right now. If the defense was impeaching this witness, they could get him to read off the grand jury transcript as impeachment.
I'm curious what you guys think about Karen continually going up there for these sidebars. To me, I think it's weird, and I personally thought it was a bad look. I'm wondering if you guys think that it affects anything as far as, because I think it makes her look like she's controlling. It just is. It's an unattractive thing rather than just sitting there. We never saw Kyle Rittenhouse go up there. You never see defendants go up there. Like, they have to be involved every step of the way. That's why you have counsel. To me, I think it's the jury. It can only invite a negative reaction from the jury, and I don't see what positive can come out of it.
Well, this is
I
why
would tell her to sit her ass down.
It's why John O'Keefe ran his head so hard into the back of a Lexus.
Yeah. Yeah, that's, he was just
controlling me. No. I don't
think
know,
she's
man.
texting her lawyers like in real time through the whole trial. She's sending them endless streams of texts.
Oh my God.
Look, I feel like you're paying attention to your other defendants more than me.
Is there another defendant?
I don't know. On one hand, I see what you're saying. On the other hand,
I mean,
it's
I
really
wouldn't want
fucking
that.
frustrating.
I wouldn't want my client coming up to sidebar with me. That's weird.
Right.
What do they know?
But this, okay, so this is a retrial, and the first trial was a media thing. It's huge in the area, from what I understand. Like, this is in Canton, like, right? This is a big deal. I think if my life's on the line, maybe I do want to come up to every sidebar. Maybe I want to know exactly what's going on in the case, and maybe my own experience, the things I've said, the things I remember can be assistive in my defense. And I can't necessarily do that if my lawyers are hearing something and relaying it back to me as if I'm an idiot, right? And they do. They dumb down what happens at sidebar. They downplay what happens at sidebar because it's not really up to the client. Like, the client's not the one who has to deal with all the shit that's coming out from the fallout. So from a lawyer's perspective, they summarize and truncate what happens. And of course, they're not going to have perfect memory of what everybody said. And then they go back to the clients like, well, this is what happened.
Yeah, but in this context, the client is an idiot.
I'm agreeing with you, but I'm just saying, like, if I'm in her shoes,
you're a lawyer. You understand what's happening at sidebar far better than 99% of all laypersons are going to.
Karen Reed just went through a first-degree murder trial. She understands more than most lawyers about what's happening at sidebars at this point. Like, that crash course in education. I mean, not only did Karen Reed go through a first-degree murder trial, it was a 6-week-long, highly publicized first-degree murder trial with tons of analysis out there. Karen Reed knows a lot about the law now. Like, I mean, for better or worse.
Well, I don't think she knows about practicing law to the extent that she may not realize that her objective is to have the jury love her, and this cannot help. That's my point. It definitely doesn't help, and it could hurt.
No, I agree, but believe me, I'm all about image in the courtroom. Like, for everybody except myself. But I can tell you it was frustrating watching my lawyers go into chambers.
I'm sure.
Sir,
You're a
when you
lawyer.
wrote the report of your notes to put in your report, do you remember the word argument?
I did.
Do you remember her actually saying the word argument?
I did.
Do you remember her ever saying any word about voice messages?
I did not.
You said that there was somebody in the front seat of the car with the defendant,
It was.
and you later learned from the defendant it was a person by the name of Kerry Roberts.
Correct.
Can you share with us the context? How did you learn that?
The defendant and my partner, firefighter Whitley, had a conversation.
I'm going to allow it.
So the defendant brought up how if her husband had died at the time, she didn't know how she was going to take care of his kids.
I'm going to allow this.
And firefighter Whitley mentioned that she had like a strong support system. All the friends are on Canton, and
Have you met Kerry Roberts? This all hearsay.
All of it, every word of it. Didn't Whitley already testify?
Yeah.
I mean, that's the appropriate witness to talk about.
We already heard it.
We already heard it, and
she's already testified. So now especially any statements that are brought up are going to be non-cross-examinable because she's done. I mean, I guess you could recall her, but the better way to deal with it is, sorry, you had your chance. You had your chance to get her testimony in. If you didn't do it, you can't do it through this weirdo. I think with that guy, never mind. I don't know. His eyes are creeping me out. Looks like there's that Nicolas Cage movie where he was an ambulance driver, kind of looks like that. It's like, God.
All I know is if I went to the dentist and my dentist had this guy's demeanor, I would leave. Like, this guy is way too angry to be a dentist. I want working on my teeth.
Helena Handbasket says, good to see you back in the light of day, Ricada. Thanks for covering this trial. Keep up the good work. Oh, here we go.
If only Binger was prosecuting. Binger.
Hi, guys. Testing this out. No female voices, Nick. Good seeing you guys.
Well, I'll have to get some female voices on there. I don't know. I don't know what female voice I would put into the AI. Like every time. It's like, why would I want to choose that?
Hey, no, shut up and fix your mic.
Sorry. Jesus.
How is EMT testimony not HIPAA violation?
So HIPAA violations are often misunderstood The information that is gathered has to be protectable. The information that is being shared and who they're being shared to has to be like specifically violative. Everybody just says HIPAA because medical information is involved in some way, and that is the HIPAA statute is much less broad than that. That's the easiest way to describe it. But here's the thing: your HIPAA kind of goes away in a murder trial. Period. Like that, you do not have a protectable right in your medical interest. You know, there may be some things about your medical history or condition or whatever that at a trial could be reasonably protected in specificity to address a specific concern, but not when you're the defendant in a murder trial. Like your mental health state, no more HIPAA. Like if you're crazy, they need to know, and the jury needs to know, and you're going to talk about it. But like there are protections to keep people from public embarrassment, but Karen Reed is well beyond that.
If anything, she would want to share it, right? I mean, it's her own benefit. You can always waive
Yes.
your HIPAA protections, and she would want them waived for the purposes of having the jury giving her some sort of a positive consideration. So.
Oh, Gopher Big Guy says, Dr. Mommy, rackets, come on, man. Yeah, okay, a Dr. Muffin's voice would be good from the Johnny Depp trial.
Yeah, but the point I was making earlier about how their memories all seem to just make her look worse is if it was completely neutral, you would think that some would make her look better, some would make her look worse. Now, it's true they've all been prepped by the state, and the state is going to basically encourage them, push them towards making her look worse.
Not at all. State wouldn't do that. They're very neutral arbiters. They're not supposed to be. They're not supposed to be neutral. Sorry.
When you spoke to the defendant and she shared with you that her last words with her husband were an argument, why didn't you ask for more detail about that?
I didn't feel it was at the time we went about the call as that we didn't think we would be witnesses in a murder trial. We were there to support Karen and ultimately get to the hospital safely.
And you were asked about trauma, and you said that you observed that the person may be in trauma, Ms. Reed.
A traumatic event,
Traumatic event.
Right.
Do you have any idea what caused that traumatic event?
I did not.
Thank you. I have no further questions.
Anything?
Very briefly, you indicated that you were asked on redirect examination by Mr. Brennan whether earlier in the night could have been 12 or 12:15 a.m., correct?
That's what he asked, yes.
And earlier in the night could have been 6 o'clock p.m.
Early in the night, yeah, correct.
Could have been 5 o'clock p.m.
Could have been.
Could have been 7 o'clock p.m.
Sure.
Okay. You were also asked whether
I
or
could
not
do times two.
Ms. Reed actually specifically mentioned voicemails when she talked about those last words. And you said she didn't,
That I remember, correct.
but she did show you her phone.
She tried to.
And she did show you a bunch of missed calls to John O'Keefe, correct?
I wasn't going to look through her phone. I don't know who she called.
Thank you. That's all.
When she said about the argument, she said those were the last words, the argument, right?
That's correct.
Sustained. All right. Jurors disregard that last statement. All right, you are all set.
All right. Thank you. Thank you guys.
Is this a good place to stop for the day?
Oh, wow.
The court pleases, yes.
Yeah, I
Jurors, we
think-
could do 6 minutes, but I think this is probably a good place to start. Why don't you go ahead? So, as I understand it, folks, we're on schedule, right where we thought we would be. We're going to release you for today. Now, when I told you this
This lady looks like she's going to tell me where the best bars are on the beach.
when you're out in that room waiting for us, we're in here getting work done to make things more efficient for the trial, especially a trial this long. We've decided that we're going to spend Monday afternoon again trying to streamline this trial and deal with issues that we have to deal with. So Monday for you will be a half a day. All right, so I just wanted to tell you that before you left today. Please, again, those 3 cautions: do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, Please disregard it, let us know. And I guess the fourth caution is the same as I've been saying. Please be very careful with your social media. All right, have a good weekend. We'll see you Monday morning.
All rise for the court, please.
And I'd like to see counsel at sidebar, please.
You're all in trouble.
I'll keep the audio up for me, but I'll pull that down in case something happens.
Oh my goodness. So
Another early day. That's nice.
Yeah, she indicated today would be a half day, but I mean, I feel like every day for her is a half day. I'm not sure how there she is. She got to get real active there at the end. They, a lot of sidebars, so the lawyers got some exercise going up. But it's because the state just doesn't like the rules of how they have to present their case. It's so frustrating, like having to do this the hard way.
You guys were intimating this. I'm not sure if you actually were saying it outright when I was sniping you the other day for a few minutes, that it sort of made me realize there would be no case here at all if she had kept her mouth closed. If she had stayed in bed that night, there's no case at all. I mean, there's really nothing. If she had, maybe, I guess there's some sort of forensic evidence as far as her car going fast in reverse, but everything here is really hinging. If she looks so much guiltier, she would be so much more difficult to convict, certainly, if she just kept her mouth closed and didn't go out there and just stayed home.
Yeah, but okay, so the hard part about that is if he's genuinely missing and she's concerned, then she's going to go out and look for him.
No,
right?
I understand. I understand. My point is, if she actually murdered him, right? So in that case, her smartest move is just, wake up at 9:00 in the morning the next day, be completely sober, and then be like, oh my God, where the hell is Jean? As opposed to if she knew that she hit him, and she was trying to kill him, certainly, in that case, the smartest move for her to do is basically sleep it off. The fact that she's going out there in the middle of the night is, to me, indicative of the fact that she certainly wasn't trying to kill the guy. I think that in fact, I haven't heard any evidence to support the mens rea of an intent to kill. But it's really just a hard lesson as far as keeping mouth shut, because everything here looks so much worse because she says things like the last thing we had was a fight, right?
Right. But I mean, the last bit, that whole day was a fight, right?
And
that
I hit him.
That sucks if he. The problem is, you have to assume for people to be perfect in their behavior that they plan to kill someone. Right. Otherwise, their rather normal behavior looks really bad. But their entire last day was a text fight that we saw that probably had some words exchanged, maybe a little sharp remarks there at the end. And now your boyfriend or whatever, for how long, is dead in the snow. And the last thing you said to him was like, fuck you, I'm going home. That sucks. There's no way around how much that sucks. And if they're doing a mental health evaluation, that's a traumatic thing that she's in, right? Like that's where she is right now. The person who I was in love with is dead. And the last thing I said to him was, fuck you. That is the worst thing that the person could be thinking about at that time for their mental health. And that doesn't mean that she killed him or that there's even evidence of it. That's just, holy fuck, now he's gone. And this was the condition. The fight seemed completely normal to me in the text message thing, normal as in between two people. And there's nothing that indicates to me that fight leads to a murder in any logical progression. Something else would have had to happen for the murder to come out of those text messages. And it seems to me that it's just I don't know. I think the guy died from activity that happened inside the house after she left. But that's my theory.
And you're certainly not alone in that. The injuries are difficult to match up as far as how she has an injury and how he has an injury in the inside part of his arm and on the front of his head. It's hard for me to understand how this is consistent with one pass by of a car. It's just very difficult for me to wrap my head around. I also wanted to ask you guys a couple of things about today's testimony that I think are interesting to note. Number one is the blood alcohol level is being taken of her 6 hours later. She obviously the body has time to sober up, and that's why they're going to try. The state will likely try to speculate that whatever level of alcohol they're able to measure of her at 6, 7 a.m. is, let's relate that back to her finishing drinking at 1 o'clock. But that only calls to mind, we don't know that she didn't drink for hours on end. When she got home, she had 5 hours to go out and get drunk with no reason, that's prohibited for her to go out and get drunk. So there's all these assumptions, which I think to some degree create a reasonable doubt as to that she was this level of drunk at that time, assuming she even was above, the legal limit.
If she went home, especially if she went home angry or after having, they have this fight all day, they're finally going out, things are going well, and then the night ends with a little tussle between them. She doesn't go home with them, obviously, which kind of so she's going home alone. Yeah, she gets home, she cracks open a bottle of gin and starts drinking it.
And she certainly, even her text messages implies that when she's feeling frustrated, she drinks. So, there's a lot of reason there. There's a lot of reason there to assume that it's very possible that she did, to at least create reasonable doubt, that as far as her level of drunkenness, if her level of drunkenness is being held against her, to create a notion of there being some sort of intent that it changes the barometer for when you conform mens rea by drinking and driving and then hitting someone, that if that were to raise that up to.
But then we have all her interview videos, which don't look great.
No, that's another part about keeping her mouth shut. That was terrible.
In fact, I have them spooled up. You want to run through them real quick?
Yeah, sure.
Run through them.
Yeah. Before I forget, I'm gonna forget. The reason I think they were asking him about the did you see any other women there? And he said he only saw Kerry Roberts and Karen Reed. Jen McCabe obviously was driving around with them also. She's the sister of Brian Albert. So as far as I understand, her sister-in-law, she's definitely related to him. She's been to that house many times. And some people in my chat had been saying that in the first trial it came out that she slipped into the house in the middle of the night, which only raises more of a question. If she was in that house, why the hell Brian Albert didn't come outside? Right? I mean, you can understand that if someone dies on your brother's lawn, you're going to go into your brother's house and be like, what the hell happened, even if you're innocent. The defense wants us to think that Jen McCabe, because of her Google search and everything, was in some sort of cahoots there with Brian Albert. And that's why maybe she's sneaking in there and having some sort of further conversation to help further along their conspiracy. But let's assume that there was no conspiracy at all. You can understand her going in there and saying, hey, oh my God, John O'Keefe is dead on your front lawn, in which case they would definitely wake Brian Albert up. You can't tell me he's asleep and that's why he doesn't notice everything happening here with him if his sister came into the house. So I think that's why the defense wanted to make a big deal about the fact that Jason Becker didn't see Jen McCabe, because I think they suspect that that's the time during which she was sneaking into the house, and that only raises further questions on this whole thing, right? I mean, that's all my speculation, but I'm wondering what you guys think about that.
You said you can't wake him up. I mean, it depends, right? Because if they did all just have a long night of hard drinking, and it might be really hard to wake him up. I mean, if the guy finally, there's a difference between people who go to sleep and people who black out drunk and pass out. And if that's the case, for whatever reason, this guy, even if it's all in good-natured fun, he gets hammered out. He plops down the bed.
Your friend is dead on the lawn.
But it's not that. They're not getting up. Like you could shake them, you can yell at them. I mean, when people are blackout drunk, you cannot get them to wake up. They're just not gonna.
They're not asleep. They're like under anesthesia. It's not the same thing.
And it's like they can't comprehend that their friend is dead on the lawn. Like that wouldn't make sense to them at all in that state. I don't think. I didn't usually get that drunk. So, but I'm talking about people I've tried to wake up who have been that drunk. And it's like, brother, you need to get up. You need to get out of my house or whatever. But you need.
What do you guys think about this question from my community? What did jurors really think of constant sidebars? I've never been on a jury, but I would imagine they're thinking, "Oh my God, they're wasting even more of my time."
Yeah.
Look, jurors are there to determine whether someone is guilty of a crime, and in a murder case, they know that they may be taking someone's life away effectively, not with the death penalty, but with incarceration for a life sentence or effectively a life sentence. And so they want to know as much as they can stomach going on. And so anything that happens where they have to watch other people engage in a conversation that they're not privy to while they're supposed to make this really, really important decision that's going to take 6 weeks of their lives to make, that pisses them off, of course. But what are you going to do about it? I mean, the other thing is to, you can have open argument on objections instead of going to sidebar at everything. This judge is really lax on how objections are presented. It's just objection, doesn't seem to want you to call for a rule or make any argument on it.
Someone in my feed said she ordered pre-trial that there would be no speaking objections. So,
I mean, I know you don't want to have the person get up and make this long exposition about every objection, but it is nice to just say hearsay, foundation, relevance. One word objections to the rule would be nice. Indications to the rule would be great. What is the grounds for the objection? But we don't need giant arguments on everything unless the judge wants it. What's up, Joe?
No, and in answer to that question, I don't think anyone on this panel would have greater insight about what the jurors think. It's probably the same way any of you would think when you're sitting here watching and they're going off the sidebar. It's the exact same thought you're having when they're doing it is likely what the jury would have it. We're kind of sitting in the shoes of the jury here. The advantage to watching with a panel like this, with attorneys, is you're able to better understand the legal mechanics and things of that and legal strategy. So you have a better feel for what each side is trying to do and the effectiveness, fairness, or questionable partiality of a judge. So these are all that's what that's what we give you. But as far as what the juror is thinking, the three of us and every person watching this stream anywhere in the world are no different from how we feel about it than a typical juror, likely.
And that's the point of juries, is to find, someone from the everyman is the juror. It could be anyone from any walk of life. This is why I think it's funny when the lab tech is up there talking about, light spectrometry at the 340 nanometers of light, is that you could hear him pounding on the machine. He's like, this baby's got 340 nanometers. It's like, come on. But the
free financing.
You can throw a handful of darts at a Kanye concert and not hit a single person who understands mass spectrometry. Like he does. And so he just says it. And he goes into all these deeply detailed technical explanations. And that's why I was frustrated. Sorry about the mic feedback earlier, but I was frustrated during his testimony because the judge is allowing him to do these long expositionary explanations of the highly technical processes. And it's like, no, let Miss Little ask him the questions, because she was clearly asking him questions about this process and how it works one step at a time.
Yeah.
And if she had asked him to explain the whole process or whatever, the judge would have said, come on now, like that's too much. But instead, the judge just did that because he wanted to explain why his process is acceptable. No, it's just as good. It's just as good. But it's not just as good, which is why you're not forensically certified and why they would not forensically certify your lab under any circumstances. You cannot use that method of blood alcohol testing in a forensic capacity. And he explained why. Produces results that are 18% higher. And if you're going beyond a reasonable doubt on whether or not someone's drunk driving, in this case, take everything out. If they BAC'd her at a 0.093 and charged her, and she says this test can produce results 18% higher than the real test, 18%, you take that 18% away and it's a 0.7078, and she's no longer over the statutory limit. That's a huge problem. And that's why his lab's testing results should have high amounts of discredit to them.
And
for
theoretically,
forensics.
could be like deemed a type of junk science, because you're not more informed. If anything, you're more likely to be confused, right? I mean, it's a
Junk science for a criminal case.
Yeah,
Great.
Yeah,
great for treating people in a hospital setting, which is exactly what they said.
Precisely.
This is about care, not testing.
Great point. Yeah, great point. Yeah, that's not that junk science is too strong a word, but it's junk in the context of what we needed here, and it's perfect for treatment. It's a great point.
And people do believe, lots of people believe that there's just you just do a drug test, or, oh, you just do an alcohol test and then it just spits out a result and that's accurate. No, they're like deeply detailed processes that are highly precise, and they're targeted. One of the problems with testing for drugs, for example, is you have a specific test for each drug. And so it gets really expensive when you want to just, well, see if there's drugs in the system. It's like, well, which ones? Right? Like because they have tests that test for 5 substances up to 15 substances. If you want to just see if someone has fentanyl in their system, you can't just say take a drug test. You have to take a drug test with one of the panels plus a fentanyl addition, because it uses specific reagents to find these things. These are not precise sciences in the way people think they are. You don't just go and like, oh, they just pour pee into a beaker and suddenly they know all of the drugs that are in there. Doesn't work that way.
Mm-hmm.
And the numbers don't work that way either. But again, everybody, it's like the assumption that law enforcement does this, so it must work right. Like, this is how we rely on putting people in jail, so it must work. And it often doesn't.
We're 1 week now. We're a week into the trial, essentially. And I was wondering, like, if you like initial assessments about the effectiveness of various attorneys and judges after the first week of this retrial. So, as far as like who, to me, Jackson is the strongest force in the room.
Jackson's great. I won't reiterate right now. I'll wait till the end of the discussion about, I think Jackson had a huge miss on that objection to the 2 video clips on day 2. But other than that, everything I've seen and heard from Jackson's fantastic. And I think he's a great attorney. He's very clear. He has great presence in the courtroom. I don't think the jury would find him unlikable in any way, but he doesn't come across as like soft either. I mean, he's clearly there to do business.
He's an advocate. Yeah. Is an effective advocate. I know what you're talking about with respect to that video, especially the one he had a partial win after John O'Keefe's mother testified. Everyone in the room, anyone watching that, you have to be a soulless, heartless demon to not have been moved by the tragedy that this woman has suffered. First with losing her daughter and son-in-law, and then the kids going over to John, and then John's death, and the way she was broken up on the stand, which anyone would be. It was very heartbreaking. And what the prosecution wanted to do, in case you weren't here on day 2, was they wanted to make Karen look like an utter biatch. And the way they wanted to do that is they wanted to play a clip of Karen refuting something that the mother testified about. The mother was asked if at any point she leaned over the counter and said to Karen, he looked like he'd been hit by a car.
The island, Joe, the kitchen island.
He leaned over the kitchen island and said he looked like he'd been hit by a car. She said she never said that to her. Nothing of the kind. Then there's a clip from an interview where Karen Reed snarkily says in a mimicking voice of the mother, he looks like she leaned over the island and she said to me, he looked like he'd been hit by a car. And it looked like she was mocking the mother. Now, the state loves the idea of this because you have Karen Reed implying that he actually was hit by a car and not beaten to death by his friends or had some other type of tragic accident. B, she looks cold and evil, especially when you play that clip right after seeing the mother crying on the stand about her genuine, awful, terrible tragedies. And so the state wants basically the jury to despise her as like, how heartless and cold are you that you're making fun of this mother who suffered through all this tragedy? So there's no reason to play that clip. There's no probative value to it. And they had this whole argument because the state wanted it in. And Alan Jackson was arguing, no, it shouldn't be there. And if anything, you could have it as a written statement, but to have her up there on a video looking callous in that way it's highly prejudicial. I mean, that was highly prejudicial. He got a partial win in that it didn't get played that day. It was held off to the next day. So it's not, you don't have the raw emotion of seeing the mother crying and having your heart break for her, and then 2 seconds later seeing Karen Reed. When there's a full day and you sort of don't have as fresh in your mind the mother crying there, I don't think it's as terrible, but it's still that was bad that Judge Cannoni let that in my opinion. I was like, I don't know why we're watching this now.
Well, and I think Nick will address this, but there a particularly bad reason why she let it in.
Yes, and that was everything you said, I agree with. But I think the purpose of the prosecution is exactly what the prosecution said at their argument as to why they should be let in. I think they were very candid with the court and very candid with the defense. They introduced it as consciousness of guilt evidence. And then they laid out before the court and before the defense exactly what that argument was. And none of it relates to what's in the, like the attachment to the clip versus his argument is so tenuous and embarrassing that it shouldn't have stayed. They didn't object to the first clip coming in, and that's where most of the argument took place. But now the prosecution on close gets to make a consciousness of guilt argument. They can call back to those clips, but the jury doesn't care what's in the clips. The jury cares that the prosecution gets to tell them, and she was saying these things because she was conscious of her, because of her guilty conscience about what she did. She took the murder weapon away from the scene. She was talking about what his mother said because of her guilty conscience. That's what the jury will hear on close 6 weeks from now. And the attachment to those clips doesn't matter, but that argument will matter a lot. And he laid it out right to the court. So they can't say they're taken by surprise. They can't object to it later. Like that doesn't have any connection to the evidence because they said, okay. And they lost the objection. To me, that's the most impactful lawyering the prosecution has done and the defense has failed so far in this trial. And I think it's very critical, honestly.
Yeah, and I heard you were bashing Brennan's opening on Viva Fry when I saw you on there, and I personally
the state's opening.
Yeah.
I hated it.
I didn't think it was that terrible. I when he was done talking, I was like, wow, she looks really. I came into this fresh. I'd never seen this. I was like, yeah, there's a lot here. She's saying she hit him. She hit him. There's all this fragmentation, and I thought he did a sufficient job. I was like, this is a pretty decent job. By the time Alan Jackson was done with his opening, I was like, whoa, okay, we got like a real murder mystery here. And I liked his opening a little bit better. But I think that
give me the three best points of Brennan's opening argument for you.
The three best. Well, I'm trying to remember now. We're going back to Tuesday.
Just in broad terms.
Well, he's got to be able to back it up, but it was the science, the math, the physics will show you.
I want Joe's impression of Brennan. I want his three best things. This is not like a trick question. I just genuinely want like the three things where you go, okay, these are the three things from the state that stick out to me.
So one of them definitely is that he was hitting on how we have forensic evidence in the form of ways and alcohol testing and the Fitbit and the whatchamacallit. We have her own admissions, whether it's testimonies or things that she said at the scene. I thought that he laid out fairly well as far as nothing. And what I felt he missed on was intentional murder. But I felt that when he's hitting on what?
No, keep going. Sorry.
I'll tell you this much. When he's talking, I like the way he even laid out. He's like and then she goes in reverse, not rolling backwards, not a quarter speed, not half speed, hits the gas at 3/4 as hard as that pedal can go down when she's going out in reverse there, and hit him with a car. And that's these are the injuries he sustained, and then she just left him there. And I felt as if overall the overarching theme I got was like, yeah, she probably accidentally ran him over there.
What did your wife think about the gas pedal testimony, Joe?
Oh,
I mean, you don't.
I actually said after I heard his, I wish that were true. I actually spent like 9 hours driving on Monday. I so wish that were true. Yeah, I
like
actually,
to kick up my feet, so I drive from the passenger seat.
The the one problem I had with his opening, and this is I felt more of a fact problem than his issue, is you're telling me she's drunk. I don't know if she can form an intent to kill a guy in that sense. And then you want to tell me she's furious at him, so she hits the gas really hard, and that's trying to her effort in hitting the gas really hard is to try killing him. If that's what you're trying to sell me, I'll tell you this: a woman is behind the wheel of a car, and you're telling me that she's furious. She is going to slam on that gas pedal, and she ain't trying to kill nobody. She wants her man to know she's mad, and the same way they'll slam a door or whatever. And a lot of guys will do this also. So you can't tell me that she's mad. And the reason we know she's trying to kill him is because she hits the gas that hard. I'll tell you right now that's not even, forget about guilt beyond a reasonable doubt. I think the prominence of evidence is kind of thin there to establish that her objective was to try and kill him rather than to make a statement to him of I'm mad and I'm steamrolling out of here.
Okay,
But
so
go ahead and dissect it why you thought it was so terrible.
No. What I found most interesting, this is again, I wasn't going against you here. All of what you said was great. But when you first described his opening statement, you said two things. You didn't say them when I asked you what the three most important things were, but those were the two things that came to your mind when you weren't thinking about it at all. And it was I hit him was the first part.
Mm-hmm.
Right. And I just find like that is the most devastating part of her case, or their case, are these admissions that she has over and over and over, or alleged admissions.
Mm-hmm.
And that's where I thought Brennan's argument or opening argument was the best, is focusing on that I hit him, and now they've got that established in the first couple witnesses. I think that's really bad for her, and I think that's going to stick with the jury when they think about what's been going on here. The first thing they're going to think about when they think about the prosecution's case is I hit him, and that's what, in your natural flow of conversation, that's what you hinted at, and I love that. I was so annoyed though that you didn't get back there when I asked you the three most important things.
Right.
But my main problem with his opening argument is that, okay, he establishes that that's a big part of it. He establishes the forensics. I do agree with you that that's really, really critical, but I don't get the story out of him at all. It felt like it was, I have this piece and this piece and this piece and this piece, but I'm not seeing the picture when the puzzle's put together. And that was my main problem. Like, you're losing me. I don't know why any of this is going to matter. And you haven't built an arc that tells me why it's going to matter going through it. And Jackson's opening statement, it starts off strong. Like, he flat out, he's just like, this didn't happen. And then he goes through why you're going to hear that this didn't happen and all the problems with it. And I thought that his narrative was better. Like you said, by the time Jackson's done, you're like, no, this beyond a reasonable doubt. No way did they get there at this point.
Yeah. I mean, the other, it was so effective that when I was trying to explain to Lady Logic why on day one, I started really enjoying this case, is I went over to her and I said, this is the opening. And I went through the opening far more thoroughly than I just did now. And I'm like, they're talking about, they got his DNA on the back of the car. They've got her broken tail light all around his body there. When you first hear him explain that, you're like, all right, her broken tail light is all around his body. How the hell could that not be that he hit her? And then you find Alan Jackson coming up there saying this never happened. Oh, you're going to remember the name Michael Proctor because he did such a bad job in this investigation that they had to fire him for his work on this case. That's how bad it was. And then he took possession of that car a couple hours before telling anyone he had possession of it. And then after they'd done a search once, twice, and on the third time, all of a sudden, after he gets the car, boom, now we have fragments from her tail light all around his body. I'm like, oh my God, this is crazy. That's when I fell in love with this case. It was during Alan Jackson's opening. And then we had that first witness that came out there. And when he was being impeached, I was like, this case is going to be crazy. And I do think that this is a really fun case. I'm looking forward to the next 6 weeks rather than dreading day by day, which is awesome. But the point I'm getting at, yeah. I'm not saying that she's guilty. And I'll tell you, I don't understand how his DNA would get on there. I mean, if he's wearing clothing, I don't even understand what the hell is happening here.
Look, wait, so this is his girlfriend's car?
Yeah.
if you want to understand how his DNA, like
Oh yeah, he
DNA
could have
gets,
opened the trunk. Yeah, he could have
gets
touched it.
everywhere.
Yeah.
If you own something or are interacting with it relatively frequently, DNA is going to get everywhere. The trick with DNA is always, are they swabbing the right place? Did they happen to find a spot where DNA has made it and been preserved at that
I don't
part?
even understand how his DNA would get in the car in the cold winter if it's that from a
I mean,
swipe
DNA
by.
doesn't like bundle up and stay in for the winter. Like it still gets on stuff.
You asked a great question. This is something else that when I was snapping you, I caught like I think the best of your coverage perhaps. So if not, you guys have been killing it. When you made the point as far as the tail light smashing outwards rather than inwards, which is something I hadn't personally thought of, but that the idea that it would smash outwards into him rather than his head pushing it inward and then it would just sort of like stay there, you know, and it wouldn't all come shattering out right then and there. It doesn't, that's hard to understand how that would happen, and does make it seem more like someone sprinkled those pieces around his body.
It's like a bomb, like an IED taillight.
Yeah. I thought that was a great point. I thought that was a great point that I myself had not come up with. Yeah.
Yeah, and I want to see how the state tries to get the forensic recreation to show me all these lacerations. The only thing I can think is that on his up near his deltoid, the upper arm, you have these big horizontal gouges. And to me, that's the closest I can get to saying, all right, if I see a jagged edge of a taillight, and if it happens to catch the arm just right, and it could gouge across horizontally, that makes sense. Like cut a couple first.
One laceration.
Right. But that's that's a laceration. That is not shards like
everywhere.
Right. This peppering of the arm. It looks like he tried to kidnap Rambo's daughter or something.
And as Andrew had pointed out, far broader range than the size of the tail light. I mean, it's 18 inches across. There's lacerations across like 18 inches, and that tail light looks far smaller than that. I don't know, but that it's spreading out throughout his arm. I agree that, and also, really, let's face it, there's no bruise other than the only bruising he got from getting hit by a car. Not on his leg, not on his hip, not on his chest. The only bruise is like what he's leaning head first and arm first into like this into the driveway where what is happening there? What bodily position could he be in that he gets no injury, no bruising at all, anywhere from toe all the way up to armpit on his torso, and only on his arm and his head. I don't understand how any person has ever been hit by a car that way, unless they were laying across a train track or something like that, and laying across a road like that. That's the only way that would happen.
Okay,
so,
you say that, and I 100% agree. But I've also watched dash cam videos from India, and I know that no matter what you think can't happen, it has happened in India. It has been caught on camera several times. So I'm willing to entertain the theory. I don't see it, but I can be shown, but I'm gonna need it to be done with some kind of bicycle in the background. I'm gonna need a train going by with too many people on it.
Right.
And like that's
the street this wide.
Exactly. But that's like, my point is, I know that I can't see it. I can't see it at all. That doesn't mean it didn't happen, though. The unlikely happens all the time. The unlikely happens in catastrophic ways, with more frequency than we want to admit. It's just unlikely for that situation. But a whole lot of shit's going on in the world all the time, so there's always opportunities. But yeah,
and the other thing that killed it that Alan Jackson like blew my mind with is that snowplow guy saying that he went by there at 3 o'clock in the morning. There's no body there. It's like, wait, what the hell? It's like the vanishing body that wasn't there at 2, 3 o'clock in the morning, and that was there when she leaves it, and is back there again at 6 o'clock in the morning. To me, I'm just like, we got like, this is a real mystery. This is like a whodunit, and you got to get proof beyond a reasonable doubt. They're gonna have a hard time. It's a hard one, if not for the fact that she opened her mouth.
So what do you guys think? Now, I think that popular opinion, or a popular opinion out there is the at least some level of conspiracy and cover up of this. Not necessarily an intentional murder, but cover up of the death, however it was caused, by the people at the party. And then, of course, pinning it on Karen Reed. They're all cops. There's problems with the investigation. So the rumors of conspiracy obviously are there, right? Do you think it's wise for the defense to try to build a conspiracy argument, or is it like more directly, or should they just aim for reasonable doubt and not go for the conspiracy? Because you don't have to present the thing that may have happened, and that can cause a lot of trouble for you if you try and can't really sell it. So what do you do in this case? Do you go for the conspiracy?
Well, I think a lot of this, conspiracy is a strong word, right? Did all these people sit around the table and orchestrate all this? I mean, that's probably not what happened for all these people. But are all these people friends with each other? Do they socialize? Did they go to the high school junior prom together? I mean, and once they do that, do we have this contamination of memories? And people want to reinforce their friends' perceptions of what happened. And so you end up with it's almost like a subplot conspiracy as opposed to an active conspiracy. It's an incidental conspiracy. I mean, Karen Reed could be completely guilty, right? She hit this guy with her car, drove home. These people don't know anything more than they know now about it, but they would still be contaminating each other's memories, right? And if a lot of the most damaging testimony is they're recounting things that are not their personal memories, but things that were kind of inserted into their minds because of recollections that other people said they had, and those things are damaging, the defense still has to address the damaging testimony. Is it credible? Is it contamination? Is this real? Did you actually hear this? And then people have to say, well, no, I didn't actually hear it.
Right, like Carrie Roberts when she recreated everything with Jen McCabe and wrote it down. Like
you can't let that stuff stay in front of the jury as if it's unimpeached.
Yeah.
So I tried to talk about this in my own case because the word conspiracy just means people acting in concert towards a particular end. It doesn't mean that they set out to do it necessarily. The conspiracies manifest at different times. My case was not a conspiracy against me, but there are certain things that happen that can where people do act in concert for a purpose, and they have a conspiratorial purpose. Even it doesn't mean that they are framing someone or whatever, but how something can be handled can be. This is not from the government. I'm not talking about government in my case, people. I'm just referring back to a prior conversation that I had. But the other thing you have, and this is where I think people, this applies in all contexts, and people undervalue how little needs to be done to fuck someone over completely, intentionally or unintentionally. A government worker missing something by accident can be the difference between someone going to prison forever and not going to prison at all. And in the same way, like Andrew's talking about, these incidental conversations that you have with your high school classmates, your coworkers, in some cases, your coworkers' wives are getting together, that those types of conversations create this. And it doesn't take much to really hose someone over, even when everything's legitimate, or sorry, where Karen Reed is completely innocent and no one interfered with John O'Keefe on his own. Like maybe he just died outside. Who knows? Meteor hits him, for example. And there could be no...
That would explain the lacerations better than the car.
Exactly. But it really doesn't take much. I don't know. That's why I'm curious on if they should go for try to convince the jury that there's a conspiracy of information. Maybe that's a better way to say it. A conspiracy of information.
So, for example, when you were saying that just now, and what Branca was saying, imagine there is a cop who screws something up, and another cop sees that he screwed it up, but you really can't unspill that milk. So you would basically be like, all right, I don't want Jason to get in trouble here. So, we're friends for the last 30 years. I'm just going to help cover that up, that he screwed that part of it up. Not that I want to see Karen Reed go to prison. I don't care about that. I'm not looking to get her. I don't have an anti-Karen Reed bias. I'm just trying to protect my friend here who from the embarrassment of having this screw up being called to light. So they'll start to cover up for each other in that sort of way. And it ends up that if you're cynical, you can look at it and say, like, they all want to see Karen fry, but that's not the motivation. The motivation is there's a screw up, which is followed up by people being like, oh, I want to protect this person from facing repercussion for that screw up, not I want to punish Karen Reed for some reason.
Especially if they genuinely believe she's guilty, right? They
Right.
don't have to have the evidence. They don't need proof beyond a reasonable doubt. They just conclude she killed John. Well, then it doesn't matter what they make up about her or what
Right.
they pretend they knew, because it's all in a good cause.
We're getting justice done by lying. We're lying to get justice done, or we're putting this together to make sure that she actually, that our friend see and his family see justice get done for them.
There's a plot summary of every detective show on the planet. It's like, we have to look over the procedures and protocols that are there to protect rights, because we know the guy's guilty. We just got to find the way to get there so we can arrest the guy and prove it.
Right. Everybody knows she's guilty. Well, if that's what they believe, then everything's fair game.
Right. And then you feel like you're not being bad. You feel like you're acting on behalf of morality, right? I mean, you feel as if you're helping make the world a better place by telling this lie, because you're ultimately seeing justice get done once you reach that conclusion.
And we've just summarized The Wire. All of it. Thanks, Joe, for explaining McNulty to us.
I never saw The Wire, actually.
It's really good. Like
everyone says.
It's
the first
really good.
episode I got a half hour into the first episode, and I was just like, this is so slow. It was the first half hour was just like, and I don't remember what happened, but yeah.
I love the first scene though. The first like 5 minutes is just it's the funniest conversation.
I don't remember it. I just remember like I was like a half hour in, and I was just like,
1 second, be right back.
Yeah. Anyway, so yeah, so we were talking about effectiveness of counsel and things of that nature. What do you think of the state prosecutors so far?
I mean, they're methodical. They're stepping through what their argument is. I don't see them making big mistakes. They tend to overreach like prosecutors tend to do. Make more out of their evidence than it actually is, but that's to be expected. They believe she's guilty. They're trying to prove a narrative of guilt beyond a reasonable doubt. They're always kind of scuzzy. So, when people say all these prosecutors did horrible things, sometimes that's true. Sometimes they're really bad. Sometimes they're, Binger bad.
Right.
I'm not seeing that level here. I'm seeing a pretty typical prosecutors taking what they can get. It is an adversarial process. The defense is supposed to check these guys when they're overreaching too much. And of course, the judge is supposed to be there to enforce all that. I don't have a problem. I think they're very low. They're low energy. They're no Alan Jackson.
Right.
Which is why they're public prosecutors, and Alan Jackson's, makes a lot of money doing what he does.
Right.
Ionetti, is that the other guy, the local guy in council? He's good too. I like him.
Yannetti. I'm not sure it's Yannetti or Ionetti, but yeah. He pronounces it Yannetti. He pronounced it Yannetti when he addressed the jury today. So, but whatever.
Okay.
Yeah.
Yannetti. That's what it is. David Yannetti.
Yeah.
He's good. Elizabeth Little, we heard for the first time today. I didn't hear much from her. She sounds like she's asking questions off a piece of paper that someone gave to her.
Yeah.
She comes across
She's
to me.
relatively new. She's new.
Well, someone said 8 years.
8 years. 8 years can be kind of new.
I guess it depends on what she's been doing, right? A lot of lawyers, or 20 years, are never in a courtroom. So, but anyway, so I wasn't super impressed by her, but maybe that's appropriate for where she's at. I don't know. Then there's that guy, Robert Alessi, who strikes me like if Elon Musk became a criminal defense attorney, kind of on the spectrum, really, kind of bothersomely loud. Like, why is he so loud all the time? It's like he's always yelling at the judge all the time. I'm like, and he throws in words like forthwith and post haste in a way that, if I ever came across like a fake lawyer in a courtroom, I'd expect him to be behaving a lot like Robert Alessi. Not that I'm saying he's a fake lawyer, but it's just kind of an odd way of presenting himself in a courtroom. And I don't know. I don't know what to say about them. And then, of course, there's the last lawyer who's not really a lawyer here, but I guess she's kind of advising the team, Victoria Brophy. She's the one who is the juror in the last trial.
Right.
But
Georgia.
I don't.
It was Victoria Georgia. Was I wrong on that?
Oh, maybe it's 3 names and I missed one. I don't know.
Oh, okay. I don't know.
But I don't expect she'll play any kind of a substantive role that we'll see in the courtroom. Every time Jackson gets up, I'm excited. I just want to see that guy perform.
Yeah, he's great on cross. How many people has he impeached in his first week? I mean, he's really, really good at that. And even just presenting the tone that he's winning, like when he's doing it.
And he does it in a polite way.
Yeah.
I can say it because he's a white guy, but he's well spoken. He speaks calmly, right? He speaks reasonably. He's not like yelling at people.
Yeah. All right. So the next question, I guess, is Judge Cannoni. What are your thoughts so far?
Oh God, she's terrible. Ugh.
Yeah, go on.
I was just gonna say I hate judges who appear like they appear laid back and passive, like, okay, we're gonna let this thing happen, and then you start looking at the rulings stack up, and it's like, oh yeah, I'll contemplate this or whatever, and it's just state for the state every single time, and you're like, okay, I know the score. I hate it.
I just don't understand a lot of her rulings. Like she'll object, sustained, object, sustained, object, sustained, object, I'll allow it. And I'm like, but this is the same thing. I don't understand what's changed because there's no speaking objection. So there's no rationale provided. So I don't understand why she's allowing some things and not others. I can imagine why, but it would be nice to know how she's making these decisions. Otherwise it comes across as arbitrary.
Yeah.
And it's arbitrary, and the state knows it because the state got denied, or they object, or yes, the state made an objection to something that was the defense made an objection to a state question that was sustained. State asked a couple questions and went right back and asked the exact same question with the exact same wording, and I thought she was going to overrule it. The state knows if they just wait, they could possibly get a favorable ruling even on the exact same question with the exact same grounds, and they're going to just push for it. And,
right. If it's random, right? If the objection being sustained is random, well, you just keep taking shots until you get lucky.
Yeah, and I think they know that she will be deferential to their position enough that randomness will not. She won't go, did I rule on this 48 seconds ago? Who cares?
Yeah, I mean, look, it's in vogue to bash on Judge Cannoni. I understand that, especially people who watch the first trial can't stand her, and I haven't been impressed. I certainly cannot say I've been impressed by her. She seems. I've seen a tilt toward the state. I haven't seen it yet be that bad.
I'm gonna.
Well, I will say
the ARCA issues.
Yeah, I was going to say that ARCA question. What's going to happen on Monday? Because the judge appeared heated towards the defense. Like, I believe you've deceived me on this discovery stuff. I need you in here. I need your witnesses in here. I want them under oath. Yeah, we're going to voir dire your experts. I want to know what the deal is with these 100 or 1,000 or whatever it is text messages, and why they're not in the record and why they weren't shared. And Robert Alessi standing up and screaming that, well, these things were deleted forthwith and post haste, Your Honor. And she's like, I have no idea what that means. And I don't blame her. I have no idea what that means either.
I said the same thing. I was like, I don't know what that means either.
But she looks like she's primed to really issue some kind of sanctions. I mean, not in the formal sense, but make evidence inadmissible, the defense experts inadmissible, if they don't have a damn good explanation for. And I'm not even clear on what the questions are, but she's clearly upset about something.
Yeah, well, on that though,
she believes there's text messages. I believe is what Alessi is referring to, that there are text messages from 2 years ago between counsel and someone else, maybe Miss Reed, maybe an expert, that she asserted that they had an affirmative duty to preserve. And she says that those text messages need to come in. Alessi saying those text messages don't exist anymore, Your Honor. Like, they're gone. We have a record that we affirmatively produced that text messages were sent between this number, but that's the best we can do. We cannot get you the text of those messages because no one has it. It's not around. It's not there. And she seems like she wants those text messages before she's willing to let the ARCA testimony come in, or the ARCA evidence come in. I think that could crush Karen Reed's case if she doesn't allow ARCA in. That's my understanding, though.
From
But
what I understand about ARCA, and those of you who are unfamiliar with ARCA, ARCA is a recreation team, which I think is often hired by the state, and in this case was hired by the defense, where they based on all the evidence they see, they try to recreate exactly what happened here, and supposedly it does a lot to help exonerate Karen Reed from striking him with a vehicle, and I guess that is consistent with our questions about how he doesn't have bruises and the weird places that he has the injuries that he sustained. With respect to Kanoni, I'll tell you this: if she's angry that she feels like she was deceived, that is not an uncommon thing from judges. Judges, if they feel as if you're BSing them and that you're trying to hide your BS, a lot of judges will become animals about it. That to me is not indicative of her being uniquely anti-defense. Now, I don't know what her basis is for coming to that conclusion. I don't know enough about what happened within the history of ARCA, but if a judge feels like you're playing games with them and trying to deceive them, they likely will come down on you with whatever force of God they think they have.
Well,
so that's not surprising to me on that end. But go ahead.
I was just going to say my feel for it is, and I fully believe that the state did this. What happened was the defense wanted to introduce this ARCA testimony that to get permission, I guess, from the federal government to employ ARCA. I don't know the backstory. I'm not sure why, but some level of permission needed to occur. And then the defense asked for the prosecution's forensic data on the car, and the prosecution dragged their feet for 6 months before they even produced their first report. They get the report. They say it's inadequate. The judge says, look, y'all's expert testimony, we need to know what your experts are going to testify to. And the defense is sitting here going, we're still waiting on them to provide what they intend to introduce for our experts to counter. We have to respond to the data that they're going to bring in. And what Alessi laid out, he's like, they waited 6 months. They got this. We responded within 48 hours. Then they waited 2 months. We responded within 24 hours, Judge. We are not dragging our feet. We are trying to do this. You imposed an arbitrary date on us turning this in, especially in a 6-week trial. But you impose an arbitrary date, and the state is trying to play out the clock and leave us with no time for our people. And we're still getting it to you. Now the judge is making bones over texts from 2 years ago. And it's like, well, what did texts from 2 years ago have to do with reports that are generated in the last 7 months? Well, we can't know until we see the text, except that's circular reasoning. If the texts aren't available, they're not available. Is there something wrong with the reports now? Are they violating the discovery on the reports now? It seems like the defense has a good argument as to why their discovery is delayed, and it's entirely at the hands of the state dragging their feet. This murder trial was over a year ago. What took them 6 more months to get this data and start to prepare this report? They should already have something to give to the defense at that point. So now, but the state does this all the time.
So you're making the point that her basis for being upset with the defense is wrong, and that could be.
So I got lost in what I was saying. My initial point is that it's the subtle bias towards the state, and you can hear it coming out of the defense and their frustrations over this discovery issue. We are in compliance with discovery. The state is dragging its feet, and you see every nod just going in favor of the state. Discovery violations on the defense, in my opinion, should have to be so egregious as to be obvious manipulation of data for the purpose of defrauding the court. Because it's the defense, you should be afforded every single opportunity to defend yourself. But all of the discovery deference that tends to go towards the state in a criminal trial. And it's frustrating because that isn't a protection of right or a presumption of innocence. Those evidentiary issues matter. And when you see a judge consistently rule in favor of the state on every little issue, it starts to add up, and it looks like a subtle bias that becomes a snowball effect, becomes a big monster, an albatross at the end of the trial.
Well, I've seen her sustain a lot of objections that AJ has brought up, Alan Jackson. So I haven't seen quite the level of bias that everyone claims. I may see more. We may see more and more of it. For me, it's like you're saying, it's a cumulative thing. I don't feel it's nearly as cumulative for watching just this trial. And I'm sure that a lot of people watch the first trial also and have formed opinions about Judge Cannone from that. And perhaps, from that it's well learned. I'm simply saying, from what I've seen, just seeing the first 4 days of the retrial, I feel like she's leaning toward the state, but I've seen other judges be far worse. That's my own personal take.
Yeah, of course. Mostly she's not doing. Someone asked me on Twitter.
It's early though. It's only. Wait, go ahead. Sorry.
Someone asked me on Twitter if you've seen anything appealable. It's like, well, not really. It's just annoying.
Right.
But is it appealable? I mean, maybe in the appellate work on this case so far is going to be in pretrial motions and evidentiary motions that are not the courtroom drama that we're watching, right. and she may make decisions there. On her objections and her admissions of evidence so far, I don't see anything egregious. I think the defense should have argued against those clips for that purpose. Although I think if the state wasn't going to make the consciousness of guilt argument, I think those clips are fine.
Yeah, that was actually the one call she made that bothered me the most, allowing those clips in, because that snarky clip, he made the point, why not just give a transcript of her saying it? Because it's all her tone, which was so terrible. And, where she looks like she's mocking the mother who everyone saw grieving. That's so much more prejudicial than probative. So much more prejudicial that there's no benefit to having the video. There's no enhanced benefit, at least, to having the video. Perhaps if you can argue the whole consciousness of guilt claim sufficiently well and tie it into that clip there, I don't even really understand how it displayed consciousness of guilt. But if the judge thinks that if a judge thinks that a juror could interpret it that way, then put the text in there.
You mean the kitchen island?
The
comment?
kitchen island thing.
Yeah. The state's argument is that basically it's a fabrication of evidence, tampering with evidence. She's fabricating a claim that the mother said something that the mother didn't say. That's the conscious. So any tampering with evidence would be. Now, it doesn't sound like tampering with evidence to me, but that's the argument the state is making. But to your point, if the argument is consciousness of guilt, you can perfectly make that argument with a transcript. Yes. Because it's simply the claim, right? The claim itself is the problem. You don't need the tone. You don't need the sarcasm, right?
Wish she looks heartless. Someone here in my chat just sent a chat saying during the last trial, defense asked judge to recuse herself due to a social connection to the McCabe family that refers to her as Auntie Bev. Okay, that would bother me. That would bother me.
There's tons of those issues, and they presumably have been resolved in favor of this judge staying. I mean, that's still there. Now, incidentally, today is her appeal is being submitted to the United States Supreme Court.
I don't think she's going to win that appeal.
I don't think they're going to accept it.
Yeah, they're not going to grant it. I don't think
who's appeal?
Karen Reed is appealing 2 of her 3 charges as double jeopardy.
Yeah, what she claims is this. I mean, I went through her appeal on one of my live streams. So she's appealing to the Supreme Court saying that at the end of the first trial, the judge never bothered asking them.
Oh, right. Yeah,
she never. Okay. Well, I'm going to just explain to the audience.
Sure.
So the judge never. They went back and forth asking questions, saying we're hung, we can't decide, and the judge basically said, okay, mistrial, we're gonna have to do this whole thing all over again, and she dismissed them without talking to the jurors any further. After that happened, the next day or 2 days later, over the next several weeks, several of the jurors reached out to the defense counsel and said, hey, we saw there's a mistrial on all 3 charges. The first thing we decided on day 1 of our deliberations was there's no way in hell she's guilty of intentional murder. That's definitely not something she can be found liable for. And then we were arguing, and also on the 3rd charge about leaving the scene of the crime. All that we had was hung up on was this issue as to whether she had accidentally hit him with her car and that caused his death. So, and that's where we couldn't come to agreement on. The entire time, that's all we were fighting about, but we all agreed to this. Now, the way the law operates on this is, it's nice that they came to that agreement up front, but it has to be said in court. And if it's not, the workaround, if it's not said in court, is that at the end of your deliberations, you have this unanimity about there being not guilty on certain charges. And while it's likely the case that once they put those two charges aside and spent the rest of the time dealing on the second one, it's very likely the case they never bothered talking about that. And it's very likely the case that they all finish their deliberations in agreement that she's not guilty of charges 1 and 3, unless they have that official vote. For all anyone knows, they may have changed their minds during the course of their deliberations about count 2. And accordingly, you cannot rely on that, even though it feels like a real injustice. And it's really a screw up by the judge. She should have said, hey, you're hung up. Are you hung up on charge 1? Are you hung up on charge 2? Hung up on charge 3? She didn't do that. That was her failing. That was a terrible, terrible failing. The defense could have asked her to do that. That was a little bit of a failing on their part, that they didn't ask her, say, hey, they're hung. Obviously, they must be hung up on, maybe they're not hung up on all of these, but then you're sort of running the risk. Maybe they're hung up on the first charge and they think she's guilty on the second charge, right? I mean, if you're the defense counsel, perhaps it's not a screw up, because until you know what the jury has deliberated about, for all you know, they're all sitting there arguing about whether or not she intentionally killed him, but they all definitely agree that she at the very least accidentally killed him. And maybe you don't want to hear what they have to say, and you don't want her polling the jury. It's a bit of a the roll of the dice, which could end up with your client now sitting in jail for 8 years rather than having a brand new retrial. So you can understand that maybe it wasn't completely a screw by the defense. It was a tactical call not to have them be polled. The judge should have polled them, didn't. Now she's saying to the Supreme Court, hey, because they found me not guilty in their private jury room on charges 1 and 3, I can't face charges against that again, because that's double jeopardy. But frankly, the law doesn't seem, even reading from the papers from their side, to me, I don't see how they're going to get past the Massachusetts Supreme Court finding that under the law, it's not considered double jeopardy unless there was a new vote by the jury at the very end of their deliberations rather than merely having it at the beginning. But if you guys have other thoughts you want to add in on that, I'll shut up now.
I don't know enough about the issue. I just saw that it was the Supreme Court was receiving it today. They could decide on when they'll hear it starting today. But they wouldn't be hearing it today, just so there's no confusion on that. I mean, I don't think they're going to take it. Just that seems like a long shot in general, and it doesn't get her out of the. She still has a murder charge, like that that she has to defend herself against. Like this is still happening. But hey, who knows? Who knows? I've got some chats here. Otherwise, if there's I got to bust on out of here. I got stuff I got to take care of today. So I appreciate you guys bringing me on here. Yeah, man. Always a pleasure.
Anytime, Joe.
Yeah. I kind of sort of feel, I know a lot of people have asked me about streaming with you in particular, like the two of you in particular. And I love hanging out with you guys. I'm sort of very, very torn about it. I'll probably end up polling my community as to like what they prefer. Because sometimes I like just having myself, like where I'm able to just sort of, I'll stop the video for like 10 seconds, 20 seconds and fall behind. And there's a lot more freedom and latitude where I feel like I can give coverage in the moment that I would never even think to do if I'm sitting as part of a panel. So, but on the other hand, there's a lot of slow time, as we all know, during the course of a trial or different comments that end up enhancing the overall production when you have other intelligent attorneys that you're able to bounce ideas off of. So I'm sort of very torn about this, but I'm sure I'll end up popping in on your. I don't know if I'll be doing this more and more on a regular basis, but I'm sure I'll be popping in on your stream over the course of this trial for the next like 6 weeks or so.
Yeah, just keep in touch. Well, we can always figure whatever out. No big deal. It's always great to have you on, man.
Either way is fine, Joe. Whatever you want.
Thank you, guys. Awesome seeing you as always, and I'll probably see you sometime next week.
All right, brother. Peace.
Take care.
Hey, let me hit my. See you, Joe. Let me hit my.
Get out of here.
My class one more time before we wrap up the show. I know you have super chats you still want to do, Nick.
Yeah.
But tomorrow, Saturday, April 26th, I'm teaching a class I only teach twice a year. It's my Law of Self-Defense advanced class that teaches you how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. Full day class taught live by me in plain English, streamed to you at the convenience of your computer. Learn how to be hard to convict. And if you can't make it tomorrow, you have a conflict, that's fine. Register anyway, because you get access to the recording of the class for 2 weeks after the live stream. So you can watch it anytime in pieces, whatever, at your leisure over that 2-week period. But tomorrow is the day. If you missed this one, it's at least 6 months before I do it again. Check it out at lawofselfdefense.com/advanced.
So you just do it once every 6 months?
Roughly, yeah.
You do it roughly once every 6
Right.
months.
No,
Well, at least you go hard.
It's that kind of class.
Oh man. By the way, guys, a new thing for my channel since coming back is the addition of super tips, which is the ability to send a message with with AI voices attached. I just had Ryan, the editor, up. He's sent off a couple more voices to be added. So I think by our next stream, next trial stream, we'll have more of them, including voices from the trial. We've got, which ones did I have him doing? I think we've got the two. We got Nuttall, and we have that the other paramedic. So far we've got that, but maybe we'll grab some of the attorneys in the case as well. I think an Alessi voice is going to be hilarious. I just need him talking for 10 minutes straight. I need to have Ryan able to find 10 minutes straight of Alessi talking. Probably might have to grab it from the first trial even, but him just yelling at everybody is awesome. So we've got those. Try them out, play around with them, but they come out like this. Here we go.
Schedule 1 is a drug dealer simulator. It's a great new indie game that went viral a couple weeks ago, by the way. If I wanted to name a cocaine blend after you, what should the name be?
What should the name be for a cocaine blend named after me? I mean, papal powder, man. That's what it's got to be. The Pope. The Pope. I don't know. I don't think I can play Schedule 1 as a term of my probation.
Seems
Is that a
very
thing?
odd that he keeps referring to her as
Oh,
the
but
defendant
hold on one second.
rather than Ms. Reed or the patient.
Is what a thing? Not being able to.
Cocaine blends, like a coffee blend. I mean, everything's blended, of course, but like, are there options you can choose? Or
So I have never encountered this, but I heard. No, I legitimately haven't encountered this, but I had heard that there are like I guess scented or flavored cocaines out there that was a new thing, and I was like, that sounds
pretty
that
gay.
sounds funny, but like, yeah, I mean, I can't. I hand to God, and when I was using, I definitely would have tried it, and it would have been funny, but I'd never actually encountered it. So that's all I've heard about anything close.
Coming on my show, this little piggy show today.
I don't know. I haven't been invited.
This whole ordeal could have been avoided if broads weren't allowed to drive. I mean, they're just total havoc on the road. Why the hell are you in reverse, lady? You can barely drive forward. Jesus.
I love Mark Richards.
Objection, Your Honor. This trial's dragging worse than my coke-fueled bender last May. Can we snort some ketamine and call it a mistrial?
That won't pick it up, guys. Let's see. What do we got? Frederick Little says we need a Mitch McConnell voice. Shut Up, I Can Cook says I sent a super tip. How did I hope I did it correctly? Also, stop SCOTUS. They're unstoppable. John Roberts is ripping his robes off constantly and shoving the Constitution down the mouth of Alito, the traitor. Oh, wait, the other way around, maybe. I don't know. Chris K. I'm a Second Amendment absolutionist, and I hate the Colorado law, but wasn't the Constitution only intended to apply to the federal government? Don't the states have more police power?
it doesn't matter what might have been. Yeah, and that's probably what was intended. The states had their own constitutions. But the 14th Amendments and circa changed all that. They imposed the federal constitution on the states.
Right. The federal constitution is a minimum bar that the states municipalities, cities, every government agent, schools, even though they get around it all the time, a minimum bar that must be respected by any government entity under the United States jurisdiction. So, except for the military. The military is different. The military is your willing forfeiture of those rights as a member of the military, for the purpose of the things, the good life the government gives you. Barbara Boyd, welcome to Paralegal Status. M says the band is back together. Let's go, boys. It was really nice having Joe on. Joe's great. Blue Vero sent 10 memberships. Thank you very much for that. I appreciate it. Sport Nugget. I kind of hate this judge. Hey, me too. Me too. Angel Australia says, oh, hey, I didn't see those come in. Where'd we go? It just moved it. Hey, Branca and Joe. We've got Lesko Brandon says your people are experts at conspiracies, Joe. How would you set this one up if you were a Canton cop? Come on now. Project Calm, ARCA hired by the feds for their investigation, gave their reports to both. It helped the defense. Prosecutor tries to force defense to hire by demands about review scope and burning their hours with discovery like texts. So that's what's going on with a summary of ARCA, the ARCA issues. Ray says nobody could ask the last jury because she immediately called a mistrial without saying anything. We're allowing the prosecution or the defense to say anything. She didn't allow any conversations about it. I don't know why it said about it twice. Oh, conversations about it. I don't know. Night of Knee says Lawcaholics. Hit the thumbs up, smash the subscribe, and ring that bell. And speaking of subscribing, guys, Andrew Branca, Law of Self-Defense. If you're over on my channel, I love having you here, and I would prefer to you always to choose me. But while you're choosing me, drop over to Andrew's channel, click subscribe. He's on a quest for 1 million subs. I mean, I say aren't we all, but this man is driving for it. So go support him in that way. Again, I can never sing Andrew's praises enough because I always marvel that I happen to make friends with this guy who's the expert on the law of self-defense, a preeminent expert on the subject. The amount of knowledge and experience you're getting in that subject and the amount of wit and wisdom you're getting in every other is invaluable. So click subscribe, follow his channel. You know who he is, guys. Kimmy Joe says 2 judges in 2 days have been arrested by ICE. Okay. Help me out here on the ICE arrest. Real quick. This is way off subject, but are these judges having these guys live in their houses or in houses that they own?
One of them in Wisconsin apparently had one of these ICE, with a final order of deportation criminals in her courtroom, heard that ICE was out in the hallway, sent the defendant into the jury deliberation room to hide him from ICE, went out in the hallway, yelled and screamed at the ICE agents, and that's the obstruction that they're citing, that she was hiding from them, someone who for them is a lawful fugitive for them to seize.
Right.
And so she's been arrested. She's super. The BMI is triple digits on this one.
Her BMI just says cake. There was the other one though, and it's like arrested with deportee at his house. And I'm like, wait, like at his house, or is this like another property that he owns where he's stashing the illegal immigrant?
Oh, I don't know. The reporting I saw, this is the New Mexico judge, I think. I think the guy was living in his house.
It's like, look, I have a pool. You can stay here, but you got to clean it.
Right.
That's my one rule.
And the lawn.
Would you like a margarita? Box Fort defendant says, love this judge working half days when the Fed judges are working 20-hour days, 7 days a week versus Trump. Fusion Evo. Def made a motion to allow Karen to be able to listen to the table from the table by headphones to sidebar. The judge didn't allow that, so she comes up every time. Now I agree with the judge not allowing Karen Reed to listen to sidebars by headphones. If the judge is of the interest of keeping those sidebars private, those headphones and then a microphone recording sidebars, even if it's not being broadcast out, is one of those point of weaknesses that could be broadcast out and really screw up the trial. So if you're going to let Karen Reed listen to sidebar, let her come to the table, I guess. I half agree with Joe's assessment that maybe it doesn't make her look good. But I mean, I don't think it's doing any harm, honestly. I doubt the jury cares that the defendant in a murder trial goes to listen to what the judge says.
They don't know. The jury doesn't know if this is normal or not.
Right. I just, like, if I'm on a jury and I'm watching the defendant get up and go with their lawyers to listen to what the judge says, I go, yeah, I'd probably want to hear too.
And I guess that's how it works.
There you go.
I mean, again, the jury doesn't know what's normal. We know, so it looks odd to us, but the jury doesn't know.
Yeah. Kimmy Joe says George Santos was just sentenced to 7 years in prison. Blue Varro, 1 single hair. That must be some forensic reference. Anonymity T2, welcome to Paralegal. Project Calm, if their husbands had to cover up on the force for one another many times, did they want to go against one another over what they all saw as an accident? There's any number of reasons that people commit crimes or commit a subsequent crime to cover up the crime. Like, usually it's fear, but the first one, I mean, if any of those guys got in a fight and punched that guy and he ends up dead, I mean, they're done. They're done forever. And actually the other people there may become accessories for not, reporting it. These are cops. So you got big problems. Who knows? Maybe just died in the snow.
And the social pressure. I mean, listen, even if people it would be normal for people to have different recollections about various details about what they remember or what they saw happen or how they perceive things. But in this social setting, where basically everyone's living with everyone, they're all in the community. They have been for decades. They're going to continue to be for decades. The social pressure, even if no one says a word to you, you just know that if you disagree with that buddy's going to be crucified on cross-examination by the defense, with your testimony being used, your different testimony used to impeach him. So that tends to have everyone do everything they reasonably can to align their testimony so they're not in conflict. That's all part of the contamination. That would not be the case if these were all witnesses who are at arm's length from each other, but they're not. Right. They're in one social group.
Now, I don't know anything about Canton, Massachusetts. How big is it?
About 25,000 people.
So a lot of people would call that a small town.
Yeah.
Right. I've heard that many of these people, many of these families that are involved in this, at least, have a large amount of influence in this town. Like they've been there 20 years, 40 years, whatever. They're established. Their sons are police officers. They probably own businesses. Like their extended families own businesses. There's a lot of social pressure that way too. If you are out in a small town, you're out. Like you're done. They're in
on many levels. So like if you run a business, suddenly getting a license to do something gets a lot more complicated than it used to be, right?
Yes.
If you have kids, suddenly your kids are excluded from the social group. They're not going on the van trip up into the mountains to ski. They're just
beat
not
up
invited.
in school.
Right. But even if not that, it can be a lot more subtle than that. They're just suddenly, they're just not part of the in group anymore. And then you feel bad for your kids, right? That this is being done to them. And all you have to do to solve it is be part of the group, get along. That's all you have to do. It's a lot of social pressure.
There's a group in a nearby town, the county seat here. And I won't say the name of the group just in case I get some detail wrong, but I don't think so. They effectively, it was a group of property owners. They own a lot of the available commercial lease property that's around, or the land that commercial lease property could be built on. And they also had, connections to the people who do liquor licensing. And so if you want to open a restaurant in this town, guess where you're going to put it? Like you're going to choose the 40% of rental property that's owned by these people. Like that's where you're going to build your restaurant, because if you don't build your restaurant there or rent an existing building, you're probably not getting your liquor license. If you're going to open a restaurant that doesn't have a bar, you're opening fast food. But if you're doing a sit down dining restaurant and you can't serve alcohol, you've cut off a huge amount of money. And that's how they squeeze people. And it's really subtle, but the people who do it, they're the big names around town that you see on the large construction companies and stuff like that. They've been there forever. They know everybody. And and it doesn't take much in a community of 25,000 for families to have undue influence. And if you're out, you're done. Let's see. Here we go. King Sovereign says, prior to the start of the trial, the judge ruled they cannot bring up the third party culpability in regards to the people at the party. I don't know. Third party culpability, I guess. I don't know the specifics of that ruling, so we'll have to look it up. That'd be interesting to see.
Yeah, I mean, generally, say you could identify someone who had animus for a murder victim who might have committed this murder instead. The defense might collect evidence and say, it's not our client, it's this other guy that did it. This guy had reason to kill the victim, independent of our client. But what they don't like you to do is they don't like you to make that argument. For all we know, it could have been one of the 6 billion other people on the planet who did this, and the state has to disprove that beyond a reasonable doubt. That's generally not allowed. You have to be able to point to some specific person who might have had means, motive, opportunity to commit this crime other than your client. And there's some room for that here, right? I mean, we don't know what happened inside that house.
Right.
There's been suggestion by the defense that another man in the group was sexually interested in, romantically interested, I guess I should say, in Karen Reed. So there could have been some conflict there. But the judge just told the defense, I'm not even going to allow you to develop that line of argument, which I think is, in this case, is probably inappropriate.
Right. And maybe that's one of those appealable decisions, where, hey, obviously this is a core part of our defense. We've presented over and over and elicited testimony that there is sound theory to support it to enough of a standard that we should be able to raise it. And to take that away is maybe appealable, but it also, they could ask the judge to reconsider the decision if they elicit some testimony that leads to that sort of conclusion. So that's the other option that we have, is that they can maybe open the door through witness testimony, probably from the state and an effective cross, and ask the judge to do that, or that would create an appeal point if she's ultimately guilty.
And yeah, if I were the defense, I would be looking hard for opportunities to get that door kicked open by cross-examination of the state's witnesses, especially the people who are in the house. If they say one thing about someone having animosity towards John O'Keefe, that I would expect that would be sufficient to kick the door open.
You'd hope so. Chris.
Yeah.
Oh,
no, that's true.
No, my stupid window went away for a second. Crystal D says, glad you're back, Nick. I don't enjoy watching trials without you. Learn more from you than anyone. Missed the first few days of trials, so I have a question. What do you think actually happened to John? Motive, not that defense needs it. Just curious. Right now, I'm of the opinion that John went inside. There was an altercation. I'm not saying that anyone intended to kill him or not. That doesn't matter to me. There's an altercation that got physical. He defended himself from a dog bite. He got punched or hit by something above his right eye where there's a hematoma, and then maybe fell or stumbled in some way and struck his head on a counter, a kitchen table, a bookshelf, literally could be anything. He either dropped unconscious inside and they took him outside, or he got up after the scuffle and went outside on his own because he was pissed off, and then dropped in the snow and died from the lingering head injury. That's my theory, is one of those two things. I do think there was something that happened inside. I think the lacerations on the arm look like a dog attack with defensive wounds. And it, to me, how does that happen? I mean, I've heard people try to explain it away with raccoons and stuff. It's like, it's a fucking snowstorm. A raccoon is not coming up and gnawing on a guy in the middle of that. Like that, you're not selling me on that at all. But a big dog biting someone who is in a fist fight with their owner, that makes sense. So hope that helps. But the defense doesn't have to prove that. That's just my impression so far. Where was I here? Oh, here we go. Project Calm. Wait, I read that one. Jonah John, you should watch the murder trial for Brooks Houck in Kentucky. Whole bunch of police conspiracy around it. I don't like, is this a new trial? I don't like rewatching trials that have already happened. Other shows do it. They're great at it. It's not my thing. I like I like to learn about the thing as it goes, see what's happening in real time. If I'm going to watch a trial, I don't want to watch one where I know the outcome. I don't go back and watch, sporting events where I know who wins. Let's go, Brandon. I'm going to let everyone in on a secret. Judge will sigh. I'll allow it when the prosecution does act A and sanction the defense when they do the same. Heather Whitaker, DUI guy has been following the case very closely and went to the first trial. You should have him on to go over the judge's bias and other issues. Maybe. Madison Weaver,
I like DUI guy, but when you hear somebody else describing yet another person's bias, there's a lot of personal filtering going on there. That's it's just not informative to me. It doesn't mean he's wrong, but there's no way for me to assess, how I would have perceived the same conduct.
but no one needs to work at all to convince me that this judge is biased towards the state. I mean, she's not. I haven't seen anything that is misconduct, but the feel of the rulings is that the majority of important rulings go to the state. I mean, sure, she sustained some objections for the defense. So the state is way overstepping on some of their questioning. I mean, they're having these guys he's giving the guys grand jury testimony and effectively trying to say, will you please just say this thing again? He can't say that, but he keeps bringing it up. He keeps going back to the same questions and the same thing and keeps bringing the thing. Can I refresh your recollection again? You just looked at it, but read it again. And he keeps going back up and keeps going back up. It's obvious he's trying to elicit a specific line of testimony from the guy's grand jury thing, and he's not saying it. And I'm sorry, but when you're on direct, you can't do that. And you can't do it on redirect. And this, to the defense's credit, they objected to that whole line of questioning on redirect. And she's like, I'll kick the door. No, the door was kicked open. It's like the door wasn't kicked open because they asked him an impeachment question about grand jury testimony that he made because it conflicted with a current statement. That doesn't kick open the door for him to go back to his grand jury testimony and read it to the jury again and say how guilty Karen Reed is. And that's what the state wanted him to do. So those are the types of rulings where I go, yeah, I mean, obviously this judge is biased towards the state. That's how she's acting. So I don't need anyone to explain it to me. I can watch it. Let's see. Madison Weaver, people say this judge is awful and part of the conspiracy. Thoughts on her so far? I don't care for her, but part of the conspiracy. I know Auntie Bev or whatever, but again, we just talked about small town stuff, and that does go that goes all into everything. These people are going to encounter these other people in the community all with frequency, especially lawyers and cops and judges. MLS, bring Valhalla up on the panel. He knows things. Not right now. I think we're about to wrap up. Jules, were there any footprints by the house? No, I don't think there were any footprints at all. But you're talking about, it's a blizzard. By the time they get there, heavy snowfall. It's been falling for several hours. The footprints are going to be the people rummaging around the yard. Karen Reed running over to where she believes John's body is for whatever reason. Either she saw something. I hate that assumption that just because she went to where the body is, that she must have known that she hit him. Because even if she was killing him, she wouldn't have known where he landed after backing into him with a car. Like it
seems silly.
Theory.
And I feel like some of these snow questions are from people who've never lived in snow country. Folks, you can shovel your driveway in a blizzard, and by the time you get to the other end, it looks like you didn't shovel anything.
Yeah.
I mean, that's how fast the snow can come down.
Yep. If it's wet snow, if it's dry snow and blowing too, it doesn't even have to be falling. If the snow is really dry and cold, oh God, I hate it. Here we go.
What's a jigger, Your Honor? I believe you have the spelling wrong. Karen went out to run down with her car a bunch of.
Oh my God. Catherine says the biggest loss for the retrial is not having Trooper Paul testify. He created the state's theory of the crash. He was terrified on direct and savaged on cross. Would love a reaction video. Now that might be something to go back and review sometime during during like a lunch break or something. That could be funny.
Whose testimony is that?
This guy, Trooper Paul from the first trial. Like it wouldn't be relevant. He's not being called apparently in this trial. So it wouldn't be relevant to this one. It'd just be like a funny thing in the first Karen Reed trial. Like, oh man, we missed this.
Why is he not being called?
His theory was, I think he's the guy who had the theory that he got struck by the car and was launched 30 feet to his resting place.
Okay.
And it's like on cross-examination, they say he was savaged, and that's what I've heard. Like his theory was so heinously bogus and obviously bogus that that the state isn't going to call him back after that performance would be my assumption.
I mean, it would almost less to me the witnesses, but like if there's differences between the opening statements or the closing argument might be informative from the first trial. Because to me, that's really the legal arguments that are being made.
Right.
If there's dead time, maybe during the deliberations or something, I don't know. That might be interesting.
This one would just be because it's funny to watch this guy get absolutely annihilated on cross. Oh, remember that from that the guy who shot the attorney, and they brought in that the use of force expert, and then they just obliterated him.
Right.
Oh, it was beautiful.
Was that Theodore?
Yes.
The immigration lawyer driving the Kia Soul got punched in the face by the bicycle rider. Yeah.
And then shot in the face.
I want to say Theodore Dalrymple or something. It was, but that's not it.
Somebody's got to have it in the chat. Do you guys remember the name of that case? Was that a Wisconsin case too? That was with Judge Edgecombe. Theodore Edgecombe.
Right. Oh, Borowski. That's a voice you need to add.
Chambers. Now. Yeah, I love that guy. He was so funny. He was one of my favorite judges to have, of the trials that we've watched. He was really good. Let's see. There was
This chat cannot handle the raw power of Valhalla awaits doing absolutely nothing and is shamefully unproductive as a result. Please release him from his wrench so he can milk baby goats.
JDE Corey says, Nick, I'm glad that you're back and doing better. From one lawyer to another, I'm happy that you had a positive outcome. Many thoughts and prayers to you and your clan. Branca, stay based.
Thank you, man.
All right. That's a super chat, says I have them. Any closing thoughts? Should we wrap up here? Or do you have anything to?
I've been told that people who watch these streams on a mobile device, like a phone or a tablet, that they can't actually subscribe until they exit out of the program. Do you know if that's true?
I have no idea.
Well, in case it's true, you're about to exit out because the show's about to be over. So you might take that opportunity to subscribe to Nick on YouTube and Rumble. Subscribe to me on YouTube. Ricada Law on YouTube and Rumble, and Law of Self-Defense on YouTube. My mission is 2 million. So should I say 2 million? 1 million. 1 million subscribers. We're 19.8% of the way there. Get a little closer every day with your support. We can't do it without you. So subscribe, hit that thumbs up, like button too. YouTube really likes that one.
I can't ever pull up my social blade and show the live subscriber numbers because they're falling faster than a Chinese diver. Like you just oh man. This is what happens when you take a year of time and don't really do anything. I mean, it was already happening because of my own choices, but that was my fault. Now it's just like the mop up of people who, if you go a long time without engaging a channel, YouTube will eventually remove you on their own.
Yeah.
And so cycles people out. Some people get banned, stuff like that. But it's been pretty steady for a long time. It's like eventually this will stop or not. Who cares? You do, because you're going for 1 million subscribers.
Right,
I'm going for a plate of rice. Joe Maz Q says, as a retired citizen soldier, I can report that you do not surrender any rights upon signing up for the military, but you do accept a differing set of due process for military domain situations. Yes, correct. You don't surrender your rights. However, you may waive some of your access to those rights for a period of time and in certain contexts and settings, mainly being under the UCMJ, in which you inherently waive your right to a jury trial. So, okay. Well, man, should we wrap up?
Let's go
close
ahead.
This thing out?
Thanks for joining us, everybody. It's been a great time. Of course, I'm attorney Andrew Branca for Law of Self-Defense. We have Nick Ricada here from Ricada Law. And we'll be covering the Karen Reed trial throughout, which I guess will be back on Monday. And hang out for a minute after I shut out. Nick, I got a couple questions for you. And that said, until we meet again, stay safe.